Yes, sir. For Senate Appropriations Committee, November 1st, Senator Guru.
Here.
Senator Hicks. Thank you. Senator Kinski.
Here.
Senator Steinmetz. Chairman Perkins. You have a quorum.
We have our Zoom working. Are we streaming here? Okay, so we're being recorded at this point, from this point on. All right, thank you. So anyway, welcome to Senate Appropriations this morning. I think we have we're the only game in town this morning, only show in town. So welcome. We're glad to have you here. What we decided we're going to do, visited about this with our committee last night. And what we're going to do is we're going to go ahead and open up comment on both House Bill 1 and House Bill 2. And we're going to do that. Our goal is that we can take up to about 10 o'clock. Then we've got to work the bill, because this is how it's got to be reported out. Assuming it's reported out, I have no indication that it won't be reported out at committee today. And it'll go to committee of the whole, which will happen this afternoon. So we don't have unlimited time to take testimony. With that, how many people in the room this morning intend to provide testimony? Just go ahead and raise your hands. Okay, raise them higher, because some of you are in the back row. Unless you have shoulder injuries, then you don't have to raise them as high. So we've got about 12 or 13, 14 in here. Didn't anybody raise their hand online yet that we know of, Karen? 3 raise their hands. We're about 15. So and it's growing every minute. Okay. Okay. So we've got 20 odd people that want to comment this morning. I think with that, if we take 20, divide that, we got about 2 hours. 6. That's about 6 minutes a piece. You don't have to take all 6 minutes. And yes. Is that for addressing both? Yes, that's for addressing both bills. We have about 2 hours for comment. That being said, we're going to allow you to allocate minutes to somebody else. So if there's somebody else that has you think is going to speak on the same subject, we want to hear that. Also, for anybody who's out there who wants to provide us all kinds of data on COVID and COVID vaccinations, please don't. It's your 6 minutes, but do what you want. There's enough data out there that you can find anything to support any argument. We get that. So, it's your 6 minutes. We'll listen to your data, but you have 6 minutes. In some instances, we may recognizing that some people actually do represent larger groups. We'll have chairman's prerogative, let some people go a bit longer. But with that, why don't we go ahead and we'll start. I think we have a staff member who's going to appear virtually and walk us through the bill. It's changed considerably since it was introduced. I started trying to follow it as it went through the House and gave up after second reading. So, who we got, Karen, that's going to join us this morning?
Mr. Chairman, I believe we have Mr. Brian Fuller and Ms. Anna Johnson. I'm having some trouble getting them in as panelists at the moment. If you'll give me just a minute, I should be able to get them switched over and they should be able to walk us through the bills.
Sure.
Mr. Chairman, can you hear me?
Yes, we can hear you, Brian.
Okay.
Thanks for getting dressed and appearing virtually this morning.
Sure thing, Mr. Chairman. Brian Fuller, LSO. I will just start walking through the bill here. Happy to answer questions at any point. I guess I'll just start with some of what is not in the bill anymore. First, the findings that were in section 1, those have been deleted. Those findings just noted the impact of COVID-19, particularly for healthcare workers, and that the legislature was exercising its police powers to ensure that there's not a further shortage of workers, and particularly healthcare workers. Then moving on to, if you have the engrossed version in front of you, Mr. Chairman, committee members, page 2, I'll go down to line 19. And this is a new definition for emergency use authorized COVID-19 vaccine. And it's just defined as a COVID-19 vaccine that has received an emergency use authorization from the FDA, but not full approval or authorization from the FDA. Then moving on to page 3, line 7.
Brian, if we have questions, you want us to go ahead and ask you go along, or do you want us to wait and let you go through and come back and ask questions?
I'll take questions as they come, Mr. Chairman, whatever you prefer.
Thank you. So Brian, I'm looking on page 2, looking at line 15 through 22, and then it slips over to the top of page 3. When we talk about a COVID vaccine, is there any reason that you simply can't combine those so that is a COVID vaccine that is marketed to diminish or decrease symptoms of COVID-19 or that has received emergency use authorization? Was there discussion about that, or is that, I understand the difference between those that are authorized by the FDA and those that have emergency use authorization through executive order. If we combine those, is there a practical difference inside the bill?
So Mr. Chairman, there is, and I'll get to that. That's on the bottom of page 3, and I'll describe kind of the difference. This is another amendment that was included in the bill. So I'll get to that shortly, and hopefully that will make clear why the two definitions are separate and different in this bill. So then, Mr. Chairman, moving on to page 3, line 7, the definition of employer. In the introduced version, this definition simply referred to a provision of Wyoming statute that used a definition that's found in the Internal Revenue Code of employer. Now, Mr. Chairman, committee members, as you'll see, employer really has 3 meanings. And first, it's any person or organization that has 100 employees or more. So that's number 1. Number 2, it's any person or organization that has at least 1 employee and has contracts that involve Medicare or Medicaid in the course of the employer's business. And then the third option would be any person or organization with at least 1 employee and has any other federal contract in the course of the employee's business, or in the employer's business. So
Brian, we talked about that. We met last night informally, and just to kind of go through this and trying to understand where we were and kind of get organized for this morning. And one of the questions that we had last night as we visited, I think the Vice President brought this up, is the intent of this simply to capture anybody who will either be subject to an executive order or somehow is going to get federal money with strings attached, to which they're going to be subject to a federal mandate?
Mr. Chairman, I definitely don't want to try to discern or divine the intent, of the other chamber in terms of how they've amended the bill, but I think that's a fair statement. That the bill narrows who it applies to try to mirror or align with the expected federal actions that may be coming.
Okay. Go ahead, Mr. Vice President.
This would become the only definition of employer that we currently have in statutes. Is that correct?
Go ahead, Brian.
Mr. Chairman, Senator Hicks, I'm not sure Brian heard your question, as your mic wasn't on at the time you began speaking.
Okay.
Hey, Brian, did you read the Vice President's lips?
Mr. Chairman, camera didn't even pan to him.
Okay. All right. Go ahead. Go ahead, Mr. Vice President.
I can do sign language, Mr. President or Chairman. Brian, the question I have here is because this will now bring in a definition of an employer into our statutes. Do we have any other definition of employer in statutes, or would this become the only standalone definition in our statutes?
Yep. Mr. Chairman. Yeah, Mr. Chairman, Senator Hicks. Two notes here. First, this entire bill is now non-codified, so there's no change to any existing. I believe there's at least a handful of definitions of employer in the statutes, but this would only apply to the provisions of this bill, this particular definition. So it would not implicate or change any other definition of employer that's currently in Wyoming statute.
Thank you.
And then, unless there's other questions, Mr. Chairman, I'll move on. The next is page, I guess I would note that the definition of healthcare employer has been deleted. And that will become clear later on as I discuss some of the other changes that were made from the introduced version. So then moving on to page 3, I'll start with line 18, and this is a new sentence that was included in subsection A, and it just provides that notwithstanding any Wyoming law, no employer in the state shall require or mandate an employee to receive an emergency use authorized COVID-19 vaccine as a condition of employment. And then that's the end of the sentence. So that was an addition that's now in the engrossed bill. Mr. Chairman, going back to your question, that's the reason for the separate definition for EUA vaccine as opposed to just one combined definition.
So Brian, with that explanation, I would take it that the first sentence of under section 2 of subsection A, which begins on line 18, that first sentence. So that first sentence is just an overall complete and utter prohibition against any employer requiring the use of an emergency use of an authorized COVID. So one of those that are approved under temporary or the temporary emergency order, those are complete ban. And the second sentence then provides where we now have the following requirements. So when we get to page 4, are you trying to tell us that that first sentence means that none of the requirements exempt an employer from having a mandate to receive an emergency use COVID-19 vaccine?
Yeah, Mr. Chairman, I think that's a fair reading of that. And I think it was specifically crafted to try to reach that particular outcome that you described.
Okay, thank you.
Yeah. And then, Mr. Chairman, the next sentence.
Wait a second, you have a question from Senator Steinmetz. Go ahead, Senator Steinmetz.
Thank you, Mr. Chairman. And Brian, could you just explain the difference between the emergency use authorized COVID-19 vaccine and the FDA approved? Just could you clarify that for us so we know exactly what the difference is?
Yeah, Mr. Chairman, Senator Steinmetz, certainly not super familiar with the FDA's processes and all of that, but I think the primary difference would be, the emergency use authorized vaccine is one for which the FDA has granted just that, an emergency use authorization for the COVID-19 vaccine to be distributed and used, as opposed to, I think, a full approval that my understanding would require, maybe additional studies, but again, Mr. Chairman, I'm definitely not keen or, any expert on that process or how that would work. Okay, thank you. Go ahead, Brian. Yep. So then, Mr. Chairman, page 3, line 22, this picks up with how the bill initially read. So this would be no employer can require or mandate a COVID-19 vaccine as a condition of employment unless all of the following are met. And then these get into the kind of the conditions that must be kind of adopted or utilized in order for a requirement or mandate. So first, page 4, line 5, this is nearly the same. This is the employer determines that requiring or mandated COVID-19 vaccines is critical to ensuring the health, safety, and welfare of the workplace. And then on page 4, line 8 is an addition, or would otherwise jeopardize the business. And then the employer provides written evidence of that to the Department of Workforce Services. Page 4, line 12, this is a new paragraph 2. So this replaces in total what was in the introduced version.
So Brian, going back on page 4, so in Romanet 1, which is lines 5 through 10. So a couple of questions. One is that the employer determines that requiring or mandating COVID-19 vaccinations is critical to ensuring health, safety, or welfare of the workplace, or otherwise jeopardize the business. So in jeopardize, does that mean physically? Does that mean financially? Anything that the employer thinks would jeopardize their business? And why wouldn't the health, safety, and welfare of the workplace be one of those things that would jeopardize their business? I'm just wondering, I'm not asking you to divine that. I'm just asking from the discussions that you heard as you worked this bill. Is there anything you can add to the differentiation that's being made there?
Mr. Chairman, I think the only thing I could add from my recollection would be a discussion of financial impacts on a business.
All right, and then with respect to critical, I mean, what is the intent of that to have critical? I mean, if you go to the 3 levels of constitutional analysis, you've got reasonable, you've got, you know, and you get to, you know, a critical right. Is the critical being used in that context, or is just critical just a choice of, does critical mean important? Does it mean appropriate or necessary? What is there any specific meaning to critical in this? In other words, is this going to require the employer to use under, like I say, under the constitutional mandate or analysis the Supreme Court uses? Critical generally means you have to use the least restrictive analysis. Are we using critical in that context or a different context?
Mr. Chairman, I'm not sure it was drafted to, you know, incorporate any sort of constitutional standard, or nor, you know, could I say whether it connotes any sort of test that's required. I think critical is just the word that was used in the drafting.
Okay, and then on line 9, when we've had some comments from members of the House who've told us that they think that the word evidence on line 9 should really be notice. Was that the intent? I mean, ultimately, it looks to me like the employer makes that determination and provides notice of that determination to the Department of Workforce Services. Then we'll do whatever it does. But is written evidence? I mean, ultimately, at this stage of the game, just the employer is making that determination, not the department. Is that correct?
Mr. Chairman, you know, and these were this language regarding the evidence was identical to what was in the introduced version. You know, I guess to answer your question, I don't know if I don't see anything else in the language that imposes some sort of duty or hurdle for the Department of Workforce Services other than, you know, I would assume, you know, the implication is they would accept the written evidence of a determination. You know, there is language that says that the Department of Workforce Services enforces, you know, the provisions of this section, but specifically to this point in paragraph 1, you know, Mr. Chairman, there's nothing else there that I think really gets to the heart of your question.
Hold that thought. We'll get to it in a minute. So thank you. All right, keep going. Any other questions, members? Okay, keep going, Brian.
Okay, then Mr. Chairman, page 4, line 12, this is a brand new paragraph 2 from the introduced version. So this concerns exemptions, and it requires the employer to provide and accept exemptions in accordance with the following. So starting with A, an employer shall grant an exemption for religious grounds upon submission of the exemption. B, an employer shall grant an exemption for medical grounds upon the submission of an exemption that's completed or signed by a licensed physician, advanced practice registered nurse, or physician assistant. And Mr. Chairman, if I may offer a potential technical correction for the committee's consideration, on line 22 and then again on page 5, line 1, after practice, just inserting the word registered to reflect how that term is used in statute. It's advanced practice registered nurse. So just one potential technical correction for the committee to consider. And then so this is page 4, line 22, for exemptions for medical grounds that are not signed by an advanced registered nurse or a physician assistant or licensed physician, the employer may grant the exemption. So it would leave it discretionary if someone simply brings a medical note that's not signed by a physician. Page 5, line 4, an employer shall grant an exemption for medical contraindication to the administration of the COVID-19 vaccine or upon written evidence that the employee has previously tested positive for COVID-19. And then subparagraph D just provides that an employer who previously, who enacted a COVID-19 vaccine requirement before the effective date of the section and stopped accepting exemptions must begin accepting exemptions again in accordance with the provisions of this paragraph.
So Brian, going back to lines 4 through 5, where you've got a two-pronged exemption provision in here under cap C. An employer shall grant an exemption for medical contraindication to the administration of COVID-19 vaccine or upon written evidence that the employee has previously tested positive for COVID-19. So it's one or the other. And I'm just wondering if there's a medical contraindication, why wouldn't that be, what's the difference between that and B, and and who would be providing the medical contraindication if it's not a licensed physician, advanced practice registered nurse, or physician assistant?
Yeah, Mr. Chairman, I think that's a fair question. You know, I'm not entirely clear why, you know, what the difference may or may not be between medical grounds and medical contraindication, other than, you know, I would note that one, you know, mentions the signing, you know, by, as you say, of a doctor or PA or advanced practice registered nurse. Subparagraph C does not include that language regarding the signature, nor does C grant that sort of discretion to the employer like B does if it's not signed.
Well, and then again, you go back there. So, I mean, at least on the second half of C, it says upon written evidence that the employee has previously tested positive. Under C, it just, I mean, how does that work? Does it just come and say, I have a medical contraindication, so I'm exempt? I mean, how is the employer supposed to deal with that as a practical matter if it's not tied to something else?
Mr. Chairman, I think that's a fair question. One for which I'm not sure I have an answer to.
All right, thank you. And I know that, like I say, this thing's only a minute about, I thought there had to have been close to 30 amendments on this thing. So not all of them passed, but it got bashed around quite a bit. Okay, keep going, Brian.
Yeah. So then paragraph 3, this is page 5, line 17. It's nearly identical, except beginning on page 5, line 23, there's an insertion of the sentence: an employer shall not be required to provide an employee's preferred reasonable alternative measures, so long as those measures are effective in accordance with this section.
Do we know keep going. Well, I think we'll ask this question here in a minute when you get to that part. Keep going, Brian.
Yep. And then moving on to page 6, line 7, this is subparagraph A. So the reassignment of work duties, that first sentence is the same, but then on page 6, line 9, a reassignment of work duties or station shall only be required if the reassignment does not impose an undue burden on the employer. And then another new sentence: nothing in the subparagraph shall require an employer to reassign an employee to different duties while providing the same or similar pay or salary. And then page 6, line 16, the first part of subparagraph B is identical, but then beginning on line 18, there's an insertion for provided that testing by means other than by use of nasal swab shall also be offered to employees when available. And then page 7, lines 1 through 3, that remained unchanged. And then page 7, line 5, subsection B. So previously, this provision used the language of an unfair employment practice, but it subjected the person to a civil penalty of $100 per day for each day that an unlawful requirement or mandate was in effect. That has now been changed to provide that this is if an employer first requires or mandates an employees to receive a COVID-19 vaccine as a condition of employment that takes effect on or after the effective date of this act, and who knowingly imposes a COVID-19 requirement or mandate that doesn't conform to the previous subsections, so the exemptions and measures and all of that, shall have committed an unfair employment practice. Then on line 11 of page 7, a person aggrieved by that practice may file a complaint in accordance with current statute for the filing and resolution of complaints regarding unfair employment practices. And then page 7, line 14, an employer who unknowingly creates a COVID-19 vaccine requirement or mandate that doesn't conform to the previous subsection must bring that non-compliance into conformity upon notification of that.
So Brian, just out of curiosity, where does the common man or woman who employs and doesn't have lawyers and professional human resources, where do they find codified statutes so that they would know how to impose this mandate against mandates?
Mr. Chairman, well, they wouldn't find it in the green books. It would only be in the session laws, the website and the such.
All right, all right, thank you. Go ahead,
Mr. Chairman.
Kinsky.
Brian, so I want to understand this 279106. That I think is everything from discrimination to, I guess, not paying overtime properly. But as I read it, is the intent that all of that 106 would apply, including the section that says a hearing officer may require the employer to cease and desist, require remedial action, including hiring, retaining, reinstating, upgrading of employees, requiring posting of notices, and require the employer to pay back pay or front pay. Was the intent that all of those penalties would apply in this situation?
Mr. Chairman, Senator Kinsky, my understanding was just that, the unfair employment practice, the resolution of that complaint would be the same as it is for any other, the resolution of any other complaint involving an unfair employment practice that's currently included in statute.
Thank you, Mr. Chairman.
Okay, keep going, Brian.
Yep. And then, Mr. Chairman, next are provisions that have been removed from the bill, and the introduced version included a requirement for severance pay to employees who were involuntary, who either separated from employment or were involuntarily terminated for not receiving a vaccine or for not disclosing the status if that requirement or mandate did not conform, and none of that language is in this bill in the engrossed version.
But isn't it now there by cross-reference, just on base what Senator Kinsky just said? In fact, there's more than just what was in the previous bill.
Mr. Chairman, that's in terms of those remedies in 279106, you're correct, they are broader than just the severance pay that was included here.
Okay, thanks. Anything else, members? Keep going, Brian.
Okay, Mr. Chairman, page 7, line 20, this is identical. This is just the enforcement by Department of Workforce Services. And then D was just changed to make a conforming amendment to delete the reference to the severance pay. And this just provides that nothing is construed to limit or preclude an employee who's unemployed to receive any other benefit to which they're entitled. And then, Mr. Chairman, some further deletions from the bill. So there was an amendment to the definition of injury for purposes of workers' compensation that addressed if an employee suffers an injury caused by a COVID-19 vaccine that was required or mandated as a condition of employment, there would be a presumption that the injury arises out of and in the course of employment. So that has been omitted from the bill. A section that created the healthcare shortage relief and worker incentive program that would provide stipends to healthcare employers and had a $20 million appropriation, that has been deleted from the bill. Then a section that provided $10 million of ARPA funds for employer COVID-19 testing, that has also been deleted from the bill. Then page 8, line 9, this is a new section 3. This is an appropriation of $400,000 from the general fund and the authorization for one at-will employee contract position for the Department of Workforce Services for purposes of enforcing this act. The appropriation is for the next biennium through 2024. The at-will position is in effect until June 30, 2024, or the date on which section 2 of this act, so the employer mandate provisions, is no longer in effect, whichever is earlier. And then page 9, line 8 is just the intent of the legislature language for not including the position or appropriation in the next, so the 25-26 budget biennium. And then section 4, so page 9, line 14, this section regarding the effectiveness or enforceability of this act, this has changed considerably. So beginning on page 9, line 16, If Section 2 of this act conflicts with a federal law, regulation, rule, standard, or order, Section 2 shall not be enforced after that federal law or standard takes effect. That would have the effect of requiring Wyoming employers to comply with the federal vaccine mandate or requirement. And then moving on to page 10.
Mr. Chairman,
Go ahead, Senator Kinski.
Brian, I'm a little bit bothered by the language on line 17, which says to the extent that this act conflicts with the federal law and so forth, which seems to me it leaves the employers trying to figure out where it does conflict and where it does not conflict. Wasn't the intent of this A to just say, if you're subject to the president's mandates, you're not going to be subject to this bill as well? Is there a way to state that more clearly so that we don't have the employers trying to figure out to what extent there is or is not a conflict?
You know, Mr. Chairman, Senator Kinski, I'm not sure I have a good answer to that. I would note, though, that the introduced version simply repealed the bill on the earlier of, it was as it originally started, March 31st, 2022, or the date that a federal law takes legal effect. It would just repeal Section 2, which is the employer mandate language entirely. So that's kind of how it started, and it's morphed into this now as it comes to you, Mr. Chairman, and committee members.
Thank you, Mr. Chairman. Thank you, Brian.
Thanks, Senator Kinski. Anything else? Keep going, Brian.
Yep. Then page 10, line 2. So notwithstanding, so this is kind of a carve out for that subsection A. So this subsection B provides that Section 2 is enforceable during any period that a federal law is stayed, or after which it has been declared unlawful or unenforceable by a federal court. Section 2 would be in effect. And then page 10, line 11 is just kind of the drop dead. It just repeals Section 2 on March 31st, 2023.
So Brian, can you give an explanation of how A and B would coexist? I mean, and where there's a federal mandate in effect, but then B comes along and says this act shall be enforceable during the period in which the federal law is otherwise in suspense. So if it goes in, if I understand this right, if it goes to federal court and the federal court stays the order, then this goes back, and then this is the law, and you have to follow it in that case. Is that how am I reading that right? Is that how this works?
Mr. Chairman, I think that's a fair reading. That, once a federal law that conflicts with Section 2 comes into being, it shall not be enforced. And then B, back on page 10 would be if there's a stay, or if it's if the order is struck down, then Section 2 would be enforceable, and then subsection C would be kind of the final, the repealer.
Okay, thank you. Go ahead, Mr. Vice President.
Brian, I've got a question. If we go back to previous page, section 4, subsection A. And so when we go down to line 21, it says, this act shall not be enforced after federal law, regulation, rule, standard, order takes legal effect. And so it's the legal effect that I have a question on. So I'm assuming this is going through a federal court system, and there's a ruling that it has the force and effect of law, even though it may not be a law. It may just be an unconstitutional order. But what happens in the case that we have two federal courts that have contrary opinions as to whether it has legal effect or not? In other words, we may have the federal court here in Wyoming strike it down, and we may have a federal court in another jurisdiction say it's legal. So under that scenario, this says it takes legal effect. Do we get to go court shopping, or what's the remedy here under a scenario where you have competing court decisions?
Go ahead, Judge Brian. Excuse me, Brian.
Yeah, Mr. Chairman, Senator Hicks. First off, back to I guess just to back up to the legal effect. I think the question there would be, does legal effect mean, for example, for OSHA, I think it's arguable that would take legal effect once it's published in the Federal Register. Then to get to your question about the, conflicting courts, subsection B on page 10, and Mr. Chairman, I'm not sure how a court would parse through this section 4, but on subsection B, line 7, it says declared by a federal court to be unlawful or unenforceable. So, Mr. Chairman, I think at the end of the day, it's not clear how that would be resolved if there were some sort of split, whether in a district court or on a circuit level. Certainly if a district court, or in Wyoming, issued an order, or the 10th Circuit issued an order, of which Wyoming would be directly bound, or that would have value, in Wyoming. I think that may be a different question than another district court or another circuit, at least for the time being.
So go ahead. Anything else, Mr.? So Brian, it occurs to me that not only could you have a split of courts, but that Wyoming employers, business people could have conflicting ordinances. For example, OSHA issues its order and you're required to be under OSHA. But then if the federal acquisition regulations were stayed, so that, that people are getting money either than the federal acquisition regulations or any other federal procurement acts. So let's say that, that there's a federal court that stays that, but nevertheless, OSHA still has its ability to enforce. MSHA may have its ability to enforce. And so then some employers are going to be subject to both. So, when we do this, I'm thinking through this, and you guys have had some time to think about that, but I see an opportunity where not only could the court decisions be conflicting, but you could have conflicting or multiple mandates that come from various federal sources, of which some people, if there's a stay from a court, are going to be absolved of having to comply with the federal mandates, but now Section 2 would be imposed. But some of them will also be subject to other federal regulations or orders that require them to comply. I just see that, again, we're having employers have a real opportunity to be caught betwixt and between the federal mandate and the state mandate. Did you guys talk about that, or am I missing something? Am I reading this wrong?
Mr. Chairman, I think that's a fair point. And I'd go back to page 9, to the extent that this section conflicts with the federal law, I think it's possible that, the section number 1 may not conflict, or number 2, like you say, there may be varying times these take legal effect. There may be varying decisions depending on particular, statutes or what have you that, Mr. Chairman, I guess, short answer is, I think it's a fair point. I'm not sure it's contemplated in this section.
Okay, thanks. Any other questions, members? Okay, keep going, Brian.
Okay.
Oh, wait a second, Mr. Vice President.
Real quick, Brian, I want to make sure that I understand this, because we have the provision that says that this law, if it conflicts with federal law, but then when we get down here, we bring in subsection 4, we talk about rules, regulations. I don't know what a federal standard is. Maybe somebody can explain that, but do we have a conflict on our own bill? One says it conflicts with the law, and then we bring in this concept that this act shall not be enforced if it's a regulation, rule, standard, or order. Is that a conflict within the bill, where we state only a conflict with the federal law in an earlier provision, or not?
Mr. Chairman, Senator Hicks, I'm not sure I quite understand your question.
Go ahead, clarify.
Yeah, Mr. Chairman, I think I'll work on that question just a little bit, Brian, to see if I can't clarify it. The answer may be right in front of me, but so hold that thought and let's move on, Mr. Chairman.
Okay.
And
Keep going,
Mr.
Brian.
Mr. Chairman, I can at least answer the question about the inclusion of the word standard. And that tracks with, with OSHA. OSHA issues standards. I believe what may be issued here would be called an emergency temporary standard, as that term is used in the federal OSHA Act. So that's the reason for the inclusion of that word. And then, Mr. Chairman, section 5, so on page 10, line 14, this is fairly similar. The provisions of this act regulating the employer mandates only apply to employers who require or mandate the receipt of a COVID-19 vaccination that takes effect on or after the effective date of this act, and to employ, and this is the new language on page 10, line 19, and to employers who have issued a mandate or requirement before the effective date of this act, but that takes effect on or after the effective date of this act. So in addition to that change, the other change here, Mr. Chairman, is that the previous version referenced October 31st, 2021. Now the reference is to the effective date of this act.
Brian, so when we have, can you help me reconcile section 5 on page 10 and then section D as in David on page 5, which is lines 9 through 15. They both seem to talk about enactments and basically effective dates and
Yep. So, Mr. Chairman, the language in section 5 is my understanding of a broad statement of the applicability of the entire bill to these two types of employers. So employers who issue requirements or mandates after the effective date of the act, or who have said, we're going to, this is our mandate, but it's going to take effect on or after the effective date of the act. The language back on page 5, all that says is an employer who has enacted, and Mr. Chairman, maybe there is a question there, but an employer who's enacted a requirement before the effective date of this section and cease to accept those have to accept the mandates, or have to accept the exemptions, excuse me.
And do you have any concerns with retroactivity provisions in the bill?
Mr. Chairman, I think all of the references now, I think that's the only reference to before the effective date of this act. And there was now the deletion of the language regarding the date certain. That was October 31st.
Okay.
And I guess, Mr. Chairman, to maybe more directly answer your question, I think subparagraph D, I think it is possible that it would apply to those employers. So this would be page 10, lines 19 to 20, who may have issued the mandate, but may have stopped accepting exemptions before their act even takes effect. I think that would be one possible way that those would comport together.
Okay. All right. Thank you. Any other questions for Brian? All right, Brian, you're halfway home. You want to take us through 1002?
So, Mr. Chairman, I focused on 1001. So I would need maybe a little time to catch up on 1002, but would be happy to do that in a little bit if the
Okay.
committee so desires.
Why don't you do that, and we'll go ahead and we're going to start taking testimony on House Bills 1 and 2. And when you're ready, get back to us, will you?
Sure thing, Mr. Chairman.
Thank you, Brian. Okay, with that, we'll go ahead and we're going to go ahead and start. Karen, have you got a timing device?
Yes, sir, I have a timing
All
device.
right, thank you. So we're going to go ahead and start with our public comment. The first one, we're going to go ahead and go to our agencies first. And again, welcome. I mean, I'm not saying this for the agencies. They're old hands at testifying. Many people here have testified before, but just come through, just come up, come in and sit in the seats up here. You're going to need to press one of the microphone buttons to make sure that they turn green. The light will green, and then you can hear. If you don't, if you're doing that one, we're old and most of us can't hear very well. If you don't use the mic, we're probably not going to hear you. And then anybody who's attending virtually can't hear you if you don't have your microphone on. So go ahead, and if we'll go ahead and have our agencies come up and go ahead and take. You don't have to wait for someone else to leave before you come up. Go ahead and let's have our agencies come up and take chairs and do whatever spacing you need or to feel comfortable or whatever you're going to do with that. So we'll go ahead and start with the Department of Health, and then we'll go to the sheriff. The Department of Workforce Services. Go ahead.
Good morning, Mr. Chairman, members of the committee. My name is Stefan Johansson. I am the interim director for the Wyoming Department of Health. Mostly, Mr. Chairman, just here as a resource to answer any questions that the committee might have. The one thing I would point out in House Bill 1001 on page 6, line 16 is the provision for an accommodation for COVID-19 testing. This was discussed significantly both in committee on the House side as well as on the floor. Just as a reminder to this committee, the Department of Health does have an employer COVID-19 testing program that we are still allocating and providing tests to Wyoming employers all over the state and have been for about 14 months. I would just caution the committee that what this provision does in our reading of the bill is require an employer of a certain size to offer it as an accommodation to a vaccine mandate if they chose to have a mandate or were compelled by the federal rules to have a mandate to offer testing as an accommodation. That would probably generate questions that we've received over the last week from employers, from providers of where do we get that testing resource? Is that incumbent upon us to provide? And most are looking to the Department of Health or the state to provide that testing resource, which we can do, subject to the volume and the frequency of the testing that would be involved. For example, Mr. Chairman, if every employer that has over 100 employees that would be subject, what we anticipate the OSHA regulations to look like in a vaccine mandate, and this essentially started tomorrow. If you take the time between now and the next session when a bill like this or a law like this could be amended, we would be looking somewhere in the territory of between 400,000 and 1 million test kits, depending if we tested every employee weekly. Now, those numbers are obviously very far reaching, but at around $100, $120 a test kit, that expense can grow significantly. We do have resources and funding sources to procure and to allocate testing kits across the state, but would just offer that to the committee as just a reminder on the scale and the size of a testing program. If the state Department of Health or otherwise were the entity supplying that resource, it could get quite voluminous in what we would be needing to provide. On the other side of that coin, Mr. Chairman, there are federal resources that have opened up for testing. HHS is offering pooled testing options to certain types of organizations, employers, et cetera. So the landscape has changed from a year ago when the state was really the primary supplier of testing resources to individuals, to healthcare providers, to employers, and we are still certainly a big part of that. But it is something that there's not a whole lot of clarity that we can offer right now until we see the federal regulations either on the employer side or on the CMS healthcare provider side with respect to the vaccine mandates. But we do anticipate if and when the rules come down for these mandates that if there is a requirement to test those that have an exemption, whether religious or medical, or a testing provision in general, for example, on the OSHA side, that the federal government will offer some testing resources to employers, to communities, and again, can't offer a lot of clarification there until we see the rules, unfortunately, which have not come out yet. Mr. Chairman, I'll stop my comments there. Again, just wanted to be a resource to the committee from the Department of Health. So happy to answer any questions if you have them.
Mr. Chairman.
Go ahead, Mr. Vice President.
Mr. Chairman, Stefan, just walk me through how you come up with the number somewhere between 400,000 and 1 million tests, given the provision in the bill would only apply to those individuals that did not want to get vaccinated. So how did you come up with those numbers? What assumptions did you make?
Mr. Chairman and Senator Hicks, you're right. It's a very crude assumption and extremely conservative in the worst case scenario. Those are essentially the numbers, just crude math on employers in the state of Wyoming that have over 100 employees. And then assuming that you had to test every one of those once a week, it would be around 75,000. Obviously, to your point, that would not be the case if many of those employees were vaccinated or the employer itself was not subject to a vaccine mandate per the bill here or per the federal regulations. And then if you cut that in half, that would essentially be the non-public entities, so the strictly private employers. But again, Mr. Chairman, Senator Hicks, very, very rough numbers. I think we're just trying to offer a little bit of scale of how big it could be if everyone were included in a testing requirement.
So if I understood what you said, if we'll just ask a quick question to our Director of Workforce Services. What's the approximate workforce in Wyoming?
Mr. Chairman, members of the committee, Robin Cooley, Director of Wyoming Workforce Services. I'm going to refer to Mr. Jason Wolf. I think has that information right at his fingertips.
Okay, thank you.
Good morning, Mr. Chairman. Jason Wolf with Department of Workforce Services. I am the administrator for workforce standards. I thought I had that right at my fingertips, but I think if memory serves, that was right around 296,000 total employees for the workforce. And I had it in a fiscal note, I believe. I'll find it shortly.
That's my recollection too, is somewhere just shy of 300,000. And so if you end with a 50% vaccination rate, that tells you you've got 150,000, right, roughly. And then, go ahead. Well, it actually goes further than that. It captures anybody who receives federal money. So that's every flat work contractor, everybody who works on any kind of federal project, everybody who receives a grant, everybody who does almost anything under the federal acquisition or procurement regulations is because the 14 Executive Order 14049 has implicated all the federal acquisition and procurement regulations to include that. So it's a much bigger number. So anyway, even if you say there's 30%, and 30%, there's 100,000. If you're testing 100,000 people a week, still a lot. And what's a test? What are tests costing these days? What are testing costs these days?
Mr. Chairman, test kits range depending on the type of kit, the type of platform it's run on, and the vendor that it's coming from. The Department of Health, we have about 3 or 4 different types of test kits and platforms that we have largely procured, mostly on the PCR polymerase chain reaction test that's run on a certain platform. And our kits are running about $100, $120 per kit. That's been the case really for the last 14 months with the vendors that we've been using.
I bought a kit at Walgreens and tested myself for $28, I think. No, I don't. But is there anything have you seen anything in the bill that would means we test it? Can you do those types of testing kits?
Mr. Chairman, it's a good question. And again, that's what we're pointing out here is really not the Department of Health's realm, but really the questions we've received over the last week from employers or organizations. Could we use X, Y, or Z kit? Do we get them ourselves? Do we get them from you? I would also clarify, Mr. Chairman, that a little less than a year ago, we did evolve a little bit at the Public Health Lab here in Cheyenne that took over a big portion of the contract where we were supplying those saliva-based kits to any individual or business. And we were able to run that assay at our Public Health Lab for much cheaper. So essentially right now, for a big portion of what the Department of Health is providing through saliva-based testing. We're running that in-house, and that's running us about $35 to $45 per kit for logistics and supplies. So it really does range, but when we go procure them, and that's the reason we're offering that is, a somewhat more expensive test is generally for that PCR test that you're getting from a private lab or from a vendor, they are upwards of $100 per kit.
And when they do that, somebody in the lab is doing the analysis, so it includes the analysis and then the report back on the sample. Okay. Anything else? Okay, thank you. Appreciate that. All right, Director Cooley.
Thank you, Mr. Chairman, members of the committee. Again, Robin Cooley, Director of Wyoming Workforce Services. Thank you for having us here today. I think as you went through House Bill 1001, I think you called up some of the concerns that we would have in enforcement with this. I believe there are ways to work out some of those issues. However, I believe there's a sense of urgency to getting rules in place, emergency rules in particular. And that's what would concern me, because with emergency rules, as you are aware, there is no opportunity for public comment. So we would be putting out emergency rules and implementing those with the full force and effect of the law, which I think is going to lead to a lot of additional implications down the road. With that, I think we are really here to provide input and to answer questions more than anything, other than recognizing some of the issues that you did point out in 1001. And with that, I would like to turn it over to Administrator Wolf. He will speak to House Bill HB 1002. Thank you.
Thanks, Director. Mr. Chairman, I think as Director Cooley pointed out, I think you guys have recognized a lot of some of the wording and issues that might come into play. One thing that I'm not 100% sure, as I'm not an expert on this, but one thing that strikes me that might need some consideration is the shalls. For instance, shall grant an exemption for religious or medical grounds. I think we need to get a question into our EEOC federal representative that we work with, just to see if that presents any issues. Right off the top of my head, it doesn't, but it was just something that caught my eye in review. Real quick, Mr. Chairman, I did find the numbers, and I can share this document with all of you, but I think that we gathered some information previously from our research and planning department out of Casper. And this was just a few weeks ago, but it looks like we have right around in the neighborhood of 115,000 employees in Wyoming that work for an employer that may have 100 or more employees, both government and private.
Okay.
Other than that, Mr. Chairman, I don't have any real issues with House Bill 1001 as it relates to us enforcing it, but would stand for any questions.
So what do you see as your as you read the bill, what do you see as your enforcement obligation as a department?
Mr. Chairman, I think from my perspective, obviously we have, to me, as the bill's written, I think it's fairly well, cut and dried. We would take, the written plan and on notice. I do like that word that someone mentioned, Mr. Chairman, I believe that was you, at notice rather than evidence. So that if an employer does have a vaccine mandate, we are on notice of that. We would, of course, take and investigate any unfair employment practice that someone is alleging and issue a determination. And I think to some of the questions on the committee, the way I saw that playing out is it would kind of flow through that 29 or 27-9-106, where we would issue a determination and then they would have their due process following that.
And can you there's a lot of people who don't know what that process is. If you can explain that really quickly.
Mr. Chairman, sure. So typically what will happen is someone will allege some form of discrimination. We will take that complaint. We will investigate it through both interviews of witnesses, if there is any, manager interviews, documentation that the claimant may submit to us, that proves or whatever the cause of discrimination. We would then evaluate that evidence, issue a determination. If either party is aggrieved by that, meaning they're not happy with our determination, they can request a fair hearing, which is heard in front of the Office of Administrative Hearings.
And from there, if there's appeal from there, then it goes to district court and off we go, right?
Mr. Chairman, that's correct.
Okay, thank you. Any other, so other than that enforcement, I mean, I didn't see any opportunity for you to enforce or decide whether the, when you receive notice of the, if they thought it was for the health, safety and welfare of the workplace, or if they thought it jeopardized their business, you simply receive that. You don't investigate that. You don't weigh on that. You don't make any counter determination on that. Is that correct?
Mr. Chairman, yes, that was my reading of the bill, and I think that's the way we would play it out within the agency.
Okay. Thank you. Anything else? Anything else? Did you have any comments on 102, 1002, excuse me?
Mr. Chairman, right off, to kind of echo Mr. Farmer's, I had read this. I don't see any major issues with House Bill 1002. One comment that I kind of drew my attention here as I was reading this and just highlighted it is page 7, number Romanet 3, lines 2 through 6, definition of a public entity. And if I'm reading that right, it does say public entity does not include any entity receiving federal funding. I lost my thought on that, Mr. Chairman, but I think just for the committee's knowledge was OSHA does receive, Wyoming OSHA, though we're a state plan, we do receive some federal funding.
Right. Okay, thank you. Any other questions for either Department of Health or Department of Workforce Services? Stefan, one quick question on the back on 1001 on the differentiation between the COVID-19 vaccine and an emergency use authorized COVID-19 vaccine. That's possible that one moves from one category to the other, isn't that? I mean, that's exactly the process, isn't it?
Mr. Chairman, that's right.
Okay.
And one vaccine has been fully approved. The others are in process. And then you have the different age groups. Right now, there's recommendation for emergency use authorization for younger age children for some of these vaccines. But happy to provide the committee with that information of how the EUA versus the full approval works with the different phases of clinical trials, if it would be helpful.
I think that's okay. Just for our edification, make sure we're all on the same page. Which is the one that has received FDA approval?
Mr. Chairman, my understanding that's the Pfizer COVID-19 vaccine, but for a certain age group, I believe above the age of 16, but we can provide that breakdown.
Okay, thank you. Go ahead, Senator Steinmetz.
Thank you, Mr. Chairman. Just one more question for the Department of Workforce Services. And I'm just wondering, when we're talking those big numbers of our workforce that is affected by a possible federal mandate, if we did not provide exemptions, what could be the effect for people who, might just choose to leave employment, and what would be the effect for the state if that were to happen? Thank you, Mr. Chairman.
Mr. Chairman, Senator Steinmetz.
Go ahead.
If the question is, are they eligible for unemployment? Is that, I guess I'm not really certain what your question is asking. What is the effect on them?
Mr. Chairman, to clarify, it would be two parts. What would be the effect on the unemployment system possibly? I mean, I know that that's a conjecture at this point, but also what would be the effect of the state as far as the workforce that we have going forward if employees were just to simply strike and not play the game with the federal government.
Mr. Chairman, Senator Steinmetz, I think as we've all been hearing, employers are in a difficult time right now as it is, finding employees. You drive down Main Street and across Wyoming and there are hiring signs everywhere. I think if we had a situation where we had individuals striking, I think what the potential is, of course, it's conjecture, but the potential is then we would have additional shutdowns from that, business shutdowns from that. And then we go into that similar situation, I suppose you could say, to what we had earlier with those individuals that are where businesses are shut down, they would be eligible for unemployment and we would be going down that same road again. So I think you can make all kinds of guesstimates on what might happen, but that's a possibility that I would see if that were to happen. On the other hand, what I've also thought of as an option is if you have individuals that are having to, for instance, quarantine for certain days and they've got to be out of work. So you've got an employer that has to juggle those individuals that are quarantining and juggling other individuals back into work and rescheduling their work. Perhaps that balances itself out. That's just another option. It's all conjecture on my part, but it's certainly something that we've been watching. Thank you.
Mr. Chairman, for providers, healthcare providers who receive funding through CMS, Medicare, Medicaid, that we anticipate likely being impacted by a federal vaccine mandate in those settings. So hospitals, nursing homes, potentially other types of providers like developmental disability providers, congregate care providers. Through Medicaid, they receive that money through us by making claims for the clients that they serve, and we provide reimbursement with generally 50% state dollars, 50% federal dollars. The other side of that is Medicare, generally healthcare services for those over 65 or with disabilities. That is purely federal. That does not run through us. We have some overlapping programming with Medicaid and Medicare clients, but for the most part, Medicare is a strictly federal program. The way that we anticipate CMS vaccine mandate potentially being enforced would also be through the Department of Health, but not through the Medicaid program. It would be through our Office of Healthcare Licensing and Survey, which from time to time puts its CMS hat on and in partnership with CMS enforces what we call conditions of participation in Medicaid and in Medicare. You can think of certain code issues with buildings, service delivery requirements, different types of medical regulations that are part of Medicaid and Medicare. And we anticipate that the CMS vaccine mandate will likely be enforced through a condition of participation with both Medicare and Medicaid, again, which would be, if everything were as it is today, would be enforced or surveyed through our Office of Healthcare Licensing and Survey. Mr. Chairman, that is the Center for
Thank you.
Medicare and Medicaid Services.
Thank you very much. All right, thank you. Go ahead, Senator Drew.
Thank you, Mr. Chairman. And I apologize for my absence. Director Cooley, I have a question, and I'm going to be asking this a lot, I think, today, and various themes, try to understand this. If this bill passes, do you feel that it would fall to your department to interface with employers on exactly how to interpret these rules and laws and how you could, and how the business owners to work through this, that you're going to be the clearinghouse for this in your rules?
Mr. Chairman, Senator Grew, to some extent, yes, and that doesn't help you very much. I absolutely agree with the assessment that when an employer submits a statement that says, for the health, safety, and welfare of my business, I need a vaccine mandate. I think that's a statement that we get, we stamp it as received, and that's done. We don't look underneath that to determine whether there is a health, safety, welfare issue there. But then when it gets further, certainly that's going to, when we do get a complaint, certainly that's going to come into us, and we will have that interface with employers, looking at the actual issue that's being raised as a discriminatory issue.
I can follow up.
Go ahead.
Director Fuchs, when asked in one of the provisions of this bill to provide evidence, and I think that may change, but the way it's written right now, to provide evidence of the need to have, have an exemption or not have an exemption, would that fall to your department to ascertain what that evidence is and how that would work?
Mr. Chairman, Senator Grew, I believe it would. Now, as you look at page 4, Romanet I agree with Mr. Wolf, and I believe it was the chairman that indicated, talks about written evidence there. I think written notice there would be appropriate. Right. But as we get into the medical information, yes, that's something that we will need to look at, and the comment, and we will need to determine if that's an appropriate medical exemption that we receive. And the comment then raised by the committee a little bit later, where it talked about the medical contraindication, that concerned me as well, because there is no indication there that we would get something from a medical provider. So that concerned me somewhat as well. But that would be where our interface would be with medical providers, certainly.
One more follow-up.
Ask your question.
Thank you. So it's more than just rules, and it's more than just one employee. It sounds like it's a little more of a task. I know that the way the bill's written currently, it's business with employees over 100 people. That may change, that may not as we go through this process. But I'm saying, depending on how it goes, this is going to be more of a workload than I think this bill indicates. As far as between rules, promulgation of rules, and then going through all these evidentiary parts and the whole show.
Mr. Chairman, Senator Grew, that's a possibility. Yes, when we looked at the first version of the bill and it talked about severance and it talked about us providing testing, that was a little overwhelming. So when it has been cut back from that point, in discussions with legislators, I think we did agree to cut it back to one employee, but certainly it could get to be much more than that. And I will let the committee know that in this particular area of our agency, we have reassigned three individuals over the past year and a half to other areas of the agency that have needed much more assistance. So in that particular area, we are down 3 individuals.
Thank you, Mr.
Okay. Mr. Vice President, did you have something? Stefan, before we let you go, how much Medicare and Medicaid dollars flow into the state a year?
Mr. Chairman, on the Medicaid side, our biennial budget in Medicaid is about $1.3 billion on a 2-year budget. Generally, about half of that is federal funding. So you can, again, crude math here. On an annual basis, probably around $250 million a year. Now, again, that's total. So what providers would be subject to certain mandates or the provisions of a bill like this, probably relegated to hospitals, nursing homes, those other types of providers that I mentioned, but they do represent a majority of our Medicaid spending.
Mm-hmm.
On the Medicare side, my understanding is that is also in the billions on an annual basis. I would have to double check on those figures since we are largely not involved there. But a good way to think about it, Mr. Chairman, for Medicare is generally, folks generally enroll when they're 65 years old in Medicare. So it's a sizable portion of the population.
Thank you. Okay. Thank you. Appreciate that. Go ahead and now open for public testimony. Oh, yes, Heather.
Mr. Chairman, I am here if this is a good time. If not, I can come back to
For
go
one-
through 1002.
Sure, please, go ahead. 1002.
Okay. So we're looking at House Bill 1002, the engrossed version. And my understanding is you want to go through this bill, but also to highlight what changed from the bill as introduced. Is that correct, Mr. Chairman?
Not so much that, I think this one didn't change, well, this one didn't change much as the other one. So just go ahead and take us through the bill. If you want to highlight a couple things you think are relevant, please do. Okay?
Thank you, Mr. Chairman. Okay, so on the title of this bill, and I'll highlight each of these sections when they come about, but so this is relating to protection of individual rights, and that's because the reason for that part of the title is that this is located in Title 9 in Chapter 14, which is
Hang on one second.
a bit loud.
We have people watching, and I don't know that you identified yourself.
Excuse me. Apologize. My name is Heather Jarvis. I'm with the Legislative Service Office.
One of our staff attorneys.
Yes.
All right, go ahead.
Okay. So in Title 9, Chapter 14, that is a section of the codified statutes that have to do with protection of individual rights. So that's why that's right there in the title at the very beginning to alert folks. Now, this bill draft is going to, or this bill provides for legislative findings. So we'll go through several of the findings on the next pages. It also prohibits the enforcement of federal COVID-19 vaccine mandates and providing limitations on requiring COVID-19 vaccinations. And then there are some definitions, and there's an authorizing litigation to protect the rights of Wyoming citizens, and there's an appropriation. So the bill begins at the bottom of page 1 with section 1 with some findings. The legislature finds that, and we go to the top of page 2. Now, I don't think that the committee necessarily wants me to read each finding, but I'll summarize this. It describes that the coronavirus was found, then that there were, in paragraph 2, it describes that throughout 2020 and 2021, that some vaccines were developed and authorized and approved. And then in paragraph 3, that it was notified in September of this year that there would be some OSHA rules promulgated to require businesses with 100 employees or more to ensure that employees are vaccinated. Finding 4, in paragraph 4, starting at line 20, it finds that as part of the plan that was introduced and some of the specifics of how that will be introduced, and that goes over to the top of page 3. Paragraph 5 indicates that it is expected that the rules promulgated by OSHA and the Federal Occupational Safety and Health Administration and the Centers for Medicare and Medicaid Services will be promulgated soon. Paragraph 6, which begins at the bottom of page 3, speaks to some of the fears of Wyoming citizens regarding their employment. Paragraph 7 indicates that the decision to receive the vaccination is a personal decision, and paired or kind of parallel to that is paragraph 8, that the decision to implement hiring practices regarding that should be a private decision as well. Paragraph 9 describes the 9th Amendment to the United States Constitution that provides that the enumeration in the Constitution of certain rights shall not be construed to deny or disparage other rights retained by the people. And then the paragraph 10 describes the 10th Amendment to the United States Constitution, providing that the powers that aren't delegated to the United States in the Constitution or prohibited by it to the United States are reserved to the states to account for. And then moving on to page 5, there are then 2 provisions. It describes 2 provisions of the Wyoming Constitution. One is Article 1, Section 38, that provides that competent adults in Wyoming are able to make their own healthcare decisions. And then paragraphs 12, the Article 1, Section 38, providing that the legislature may determine reasonable and necessary restrictions on the rights that are granted under that paragraph, subsection C, for the general welfare of the people. And then moving forward to paragraph 13, that describing that this legislature, through various legislative enactments, has established its primary role over immunizations and immunization laws and regulations that are based in Wyoming that the legislature has enacted. And then paragraph 14, the legislative process, which permits that persons can submit religious exemptions to vaccine mandates, and that has been provided for in law. And then begin at line 22, that by imposing a COVID-19 vaccine mandate on the people and businesses of Wyoming, this finding indicates that the government's actions, the federal government actions, constitute an abridgment of both the United States and the Wyoming constitutions, those provisions that were laid out previous to this. And then the final finding is on page 6, starting at line 4 in paragraph 16, that the state of Wyoming as a sovereign entity cannot be compelled to enforce vaccine mandates from the federal government that might well be deemed an unconstitutional exercise of the power of interpretation to insist that the states are bound to provide means to carry into effect the duties of the federal government, nowhere delegated or entrusted to them by the Constitution. That ends the findings of this bill. Section 2, which begins midway through page 6, inserts into that Title 9, Chapter 14 that I described earlier about enforcing constitutional rights, a codified section of law that begins, it's 9-14-103 is the newly created section, and subsection A are some definitions. So the first two definitions, COVID-19 and COVID-19 vaccination. COVID-19 was previously defined, and so it refers to a place where that is defined in 1-1-141 subsection A, paragraph 2. And then for COVID-19 vaccination, it's defined to mean any vaccination that is marketed to prevent COVID-19 or any vaccine that is marketed to diminish or decrease the symptoms of COVID-19. Now, at the top of page 7 is a definition for public entity, which refers to a quite expansive definition of public entity that already exists in statutes in Title 16-6-101, subsection A, paragraph 8. And that's an expansive definition of public entity, but then it is accepted out. This was one of the amendments that was put in, except that public entity does not include an entity receiving federal funding that by complying with subsection B of this section would lose that federal funding. That was inserted to carve that part out.
So-
those folks out of that.
So I've got some questions about that. I think we looked at that last night when we were kind of doing some prep work for today. And I think it was it you, Mr. Vice President, looked that up? Or was it? And go ahead, Mr. Vice President. It's quite an expansive list.
It is. And I apologize, I should have brought the definition.
Was it-
Mr. President or Mr. Chairman, I don't have a question, I have an answer.
Okay,
And I would reserve that to when we work the bill,
okay, all right,
rather than ask our staff a rhetorical question.
yeah. So it's a broad list, but anybody, it's universities, community colleges, it's cities, towns, counties.
Mr. Chairman, yes, it is
Commission.
essentially, and I don't want to misspeak because they are listed in 16-6-101A8, but it is essentially in entities that serve the public and receive public funds listed in that.
Right.
But however, I can obtain the actual definition.
No,
if
that's
you'd like.
okay. Yeah,
Sounds like you might have looked at it, Mr. Chairman.
yeah, we've looked at it. So I think we know that's just for public consumption. So go ahead, keep going.
Okay.
So if you accept it, I think we're on B.
Yes, so now we're on subsection B, And many sections of the rest of the sections refer to this subsection B. This is sort of the chunk or the big force behind this particular section of law. And it indicates that no public entity shall enforce any mandate or standard of the federal government, whether emergency, temporary, or permanent, that requires an employer to ensure or mandate that an employee shall receive a COVID-19 vaccination. So that, and then we move on to subsection C, that subsection C and D are both timing of, they're going to refer to some of the, whether there are any challenges in court to these. So subsection, as far as to when subsection B is enforced. Subsection C describes that to the extent that the subsection B, or well, this entire section, but it's B, that conflicts with federal law or a regulation, rule, standard, or order. That language is to catch everything. That this subsection B shall not be enforced after the federal law, regulation, rule, standard, or order takes legal effect that requires Wyoming employers to comply with the federal mandate. Then you read, go on to subsection D, that notwithstanding the subsection that we just read, subsection B shall be enforceable during, and this is, that indicates any period in which the federal law, regulation, rule, or order is subject to a federal judicial stay applicable in Wyoming, or is otherwise repealed, withdrawn, superseded, or declared by a federal court of competent jurisdiction to be unlawful or unenforceable. So what those two are saying is that in subsection C, it's saying once a law goes into effect, it shall be it shall be effective, sorry, excuse me, subsection B shall be enforced once a rule is in effect. However, not if it conflicts with federal law, and not if it is, if a federal law is repealed or withdrawn or somehow superseded or found to be not constitutional, or for whatever reason is struck down. But during the pendency of a stay, it shall be enforced. That is so that's the combination of those two paragraphs as far as when the enforceability of subsection B. Then there's this new subsection E, which I'm on page 8, starting at line 7. And this provides that no public entity shall require a person to receive or show proof of a COVID-19 vaccine for the person to receive or qualify for any public benefit to which the person is entitled. And the sections that are not withstood at the beginning of subsection E, those are some public benefit act statutes, specifically, for example, a vaccine for going into school, and right now the rest of those left me. But as far as public accommodations such as school shall not be withheld because a person does not show proof of vaccination. Then on section 3, starting in the middle of page 8, this indicates that the Attorney General's office, with direction and consent by the governor, may initiate and participate in litigation and to take any other appropriate action to challenge and resist the federal government action related to COVID-19 vaccine mandates. And section 4 is an appropriation to the governor's office to accomplish what is described in section 3. And then this is the section 5 on page 9 is the effective date, which is effective immediately.
Okay, thank you. Any questions for Heather? Thank you, Heather. Appreciate it. Go ahead, Senator Kinski.
So Heather, when just kind of a little bit of a heads up, when we get to markup, I think everything on page 7, what we're trying to say is, federal government, we are not going to enforce your mandate. Period. And then we say it's stayed pending any litigation. that's not the way it reads when I go through here. It seems much, and I know it's been heavily amended in the House, but I think we're going to try and get this much more clear than we've got it here. So that's just kind of a heads up. The second thing that I'd like you to think about, because I've already put in an amendment request to this effect, and it's not real clear to me, but this section about, I mean, we are directly subject to this as well as a state, to the extent that we own hospitals, political subdivisions, we own the state hospital, we're going to be subject to the CMS mandate. To the extent that any political subdivision of state receives grants, we're going to be subject to it, to a complete cutoff. So I'd like to see something following on the heels of this that says we won't enforce your mandate on private businesses. Something that says, by the way, your mandate is not, we're not subject to your mandate as a state. You're violating the 10th Amendment. And so Justice Roberts in Obamacare said, you know, when you just threaten to cut off all the money to the states, it's like a gun to the head. They don't have a meaningful choice. So 3, if you imagine, if you just took 3 out and there's a whole recital in there that says, to the extent that you're trying to enforce this against us as a state, not Wyoming businesses, you're violating the 10th Amendment. And then with respect to the businesses, we don't really, to an extent, any businesses want to challenge it. As a state, we don't have standing. The business has standing. We do not. So I wonder if we couldn't have a section that says that the state would help bring a class action lawsuit on behalf of anybody affected by the OSHA mandate, the CMS mandate, or the grants cutoff mandate. Because they may have standing, but they won't have the resources. So then section 3 is kind of alludes to that, but I don't know that anybody's going to be creative enough to actually say, well, let's bring a lawsuit on behalf of the state, qua state, and then let's bring a class action on behalf of the businesses.
Mr. Chairman.
Yes, go ahead. Heather.
Senator Kinski, you were focusing on section 3 on page 8. And I'm not entirely sure whether to interpret what you're describing as to an expansion of section 3 to suggest a class action as a suggested amendment.
Mr. Chairman,
Go ahead.
I'm suggesting just strike section 3 and make a new section 3 that says,
Okay, well,
that recites the fact that the state, because we are in the business of accepting federal grants and getting Medicare and Medicaid, that if there's a threat by the government to cut that off, if we as a government do not submit to their mandate, that it violates the 10th Amendment, and we will have standing to sue on that basis and will sue.
okay, we're a little bit ahead of ourselves. We're working the bill.
No, I just want to give her that while she's
Okay.
here. And then a section 4 that will bring action, will help businesses that do have standing to bring action, the class action.
Okay. All right, let's
Thank
go
you,
ahead
Mr.
and
Chairman. Thank you for your indulgence, Mr. Chairman.
You bet, Mr. Vice Chair. We are, let's go ahead and start into public comment. And so let's go ahead and please come up and go ahead. So have we got a list of people that signed in? Was there a sign-in list today? Okay, and then do you have that list for me? That's all right. All right, so let's go ahead and we'll get started. We've got and 12. And how many do we have in the room, the waiting room?
Mr. Chairman, we have a dozen.
And how many of those were, last week was 7 or 8? Still 7 or 8? All right. So we're up to over 40 people who want to testify. So we're gonna, just to go ahead, just the rules are you address the chair. You address, you please identify your name and who you represent if you're representing somebody. And we're gonna struggle to give everybody 6 minutes. There's gonna be some exceptions because some people in here actually represent significant amounts of people that are actually, so we're gonna give a little leeway to some of those folks, but let's go ahead and get started. So please, sir. So you're gonna be first?
Yes, thank you much.
Okay.
So I'm Jeff Chapman. I'm the Chief Medical Officer at Cheyenne Regional, and I will try and be very brief. I think I have a number of concerns. One is that I totally understand the intent of this bill, and I allowed it.
And you're speaking on 1001 or 1002?
1001, sorry.
Thank you.
My fear is the impact of this bill is going to be to create chaos. I think that just listening to the conversation, the concerns from Director Cooley, the concerns from myself, I think as written, I think that the impact is going to be chaos in the sense of how do we enforce it? How do we implement that sort of thing? And just, for example, one of my concerns relates to the religious exemption. I think there needs to be something in the bill that says that employers have the ability to create some type of a process on what constitutes a religious exemption. It certainly leads to a lot of questions. Does someone just writing a letter saying, I object to this religiously constitute reason as opposed to requiring something from clergy, et cetera? And we're experiencing that struggle in our institution, how we fairly decide that. The second thing is medical exemptions. Again, just vague terms like a medical exemption without any type of guidance as to what constitutes a legitimate medical exemption. My recommendation would be to put some type of wording in that says, based on CDC and Infectious Disease Society of America recommendations. The current CDC standards are pretty clear what constitutes a medical exemption from a vaccination. And then my last thing just that I would like to bring up is the line that states if someone has had previous COVID, tested positive for COVID. I think there's a lot of data out there, and I do not think you can make a conclusion at this point in time. I think that the majority of the data at this time supports that vaccination provides better immunity, but I also respect that there are some data that does not support this. But without specifying what testing positive for COVID-19 in the past actually indicates, again, I think that we're going to create a lot of questions. And with that, I will yield my time unless someone has questions for me.
Okay, does anybody have questions for Mr. Chapman? Thank you, Mr. Chapman. Next.
Good morning, Mr. Chairman. My name is Jasper James Chen, JJ Chen. I am wearing a couple different hats this morning. The first one is I am the president of the Wyoming Medical Society. Second, I'm a psychiatrist at Cheyenne Regional Medical Center. And third, I am a proud small business owner here in the state of Wyoming. I'm a first-generation Wyomingite, having lived here for 7 years. I'm a second-generation American and most proudly married to a fifth-generation Wyomingite. My wife and I both come from a small and long venerable tradition of small businesses. Primarily speaking as to 1001 this morning, I believe and have faith in the small businesses of Wyoming. I believe as you work through the bill today, please consider the fact that our enlightened businesses have the ability to ensure that we are taking care of both of the people who are working in our businesses, and our general population in our community as well. This is a state that we believe truly has taken care of her own people. This is a state that I've loved and lived in for the 7 years that I've been enjoying this experience so far. I believe we trust that the state has the capability of ensuring that all of our employees and all of our workers and the individuals that they serve are going to be benefited by any such adopted statute. Thank you very much.
Thank you, Mr. Chen. Any questions for Mr. Chen?
I would have a question, actually, going back to Mr. Chapman from Cheyenne Regional. You asked that the medical exemption at a minimum be based on CDC, or you mentioned some other organization.
Yes, through you, Mr. Chairman, Senator Kinski. So Infectious Disease Society of America. And that, I believe most people, those two organizations, one might also include the NIH, National Institutes of Health. I think most people feel that they create reasonable guidelines.
Mr. Chairman, if I may, and the doctor as well could answer this. So and first of all, I don't want the employer in the middle of this. You know, it's got to be the physician.
Yeah.
So as a physician, can you turn to the CDC and infectious disease or NIH and get some kind of guidance as to when a vaccine would be contraindicated? Like, for instance, I got a call from somebody, they have severe rheumatoid arthritis, autoimmune disorder. They're just very concerned about taking the virus. They have a friend similarly afflicted that had a very bad reaction to the virus. They said, well, you know, it might be coincidence, but who knows? So would a physician get some solid guidance on when to be cautious, even though there may not be solid peer-reviewed evidence, just when to be cautious about administering the vaccine?
Yeah, Mr. Chairman, through you, Senator Kinski. So in answer to your question, yes, I think that the guidance is fairly clear and succinct. And I think this goes to my point that the complexity, the difficulty of this, the enforcement just sets us up for lack of a better term, chaos, in the sense of I don't know how you're going to implement and enforce all of the pieces of the bill as they stand in balancing individual rights versus employers' rights. I think it's a very difficult thing. And that's without further work. I think that I would support not passing the bill as it stands.
Mr. Chairman.
Go ahead.
And so at Cheyenne Regional, and perhaps Doctor in your business as well, are you already doing something like the process that's here? In other words, you're giving employees who don't want to vaccinate a pass if they've got a valid reason for it, and then they either have to mask or they have to avoid patient contact or some other alternative means. Is that something Cheyenne Regional or your medical practice is already doing?
Yeah, so at the present time, we are not, have not implemented any mandates or any need for a exemption. It's something that we take very seriously. And again, we're trying to balance individual employee rights with the safety of our staff and our patients. And we continue to assess it. So the short answer to your question is no, we have not at this time. However, with the flu vaccine, we have had to make such accommodations for religious and medical exemptions. And we have a committee and a process for that. And we're a large organization, so I think we're capable of creating a process like that. What I fear is the very small organizations, the medical practices that receive federal dollars from CMS, that sort of thing. It becomes much more difficult and onerous for them to create a process. Plus, we also create multiple processes that are not consistent across employers.
Thank you, Mr. Chairman.
Okay, thank you.
Mr. Chairman,
Go ahead, Mr. Vice President.
one question, and when we get to page 4 on line B, it talks about the employer shall grant exemptions for medical grounds. On submission of exemptions that is completed and signed by a licensed physician, advanced practice nurse, or physician's assistant. So the question I have here, you could have potential reactions or some adverse effect associated, but are we missing something here from a standpoint when we start looking at mental health issues? Is there potential here that we have not captured that we may want to grant for somebody that has some type of psychiatric problem or something, an exemption as a medical exemption underneath that? I'm just trying to anticipate that somebody might have some mental illness that mandating a vaccine could actually create some mental health issues. And so just your thoughts on that as Dr.
Mr. Chairman, through you and Senator Hicks, there is a lot of moral injury related to COVID as it is with or without regard to the vaccination. I would say the moral injury and psychological harm can come not only in the effect of the individual who is or is not vaccinated, but also the healthcare provider who may live with the decision that their patients are not vaccinated or have a personal belief system that does not allow them to want to take the vaccine at the present time. As a psychiatrist, individually speaking, not even as a medical staff officer, Cheyenne Regional Medical Center, vaccine is a very, very personal choice. I do personally believe that vaccines are incredibly powerful and robust at saving lives. We already have surpassed the almost 750,000 numbers of individuals who have died in the United States this morning. And so my goal as a psychiatrist, first and foremost, is to prevent unnecessary death. Whether someone gets the vaccine or not may certainly help in that regard, but I will be taking care of the fallout for years, if not decades to come, as a result of whether or not individuals choose to take the vaccine or not.
Well, I think the question, Doctor, is, and I didn't recognize that you were a psychiatrist, but it makes you, I think, uniquely qualified to speak on that. And the question is, being that case, should we add to the individuals who can grant a medical exception? Should it include licensed mental health professionals?
As a psychiatrist, I cannot also speak to the fact that we would be the end all and catch all for being in this decision. I would trust that any licensed physician or APRN or individual in the statute would be able to, on their training and professionalism, be able to grant exemptions as appropriate.
Okay. All right. Thank you.
Just beg your indulgence one more time.
Go ahead.
Back to Cheyenne Regional, because COVID obviously is a concern. What is the hospital doing? I mean, you don't want employees walking in sick. Describe to me how you're protecting the patients and the staff at Cheyenne Regional absent a vaccine mandate. How are you proceed? What's your procedure?
Mr. Chairman, through you, Senator Kinski, the current process at Cheyenne Regional is that we ask all of our employees to do a screening every day online through an app, talking about symptoms. If they have any exposure, any fever, anything like that, then we refer them to occupational health. And we currently are not testing randomly or requiring testing, but that certainly has been considered. I don't know if that answers your question adequately.
Mr. Chairman, it does. Thank you. So the answer is you're just screening everybody to see whether they have vaccinated or not. You're just screening everybody as they begin their shift at the hospital and based on signs and symptoms.
Mr. Chairman, through you, yes, is the answer to the question.
Thank you, Mr. Chairman.
Very much. Appreciate your attendance this morning and taking time out of your busy schedule. I'm going to go ahead and start calling people up so I can keep track of this a little bit easier. Let's have the next three come up. Scott Meyer, Tim, is it Tim? He's also from Cheyenne Medical Regional Center, and Robin Rolling. And is there a Tim? Come on up, Scott Meyer, come on up, and then Robin Rolling, if I'm recognizing, come on up if you're going to speak today. So, and then we'll go ahead and Mr. Meyer, we'll let you go first.
Thank you, Mr. Chairman. Scott Meyer on behalf of the Wyoming Bankers Association. I guess I'll just start by telling you that the Wyoming bankers that I represent, 25 or 26 of them are local community banks. We've got a few national, but most of them are the small community banks. These community banks are the spirit and the backbone of small businesses. That's what we do, and that's what we help do. So in general, anything that has to do with dealing with the employers, we are supportive, but we're not in support of anything that puts additional burdens on our small businesses and including our banks. One thing I'll point out to you, that anytime that there's a conflict between the federal rules and the state rules, the problem gets magnified, at least with respect to my members, is that if you look at FDIC insurance, that is a program that is ostensibly run by the federal government and could very well affect my members, whether they have 100 employees or not. I'll keep in mind that what we have that makes us so special is that state charter, or we will not risk that charter, but at the same time, we don't want to abandon our customers either, because they are the ones that are counting on us. And you all well know about what we've done with respect to the COVID stuff and the PPP loans. And so we do believe in our local businesses. As to a couple of comments that I want to make, I want to look at House Bill 1001 in Section 2. There has been a little bit of comments on that, but it seems under 2B that there is a shall have language in there, and we're a little bit concerned about that. As committed to unfair employment practices, it seems that they're automatically, now people are committed or automatically deemed guilty and subject to 27(9)(106). And we would suggest something that maybe say something like may have, or something in equivalent. I think that I don't want to have anybody deemed to have been all of a sudden in violation of something just by presumption. We've also heard this morning a little bit of testimony too from the good folks at the Department of Workforce Services, and with all due respect to the department, I don't think that that is probably the proper place for any of these challenges to go. They are experienced in processing employee claims, as are Wyoming employers, and you want to think a little bit about maybe whether that should be the department, the unemployment division. They have equally as much respect and understanding of how this works, and they wouldn't be recreating the wheel. I'd also point out that the outcome would be an unemployment insurance payment charged to the employer rather than a discrimination determination. I did hear that this morning through the testimony as to discrimination, and I don't think we really want to go down that road. That would be very difficult for these small businesses. A discrimination outcome would affect a company's ability to either obtain or even retain liability insurance, and could trigger that payment of forward pay, which I don't think that is what we want in there. So we might want to consider making that, instead of the Department of Workforce Services, maybe the unemployment division.
They are part of the Department of Workforce Services. But
in a separate area of how that they're enforced. I don't want to be considered discrimination. There's a little bit of discussion, and I know that some of you have talked about this, but about the self-insurance plans. I'm a little bit concerned about that because of the cost and whether the mandates that are coming out of there, whether the state would be willing to start picking some of those up. Some employers have faced massive COVID hospitalization claims when they're under self-insurance. And you can imagine the shock to some of these systems if all of a sudden they would have to do this. So I guess if an employer faces a few of these, they could limit their ability to continue offering a benefit plan. And I think that that is something that we do not want to have happening to our small businesses. Again, I just bring out the point that I try to navigate between what is a federal mandate, what do we have to do, and what's the state. I think that it gets to be some very difficult decisions for not only small business, but especially for bankers. I guess where I'm trying to go and try to think about this is that the EEOC already has some language in there as to what is the requirements under exemptions and reasonable accommodations. I don't need to have another conflict in there. So I think that that probably ought to be something that we consider. Those are long and lengthy, and I'm happy to try to go through that with somebody. There was a discussion earlier this morning, and I think, Mr. Chairman, you had brought up the idea of written evidence versus notice, and we certainly support the idea that written notice is probably more appropriate than evidence. And then there is also some discussion in there about what kind of accommodations the employer has to make. And when you do that, as to whether there's medical exemptions, whether, you know, the discussion that we heard earlier about whether somebody has priorly had COVID, with respect to that, I would ask that that has to be provided by a medical doctor. I get concerned about small businesses and especially the banks regarding HIPAA language. And I don't want the employers and especially my banks having to make a determination as to what is valid and what is not, what is an exception under the medical rules. I don't want them to have to explain to my employers and they make a decision as to what happens, what is a valid excuse or not. So I want to be perfectly clear that that has to come from a medical provider. We don't want to get into those discussions. And then finally, I heard some discussion a little bit this morning about the testing. You know, instead of maybe under 2 Romanet 3, maybe instead of shall be offered to employees where available, maybe it should read something like shall be offered to employees when reasonable and cost effectively available to the employer. I know that there's been a little bit of discussion this morning regarding some ideas on, you know, what is the cost, but think about a lot of the areas in Wyoming that are rural areas, and they may not have access to suitable testing, some forms of suitable testing. So I want to make sure we don't put our employers in, you know, an unfair advantage of trying to figure out what they have for access options and costs. With that, I would stand for any questions.
Okay, thank you.
Mr. Chairman.
Go ahead, Senator
Thank
Kinski.
you, Mr. Meyer. You said on page 4, you wanted a shall have changed to a may have. Where is that on page 4? Which particular shall did you want changed?
Let me grab my iPad. Hang on.
Actually, I think you're referring to page 7, line 10, where knowingly shall have committed an unfair employment practice. Is that what?
Mr. Chairman, that is correct.
So that's on page 7, line 10.
Okay. Is that the only shall may, Mr. Meyer?
That's all I recall right now.
Okay, Mr. Chairman.
Go ahead.
So if we move this out of the discrimination realm and into the UI claim realm, how would you see the UI claim being triggered? That the employee feels that the employer is not offered reasonable accommodation would be the basis of an unemployment claim?
Mr. Chairman, Senator Kinski, I would.
Okay. And then the last, Mr. Chairman, if I may, the last thing you said is the EEOC language already has exemptions and something else built into it. And you'd like to leverage off of that if this bill moves forward. What it was exemptions and what else the process?
Mr. Chairman, Senator Kinski, I think that the EEOC also has like reasonable accommodations and exemptions as to what you would do. And I just don't want to have a conflict between what our definitions are and the EEOC have.
So, Mr. Chairman, would a cross reference to the process and the definitions of reasonable accommodations and how you determine exceptions under EEOC, would that assuage a lot of these concerns that we may have conflicting processes running around?
Mr. Chairman, Senator Kinski, I think so. Whatever I can do to alleviate the any miscommunication or a misunderstanding between the two different areas or making any conflicts.
Mr. Chairman,
Go ahead.
Mr. Meyer, would you mind? Could you try and put an amendment together to that effect so that I can better understand it and maybe present that to staff? It's a comment I've heard from many other businesses. If you're going to do this thing, just follow an established process and established definitions.
Mr. Chairman, Senator Kinski, I would be happy to.
Thank you.
Okay, thank you. Anything else from members? Thank you, Mr. Meyer. Appreciate your time and attendance today. Next, I think we've got, just go down the line. I think Mr.
Thornell.
Thank you.
Mr. Chairman, Tim Thornell, President and CEO at Cheyenne Regional Medical Center. I'm joined by Joanna Vilos in lieu of Robin Rolling. Joanna also signed in to speak today as well. She is our Chief Legal Officer and Human Resources Officer. I'll offer 2 comments and then yield the rest of my time to Ms. Vilos. First, as we look at the employment side for not just hospitals, but all of healthcare, but hospitals in particular, we are faced with many challenges retaining employees at this point in time going through the battle with COVID. And certainly there is some concern that's been expressed about the potential to lose some employees if mandates are put forth. But we also have to recognize that we are already losing employees because of the fear of COVID spreading in the hospital and where they work. And the risk that they just inherently take working in that environment. And as we move forward with the hospital at Cheyenne Regional, we are currently at 79% of our employees are voluntarily fully vaccinated. So the vast majority of our employees are vaccinated, and we have concern today and growing concern over time that employees who are vaccinated will not want to work in an environment where it is not required of all their peers. And we will absolutely be at risk of losing employees if we don't have the option to have a vaccine requirement at some point in the future. So again, just speaks to employers need to be able to dictate their own future and having the ability to choose when and when not to implement a vaccine requirement amongst their staff. My second point, more specifically speaking to House Bill 1001 with regards to Section 4, it's really important to retain the spirit of what's in Section 4, if not augment that to what it is. And that is that we need to maintain the ability to, as any business, to stay clear of any conflict between state and federal rules that may come down. To the extent that we are in the crosshairs of those two, just makes life so much more difficult and almost unbearable for businesses. So Section 4 has some of those provisions in there. With that, I'll yield the rest of my time to Ms. Vilos, who can speak a little more specifically to some suggestions for House Bill 1001.
Okay, thank you. Ms. Is it Vilos? Joanna Vilos?
Yes,
Okay.
Mr. Chairman, yes. Joanna Vilos with Cheyenne Regional Medical Center. As Mr. Thornell just stated, I'm the Chief Legal Officer and Chief Human Resources Officer there. Thank you to the committee for allowing me the opportunity to speak. So by way of background, just very briefly, I was born and raised in Worland, Wyoming. And so I would just note that I'm very sensitive to the concerns, heard a lot of testimony from people from my hometown last week, in fact, and very sensitive to the concerns around individual rights and individual choice, but also by way of background, my primary area of expertise in the law is employment law, has been for many years, and also health law. But my employment law background is what really gives me pause about some of the language that's contained in these two bills. So many of my comments have already been addressed by others. I'll go through them very briefly and explain why they're on my list as well of things to address. So for House Bill 1001 on page 4, you've heard a lot already about religious exemptions. And as the language currently stands, it just says that it will be granted upon submission of the exemption. As you've heard, that causes some confusion for employers, I believe, because it doesn't identify any standards around that. It just simply states that that will be granted upon submission of the exemption. Employers are very used to providing religious exemptions based on existing law, federal law, Title VII, and then also the corollary under the Wyoming Fair Employment Practices Act, and would just ask for recognition that there are existing standards around that. That would be very helpful if we could implement here so that employers aren't confused about how to grant those religious exemptions.
Mr. Chairman.
Go ahead, Senator.
So a question that I have specific to that, if that's the concerns on what constitutes a religious exemptions, could you please articulate to me exactly what the federal standards are for religious exemptions?
Mr. Chairman.
Good.
Yes, I'll do my best on that. It's a big topic. There's a lot to it and a lot of case law that's been developed over many
Mr.
years.
Chairman, the federal religious exemption. So if you would please, because we don't want to create a conflict. So my purpose of the question is if the feds have already defined what religious exemptions are, what you're going to tell us what those are, and we just say it's whatever the feds say it is, would that alleviate your concerns? But before we get there, what are those religious exemptions that the guidelines and standards that the federal government currently uses?
Go ahead, Ms. Vila.
Mr. Chairman. So Senator Hicks, it essentially is captured in the phrase sincerely held religious belief. So if you have a sincerely held religious belief that interferes with your ability to do something in the workplace, you are typically permitted to request a religious accommodation. For vaccines, no different. And there's a lot that goes into that, of course, in terms of what kinds of questions you can ask about the sincerely held religious belief and other things you can request. And then also considerations around that, including undue burden, which is something, or undue hardship, which is something that I was going to get to next.
So could you provide us a copy of those?
I could provide you, yes, I could provide you some language about existing law for religious exemptions.
And also the most recent DOJ guidelines on religious exemptions would be helpful also.
Yes. Oh, sorry. Excuse me. Sorry. Absolutely can provide EEOC guidance.
All right. Thank you, Mr. Chairman.
Thank you very much.
Mr. Chairman,
Senator Kinski.
before we leave that topic, I don't know what the feedback is here. You referenced federal law Title VII and the Wyoming Fair Employment Practices Act. Those aren't two different things. Those are the same thing, correct? I mean, we implement federal law Title VII via the Wyoming Fair Employment Practices Act. It's not two different things. It's the same thing.
Correct.
Okay, thank you.
All right, continue.
And I guess I should note that that's a very simplistic answer to the question, but yes, Wyoming Fair Employment Practices Act follows federal law. Typically, there are some employers who would just be subject to one and not the other, but yes.
So one more, Mr. Chairman. So you're going to provide to Senator Hicks what those are and the guidelines, but could you also provide a suggested amendment that would align granting of these exemptions up with the existing, sort of the same thing I've asked Mr. Meyer, that would line the process, the standards, how you go about granting medical or religious exemptions up with this well-familiar and established processes would be very helpful. Thank you.
Yes, Senator Kinski.
Ms. Vilas, continue. Ms. Vilas, continue.
Next comment is very similar. It relates to page 6 where it discusses undue burden. And it's great that it considers undue burden as a concept here for employers, so that there is that framework where if you can demonstrate an undue burden, there's not compliance with that particular provision. My question again would be similar to what we just discussed. So undue burden, is this intended to be a similar construct to existing federal law, federal non-discrimination law that most employers are used to following, and in that realm typically referred to as undue hardship, also undue burden? Some clarity around that I think would be very helpful for employers.
Okay.
Next would be on page 9, section 4. I won't belabor this point because I know it's already been raised, but it relates to the enforceability and just ensuring that there would be some clarity for employers about when they fall within the constraints of the state law and when they are in safe territory to comply with federal law. I think it's evolved over the last week in this bill and become much more clear, but still still some gray area for employers in navigating when they fall within the state law and when they are, again, in safe territory and complying with the federal mandate. And I guess I'll just note there that my concern is more for employers around the state who don't have legal counsel. I think about my background and what I can bring to our organization in terms of navigating this, and have concern for other employers who don't have that at their disposal. Mr. Chairman, would it be appropriate to go into a couple of comments on House Bill 1002 now?
Yes, please.
Okay. So page 7, line 3, where public entity is defined. My overarching comment, I guess, there would be my biggest comment would be about the word would lose that federal funding. So the word would there. Concern would be that it places somewhat of a burden on the employer to demonstrate that they in fact would lose that federal funding. I'm not sure what that proof would look like exactly. And again, leaves some gray area for employers, not understanding if they fall within or without. Again, on page 7, so similar comments to 1001 relating to enforceability. Again, just a concern for employers understanding when this is enforceable against them and when it's not. On a related note, page 8, line 8, I believe, talks about how no public entity shall require a person to receive or show proof of a COVID-19 vaccine for the purpose to receive or for the person to receive or qualify for any public benefit. I'm unsure how public benefit would be defined, but my concern here would be for public employers who have offered a vaccine incentive program. And so would that fall within this, or would that be in, again, safe territory? The other concern around this is that public entity, with the way it's defined previously, which I very much appreciate because it does indicate that once you could lose your federal funding, you are no longer considered a public entity. The issue would be that there are going to be times where you may fall within this statute, at least initially, before your federal funding is in jeopardy. And then other times where you fall into the safe territory and you are not covered by this statute. And so if you do have a vaccine incentive program or something similar to that, there's a possibility that there will be times that's okay because you're falling outside the definition of public entity, and times where you're not okay. And the EEOC, again, has developed some standards around vaccine incentive programs and related things. Employers have been relying on that for several months now to implement vaccine incentive programs, as we have at Cheyenne Regional, and would like to be able to continue that and make sure that that is not something prohibited. Mr. Chairman, I know I've done a lot of speaking, so I think that's it.
Okay, that's good because you just ran out of time. So it worked out really well. Any other questions for Ms. Bayless?
Mr. Chairman, Ms. Bayless, if you can send me those things in writing, that'd be helpful.
Whatever happens, so, okay, at least on this first round.
And then, Mr. Chairman, in terms of aligning this with the Wyoming Fair Employment Practices, I would assume that you want reasonable alternative measures changed to reasonable accommodations as well. That you didn't mention that, but that's something that's been mentioned.
Mr. Chairman.
Thank you.
Yes, Senator Kinski.
Thank you. Anything else? Anything else? Thank you. Appreciate your time and attention today. Does it all take care of Mr. Miss or Mr. Rolling? Is he's taking care of it now too?
Yes, thank you.
All right, thank you. All right, so thank you for those three. Let's see, Ken, let's have Keith Kennedy and Stacy Leach come up, and then we'll admit the next three people. Pick three people to admit from the online room too, please. Okay. So let's see, where's Stacy? I thought I saw Stacy. Oh, Stacy's right there, and Mr. Kennedy's right behind you. All right, go ahead. Miss Leach, go ahead.
Chief Perkins and the senators. My name is Stacy Leach. I am here representing We the People. I am a master's educated registered nurse and have worked in this community for 17 years. I'm now facing the possibility of termination if I choose not to comply with a forced experimental medical procedure that I do not need. I've listened to the proceedings over the last week, and I felt the need to share some important scientific facts to assist you in making an informed decision. People who had SARS-CoV-1 in 2003 are still immune today, 18 years later, because of these two viruses are 70% similar. Our God-given immune system is made to learn viruses, every molecule of the virus, and to remember it forever, to protect us forever. The COVID vaccine was made to teach our human body to produce antibodies against the spike protein. The spike protein is the exact part of the virus that has changed with each variant. This is why those who are fully vaccinated are still getting COVID and actually make up the majority of those currently hospitalized with COVID-19, contrary to the data that can be found on the State Health Department website. Again, acquired immunity, natural immunity, produces stronger protection because our immune system remembers the entire virus, not just the spike protein. Additionally, the COVID vaccine has caused more deaths, 17,619, produced more permanent disability, myocarditis, miscarriage, irregular menstrual bleeding, including postmenopausal women, strokes, Bell's palsy, than all other vaccinations in history. And I see on your desks, you have a document that talks about D-dimer. Please read that. It's affected by the vaccine. I have a coworker who is a veteran who, after one Moderna shot, has suffered debilitating joint and body pain. He's told that he now has multiple sclerosis and will have permanent disability. Also, please know the FDA-approved Pfizer Comirnaty vaccine is not available in the United States. The Wyoming State Constitution gives us, we the people of Wyoming, the right to make our own healthcare decisions with or without consultation of a medical provider who may be fearful of their own job loss if they write a medical exemption or prescribe an alternative treatment. Healthcare is a right retained by the states. This right is not given to the federal government. It belongs to us. If you uphold your rights, if you uphold our rights, it's completely up to you. You are responsible for protecting our rights. I respectfully ask that you uphold your oath to protect our individual rights of medical freedom.
Thank you. Questions for Ms. Leach? Go ahead, Senator.
Thank you, Mr. Chairman. Ms. Leach, I want to make sure I understood you correctly. Did I hear your testimony right? Did you say that most people that are hospitalized today for COVID-19 are there because they had the vaccine and now they're in the hospital?
I can tell you most recently that the people that are hospitalized, more of them last week at one hospital in Cheyenne, 83% of the people hospitalized with COVID-19 were fully vaccinated.
Okay, but that's not what you said when you testified before. Thanks for the clarity. I appreciate that. Thank you.
Okay, thank you. Any other questions? Thank you, Ms. Leach. Mr. Kennedy.
Thank you, Mr. Chairman. First of all, Keith Kennedy on behalf of the Wyoming wheat growers who oppose any vaccine mandate. And you might think that many of those folks might not be affected. They're small business owners, but in point of fact, many of them serve, for example, on a county or state farm service agency committee, and they are required because they are treated as federal employees. I'll take off that wheat grower's hat and put on my personal hat now. I would posit that, and I certainly don't envy the position you're in, because at a certain point, individual rights would have to surpass business rights. And if they do not, at some point, we'll lose both. I am a federal contractor. Last year, over 50% of my income was from federal contracts. I would also like to call your attention to sleight of hand on behalf of SAM and the OMB, where early in August, all of us who are registered on SAM were granted an additional 180-day exemption to do our annual SAM report. I believe that this was foretelling that in the federal acquisition regulations, it would be required, a vaccine mandate would be required. And such is the case now. That was effective in the executive order issued on September 9th. Regarding one of the good senator's questions on the EEOC, I would also suggest that you look at some language from the US Supreme Court, which says we reject the notion that to claim protection of the free exercise clause, one must be responding to the commands of a particular religious organization. And that case is Frazee versus Illinois Department of Employment Secretary. And I can give you that, email you that quote, the citation later if you so wish. As the previous speaker mentioned, the approved vaccine is not legally, is available legally, but it is in physical fact not available. And Mr. Chairman well knows that I deal with labor labels on a regular basis. And that product is not yet available. They are all under the emergency use, experimental use authorization. And I would point out some other language from another code from many years ago, about a little over 70. Voluntary consent to medical experimentation without the intervention of any element of force, fraud, deceit, duress, or any other ulterior form of constraint or coercion is necessary to conduct an experiment. And with that, Mr. Chairman, I'd welcome any questions you might have.
Thank you, Mr. Kennedy. Any questions for Mr. Kennedy? All right, thank you very much. So let's go ahead and admit the next three witnesses out of the virtual room, please.
Mr. Chairman, I have admitted 3: Brett Glass, Mary Kate Buckley, and Nathan Anderson. I
Okay,
would make one notation that if other attendees do want to be brought in the room, they should raise their hand because otherwise I won't see them.
fair enough.
Mr. Glass, you're on.
Thank you, Mr. Chairman and members of the committee. My name is Brett Glass, and I operate 2 small businesses here in Laramie. One of them is an internet service provider, and the other is a provider of rental housing. We've looked over the 2 bills that are before you today, and our considered opinion is that there's nothing good or useful in either bill, and you should consider seriously whether you want to pass them on to the Senate at this point. The first problem we see with them is that neither one actually nullifies anything that the Fed is likely to do. They're both going to be superseded by the supremacy clause of the U.S. Constitution. Worse still, they're attempting to fight overreaching regulations with more regulations, and that's exactly the wrong thing to do because it only confuses things and makes things worse. In a sense, they're shadowboxing with regulations that haven't even been published yet. They're poorly written, and worst of all, they assume that employees do not want vaccination requirements, when in fact my employees do and insist on it, and could very well walk out if we did not have them, or if an unvaccinated person were allowed into the office. Now, employers right now are already facing shortages of workers. They're already motivated to keep their employees who can easily find their jobs due to a worker shortage. So we are already motivated to accommodate any problems that employees have with a vaccine mandate. mandate, but our state needs to encourage vaccination. Anything we do to discourage it in any way is going to do us harm. We're already contending for worst in the nation in terms of vaccination, and we're being portrayed on social media as being an ignorant backwater. We don't need our Thanksgiving COVID surge to be any worse than it's already going to be, especially since our hospitals are fuller than they ever have been. And there's no sign of the pandemic abating here in our state. Please don't fall prey to disinformation. This is a pandemic of the unvaccinated. And the vaccines, including Comirnaty, which is the same Pfizer vaccine of which I've now had 3 doses with no side effects, are available and they're safe and effective. Please see the sites of the CDC and of Johns Hopkins University for the facts instead of believing the disinformation. Now, I'd like to address some specific things in the 2 bills. HB 1001, unfortunately, has many awkward and vague provisions in it. There's an attempt to exempt small businesses, which is a good thing, but it's done very awkwardly. It defines a small business as not being an employer. And some of the provisions there are also unclear because they might sweep my small business in nonetheless. If a small business has a government contract, is it swept in regardless of size? And what kind of federal contract does that need to be? I am an internet service provider, and so I have a contract with the federal government to implement the Emergency Broadband Benefit Program, which is a program to keep people online during the pandemic. Does that force me into into regulation by the state? If I get a broadband grant through the Business Council, also to provide needed broadband in the state, does that sweep me in? And if I decide that I want to merge my business with a larger entity, even if I retain my small local office, does that sweep me in? It's unclear, and it only subject us and other businesses to uncertainty. The federal government could also yank the rug out from under the language in this bill simply by changing the size of businesses that are affected. If it changes that number 100 employees to a different number, suddenly our statute is wrong and could cause problems and confusion. Also, if we challenge the federal mandates, and this goes through the court, the court system going up level by level, we could be whipsawed back and forth between state and federal regulation. And again, this will only harm our productivity and our ability to do our work. It could also this law could also jeopardize my ability to find insurance, because if employers are forced to hire the unvaccinated, insurance companies could react by pulling out of the state. We could have, instead of having only one major insurer on the exchange right now, where you can get insurance if you're a small business, we could have 0, and this would be a terrible problem for us. The exemption requirements in HB 1001 are also very awkward. As was mentioned before, there are no clear criteria for what constitutes a submission of an exemption. There's vague language with regard to what religious grounds are, especially since the Supreme Court has ruled on this and has said that you can't get a religious exemption from many requirements. And the medical exemptions, well, we don't want them just to be granted by anybody with a medical degree, because there are examples in Florida of doctors who have set up tents in parks and offered to give anybody an exemption who comes up, regardless of whether they should have one or not. There's vague language with regard to accommodations for people who don't get their shots, and all of this would throw things into confusion for us. We really, we'd be in uncharted waters here, and it would do nothing but harm our ability to do good things for residents of the state. Now, HB 1002 has similar problems. If enacted, it could, in theory, prevent our local courthouse from being a safe place to go to, prevent City Hall from being a safe place to go to, and prevent the university from being safe. And since Laramie is, of course, dominated by the university, it's a large percentage of our population, could really endanger the entire community. UW right now, if you look at the scoreboard on their website, has about the same number of cases that it had in mid-August. And
Can
so
you-
our community
we're-
could be harmed.
We're quickly running out of time. Can you wrap up your remarks or?
Okay, I will, Mr. Chairman, thank you. I will do that. Finally, HB 1002 appropriates $250,000 for a quixotic fight against the U.S. Constitution that we won't win. Can we afford to spend that money right now? You're the Appropriations Committee, and so you need to judge whether that's a worthwhile expenditure. So in any case, I would just ask that you seriously consider whether to pass these bills on. I think it might be a great relief to the members of the legislature who've been called out for longer than they thought if you simply did not pass them on. Thank you very much.
Thank you. Who's next? Any questions for Mr. I think it's Glass. Any questions? Thank you. Next person is?
Ms. Buckley.
Mr. Chairman, members of the committee, my name is Mary Kate Buckley, and I am the president of the Jackson Hole Mountain Resort located in Teton Village, Wyoming. I have been in my role since 2018. We employ 500 plus year-round people and approximately 1,500 seasonal workers for our winter season. Tourism is Wyoming's second largest industry, and at the Jackson Hole Mountain Resort, we accommodate more than 600,000 visitor days during the winter months and roughly 150,000 visitor days during the summer months. Many of our guests are international, and as with many of our guests, they come via air service. The Jackson Hole Airport is essential to the economic vitality to our community and tourism industry in Teton and Sublette counties. I'm here today to express my concerns about HB 1001 as well as HB 1002. As an entity that falls under the definition of a federal contractor, because we hold a contract with the federal government in connection with federal property or lands and offer services to the general public. All federal contractors, regardless of size, and their subcontractors have to follow the executive order to keep their contract in good standing. The executive order is a condition of our contract and any future contracts. Following the law is very important to me as a leader. I need to create clear expectations for our team at the mountain, and we need to have an environment of certainty on how we operate our day-to-day business as a federal contractor and how we work with our subcontractors. Our federal contract status is critical to our business, and we want to do everything we can to follow federal law as well as Wyoming law as we carry out our business. After looking at the two bills before you today, it appears that there are areas of direct conflict which will put me as a federal contractor in between the federal government and the state government. HB 1001 creates wide standards called reasonable alternative measures that are not consistent with Title VII of the U.S. Civil Rights Act as related to the process for an employer to examine a religious exemption or a medical exemption under the American with Disabilities Act. This lower standard created for exemptions in HB 1001 will put me in non-compliance with the requirements of the executive order. It is my job as a leader to help create clarity for my team, and having conflicts of what we should do is a no-win situation that could have significant civil penalties for my organization as an employer if we violated, or worse, our contractor status could be in jeopardy. I am also extremely concerned about the impact this inconsistency could have on our air service to Jackson Hole Airport. Our airport is unique in that it is the only commercial airport in the United States located entirely in a national park. It is my assumption that they too will be impacted by the federal vaccine mandate as a federal contractor, and a conflict between laws could put our air service at risk, which would have a crippling effect on our tourism industry. This in turn would have a direct impact on the state's general fund. Over the years, we have worked so hard as a community and a state to help secure our air service, and we simply do not know what consequences failure to follow the executive order could have on our airport. As such, I am opposed to HB 1001, as I feel it is important for employers to be able to make operational decisions that are best for our Wyoming businesses. And the gross bill draft of HB 1001 or HB 1002 does not establish a meaningful framework for me to operate our organization in a way that does not put me at risk of impacting my status as a federal contractor. Working with the federal government is essential for us to operate the Jackson Hole Mountain Resort, as is working with the state of Wyoming. We have shown we can work with both and want to work with both, but it becomes impossible when our partners require different policies of us. I appreciate the opportunity to be with you today, and I am happy to answer any questions you may have.
Thank you, Ms. Buckley. Any questions from Ms. Buckley? Any questions from Ms. Buckley? Thank you, Ms. Buckley. Who's next?
Mr. Chairman, we have Nathan Anderson.
Nathan Anderson. Mr. Anderson, please, welcome.
Thank you, Mr. Chairman. Nathan Anderson. I represent Union Pacific Railroad. We're a federal contractor and as such must comply with President Biden's executive order. I'm going to endeavor to be brief, as a number of the issues that I want to emphasize have already been brought up in your committee. Couple of points that I think are relevant. The executive order creates effectively three different categories of employers: those who are federal contractors, regardless of size, and those who are above 100 employees who are not federal contractors, and those who are below 100 employees who are not federal contractors. That guidance that we expect to see from OSHA will address those who are not contractors and have more than 100 employees. The guidance provided by the White House makes it clear that any contractor, regardless of size, cannot defer to those OSHA standards in lieu of the contractor standard. That's going to create conflicts between House Bill 1001 and the federal executive order, which puts employees and employers at odds with the federal versus the state order or law. To avoid that conflict, and to avoid unnecessary, expensive, and time-consuming federal preemption litigation, lawsuits, and maybe at a finer point, confusion among our 800 plus Wyoming employees, we would like to propose an amendment to House Bill 1001, and you've each received that via email. Simply put, on page 10 of the amendment in section 5, add line 22, this act shall not apply to federal contractors as designated in Executive Order 14042. Mr. Chairman and members of the committee, our supply chain in the nation has been greatly impacted. This amendment helps to further move us toward both a safe operating environment and a recovery of our supply chain system. We urge you to include this amendment in the bill, and I will stand for any questions you have.
Thank you. Thank you, Mr. Anderson. Any questions for Mr. Anderson? Thank you, Mr. Anderson. We are going to take a 10-minute break so everybody can stretch your legs and maybe if nature's calling, take care of that. And then when we come back, we would be pleased to hear from Eric Boley, Cindy Delancey, Jasmine Hall, Katie Legursky, and Jonathan Downing when we come back, please. Let's go ahead and bring the committee meeting back to order. And so we've got, I think up here, we've got Eric Boley, Cindy Delancey, and Katie Legursky are up here. And thank you for some of you notifying me that you are on the list, but you really don't have anything to add. I should still have anything to say, but nothing to add. So we're still working our way through the list. So with that, we'll go ahead and we'll start with Mr. Delancey, if you want to go ahead.
Thank you, Mr. Chairman, members of the committee. My
And
name is
before
Cindy.
you do start, before I start your timer, I understand that Chris Brown is here, and he wanted to defer some time to you, and along with Jonathan Downing also wanted to defer some time to you. And we also, Katie Legursky wanted to defer some time to you. So you have, you do have quite a bit of time to go ahead and address that. So why don't we take Chris first, because I think he's really short, and then we'll go to you, who I think will be a little bit longer.
Thank you very much. Good morning, Mr. Chairman, members of the committee. Chris Brown, representing the Wyoming Lodging and Restaurant Association and the Wyoming Travel Industry Coalition. Mr. Chairman, as I have called around to business leaders across the state, there has been a wide range of thoughts on this subject matter. And our concerns boil down to two. Ms. Buckley did an excellent job of illustrating the concerns we have with how this might potentially affect air service to Wyoming. Mr. Chairman, the contracts and the relationships with Wyoming's communities and the limited air service that we receive have been fought for long and are well established. But it's important to understand that with air service, there is significantly more demand than there is supply and resource. And so we are concerned that if this state law was passed, it could potentially create uncertainty for air service to the state, and whether actual or perceived could potentially cause the air service companies coming to Wyoming to seek more lucrative markets. The second concern, Mr. Chairman, that I hear as I call around the state is, of course, the potential for litigation and setting up, do we follow state or do we follow federal law? Mr. Chairman, as someone that has been engaged and monitoring this discussion from the moment you all gavelled in last week, it's challenging for me at this pace to get my arms around this legislation and understand all the nuance that could potentially impact the hospitality and tourism industry. For business leaders across the state that are facing unprecedented challenges with workforce, with supply chain, with the fast pace that we've worked with this legislation, there's no way that they're going to be able to have their arms around this in a quick enough time. We all know that COVID in general has caused, passionate feelings and significant passions on both sides, on any side of this discussion. And it's not hard to think, Mr. Chairman, that if there is a state law and a federal law in play, that there could be the potential for litigation to come up. And as business owners across the state are dealing with the already existing unprecedented challenges with COVID, the potential for litigation is not another challenge that, it's something that's giving them pause and giving them concern, Mr. Chairman. So again, I told you my comments would be brief, and I'd defer to Ms. Delancey for more nuance and detail.
All right, thank you very much. Mr. Delancey.
Thank you, Mr. Chairman, members of the committee. My name is Cindy Delancey. I'm the president of the Wyoming Business Alliance, and I appear before you today on behalf of our over 400 members across the state in every industry, the extraction industry, the hospitality industry, the agricultural industry, the construction industry, the digital technology industry. The point of me sharing that with you is that we are a very broad and far encompassing group of business owners and leaders across our state. And there's not been one of our members that has asked for support for either one of House Bill 1001 or 1002. So I will just start my comments by saying that the Business Alliance and its members stand in strong opposition to House Bill 101 and 1002. These bill drafts are bad for business, period. And I'll take 1001 first and then offer some comments on 1002. Let's be clear that business never welcomes mandates at any level. And to respond to a federal mandate with a state mandate certainly does not make good policy and has not been the past practice of this body. We've all been taught in kindergarten that two wrongs don't make a right, and House Bill 1001 and House Bill 1002 does not make this situation right. It complicates an already extremely complicated situation. I'm going to spend some of my time walking you through some of the pages of EEOC guidance on religious exemptions, medical exemptions. I've provided this information to several of you already, and just want to kind of drill down a little bit more on some of the comments that have already been stated. This bill draft sets up a supremacy clause pursuant to Article 7, Section 2, showdown between the state and the federal government, with businesses big and small caught in the middle. This is just not a position that 90% of business done in Wyoming is done, actually 98, 95, 96% of business done in Wyoming is done by small businesses. I just ask you to reflect on the conversations that we've all had together this morning. We spent hours now going over, what does this mean? How does this work? What's the implication of this? We simply don't know. And I can assure you, if we in this wonderful institution are asking these difficult questions, trying to get at the heart of the matter, I can assure you a small business owner in rural Wyoming that doesn't have a team of lawyers or resources at their disposal to try to figure some of this out, the consequence to them is far and wide. One of the former speakers talked about chaos. I think this is chaos and confusion with severe consequence for employers. We have to keep mindful that the role of this body is to create good policy. Business friendly environment is something that Wyoming has prided itself on for decades and generations, and turning well-established principles of law and moving away from the free market economy that we pride ourselves in Wyoming certainly doesn't feel very business friendly at the moment. As I said, specifically, both bill drafts, but we'll start with 101, fall short of the standards set in Executive Order 14042. The question before us today is not like whether or not anybody likes Executive Order 14042. It's how 14042 interfaces with the efforts of the legislation before us and how to reconcile it. That executive order that I have here, I've provided this to all of you, spent a lot of time with it, really sets out the standards as far as that the executive order sets the floor, meaning that any kind of state legislation cannot dip down below what is set in the executive order. Anything that falls short of that, again, sets up that supremacy clause showdown that I was mentioning to you, and will likely be construed by the courts in any kind of challenge as the violators being subject to penalty, whether the penalty is having federal contractors rights and to their contracts that they've entered into changed or modified or even worse, rescinded. Another topic that I haven't heard much about that I'd like to remind everybody of as well today too is that in Wyoming we have the privilege, not the right, of enforcing our own OSHA standards and stepping into the shoes of the federal government here to regulate our businesses. If we fail to follow the executive order, the consequence of losing that OSHA primacy is grave. And it's something that if revoked, as other states are already starting that process with federal regulators, Arizona, Utah, South Carolina, have already had that conversation started with them. And I don't foresee that that's something, again, that any Wyoming business would support at this time. So walking you through House Bill 101, the first, basically what we have here is a situation where the five elements for an employer to attempt to impose a vaccination as a condition of employment are basically flawed in the sense that right now, the way that things are written, anybody can get an exemption for anything under one of these different categories. And specifically, when you look at page 4, line 2, After we talk through the medical exemption for exemptions for medical grounds that are not signed or completed by a licensed physician, advanced practice nurse, or physician assistant, an employer may grant the exemption. That is not consistent with the guidance and direction given to us from the EEOC and administered through the Wyoming statutes of the Unfair Employment Practice Act. And I will explain my comments in a little bit greater detail. We have under the process for those of you that, hopefully never have to go through an unfair employment process with an employee. Basically, the employee alleges the discriminatory behavior of the employer. It is then a claim is filed, a claim is investigated, it goes before an administrative hearing officer. The remedy to the employee, as we've already discussed, is a little bit farther reaching than what was originally discussed this morning, as far as back wages, front wages, attorney's fees, all kinds of damages related to severe emotional distress. The civil penalties go on and on and on, as they should. We do, the business leaders don't want a climate where that they're able to engage in discriminatory practices against their employees. So, we stand in strong opposition. We do not feel this bill is ready to go forward, but if there was some necessity for amendment, I would think striking that basic open-ended, anybody, the employer can grant anything if somebody talks about a medical exemption, be the first thing to go. Moving on next to the language that's in place on line 16 of page 4 that says that an employer shall grant, this isn't a may, this is a shall. Again, preempts, Wyoming is trying to get in front of our federal partners as far as preemption on well-established standards, case law, precedent, predictability that business has relied upon for since the beginning of time as the cases have evolved to try to give guidance. I'm going to read to you just a little bit out of the EEOC guidance that's available online for all of you. And it just says the EEOC enforces Title VII of the Civil Rights Act of 1964, which prohibits employment discrimination based upon religion. This includes a right for job applicants and employees to request an exemption called a religious or reliable or reasonable accommodation from an employer requirement that conflicts with their sincerely held religious beliefs, practices, or observances. If an employer shows that it cannot reasonably accommodate an employee's religious beliefs, practices, or observances without undue hardship on its operations, the employer is not required to grant the accommodation. As we say here, why I advocate for following our guidance in federal law is because it's a balance. It's a balance between that religious claim by the employee, but also it's a balance of how the employer conducts their day-to-day operations. So in this document, there's a variety of different scenarios to give employers guidance on. The first one is L.1.1. Do employees who have a religious objection to receiving a COVID-19 vaccination need to tell their employer? If so, is there a specific language that must be used under Title VII? Employees must tell their employer if they are requesting an exemption to a COVID-19 vaccination requirement because of a conflict between the requirement and their sincerely held religious beliefs, practices, or observances. Under Title VII, this is called a request for religious accommodation or a reasonable accommodation. When making the request, employees do not need to use any magic words such as religious accommodation or Title VII. However, they need to notify the employer there's a conflict between their sincerely held religious beliefs and the employer's COVID-19 vaccination requirement. Same principles apply if employees have a religious conflict with getting a particular vaccine and wish to wait until an alternative version or specific brand of COVID-19 vaccine is available. As a best practice, an employer should provide employees and applicants with information about who to contact, the procedures to use to request a religious accommodation. We've heard from our employers that they have these kinds of procedures in place. And that's where, again, business is best situated to make those operational decisions as far as what works for them, as opposed to the Wyoming legislature stepping into the shoes of our business leaders telling us what's best. The guidance goes on to say, and I won't read all of this to you, but one thing that I find point why I think the language in that we see on page 4 again leads to this chaos with severe consequences is L.2. Does an employer have to accept an employee's assertion of religious objection to a COVID-19 vaccination at face value? May the employer ask for additional information? Generally, under Title VII, employers should assume that a request for religious accommodation is based on a sincerely held religious belief. However, an employer has an objective basis for questioning either the religious nature or the sincerity of the particular belief, the employer would be justified in making a limited factual inquiry and seeking additional supporting information. An employee who fails to cooperate with an employee's reasonable request for verification of the sincerity of the religious nature of a professional belief risks losing any subsequent claim that the employer improperly denied an accommodation. It goes on to talk about religion, but the takeaway from me sharing with you is that Title VII does not protect social, political, or economic views or personal preferences. Thus, objection to COVID-19 vaccination that are based on social, political, or personal preferences or non-religious concerns about the possible effects of the vaccine do not qualify as religious beliefs under Title VII. Sincerity of an employee's stated religious belief also is not usually in dispute. The employee's sincerity in holding a religious belief is largely a matter of individual credibility. And then it outlists the factors that the employer should list to as far as looking at that credibility. The burden for religious belief exemption is lower than the assertion of a medical exemption, which I'll speak to here in a moment. But the way that our draft legislation reflects that an employer shall grant an exemption for religious grounds doesn't take into consideration any of those factors or balancing as far as that accepted practice that courts have litigated for a very, very long time, and just again throws us in that gray area of uncertainty and conflict. To have a medical exemption as we move on, we really need something beyond more than just this open-ended catch-all for anybody to apply that doesn't want to, for whatever reason, have follow their employer's precondition of a vaccine, which again, I come back to that the employer is best situated to make those operational decisions as opposed to legislation from the legislature. But how it works generally is that to be granted a medical exemption, you have to have an underlying condition, some kind of medically recognized condition that you would need your doctor to affirmatively state that taking the vaccine could have a contraindication or exacerbate your underlying medical condition. And that's really, again, that's all the way that OSHA approaches that. And then you get into this discussion of reasonable accommodation. We've discussed, and I won't, reiterate the need that the language of reasonable alternative measure does not comport with the language used by the courts or given by the EEOC guidance. So as we move forward, it's important that we stay consistent in our analysis of, what are discriminatory practices, because the employers that I know don't want to do any of this. They want to follow the law. And right now we don't even know what that is. And by piling on, it just makes it even worse for businesses to try to do the right thing. We're not rule violators. We're rule followers. We want to do the best for our people. Our people are our best assets. Right now, we need our people more than ever, and finding people has been incredibly difficult. But we also must make sure that we don't lose our livelihood at the same time. And as Wyoming is, 50% plus federally, occupied with our different subsurface and surface rights, the bottom line is the federal government is our partner, and many of our contracts relate to that federal piece. It impacts everything from ski resorts, airlines, universities, all of the above. And what this legislation is essentially doing by creating a protected class of a new discriminatory category, which I will reference that, the Senate has voted down 1003 that had a protected class piece in it as well, is that it pits employees versus employers and invites litigation. It's just not something that the business community can support, especially, as we round the corner of 2 years of dealing with this public health emergency. We don't want to be encouraging and inviting litigation from our employees and expanding that realm of how we are able to work together on the road to recovery. Wyoming, again, as I said, has prided itself where people are watching what we're doing. And by creating confusing standards, adding additional protected classes, encouraging litigation, setting up fines and penalties through the Unfair Employment Practice Act, it just doesn't feel very business friendly. We need to have a climate that promotes certainty, stability, and putting our federal contractors at risk, as well as our OSHA primacy, is bad for business. The other discussion that I wanted to have before I move on to some comments related to 1002 is this notion of, we've already talked a little bit about the supremacy clause. I know your capable LSO staff has given some guidance on the role of what essentially is the law of the land, which again is recognized by the Wyoming Constitution. But this notion that OSHA is acting outside of its scope of authority under some kind of 10th Amendment challenge, just want to also kind of walk through some of that as well while we have a moment today. Federal OSHA adopts standards that requires if OSHA adopts a standard that requires employers to mandate vaccinations, Wyoming OSHA will be required to implement a standard that is at least as effective in providing safe and healthful employment and demonstrate to federal OSHA that it has done so. Obviously, Wyoming OSHA cannot act in a way that is contrary to the requirements of federal OSHA standards. The 10th Amendment does not contradict or limits OSHA's power to create and enforce workplace safety standards and requires state with plans to do so also. The Supreme Court has held that if a power is delegated to Congress in the Constitution, the 10th Amendment expressly disclaims any reservation of that power to the states. When Congress created the Occupational Safety and Health Act, it did so through the exercise of its congressional powers to regulate interstate commerce, to provide for the general welfare, for the stated purpose to assure, so far as possible, every working man and woman in the nation safe and healthful working conditions, and to preserve our human resources. No court has held that OSHA exceeded its constitutional power when it passed the act, and a 10th Amendment challenge to OSHA's authority to adopt a vaccine mandate would be unprecedented. So again, members of the committee, these are all very well-established principles of law that I honestly feel that amending this bill to try to bring it into conformity with these well-established practices of law would reach far beyond the scope of what we're trying to do as far as with this draft. Essentially, every page would need to be amended, which signals to me that maybe this isn't quite the time to be working on passing legislation that could be so detrimental to Wyoming's businesses. I can specifically walk through more of the amendments, but I would like to reserve the rest of my time just to make a few comments related to 1002. I too share the same concern related to this definition on page 7, which again, this discussion of subpart B, which would lose that federal funding. That would become an analysis of what, who would lose when, under what circumstances, what would it take for compliance. That really feels a little bit beyond, something that could be workable. It doesn't state who that analysis belongs to. And again, moving forward to page 8, line 11, where it talks about notwithstanding cites the statutory provisions, no public entity shall require a person to receive or show proof of vaccination for a person to receive or qualify for any public benefit to which that person is entitled. I want to bring this back to, again, our air service in Wyoming, which is crucial to the success of business in Wyoming. Air carriers are not really going to be all that concerned with, what Wyoming does on this. They are international corporate organizations that have their own, rules and procedures that they need to follow, specifically as federal contractors. Our air service is so fragile as it is. And by layering on, putting, again, that conflict, because I do think, a public benefit is transportation, that this could very well be wrapped up in that whole conundrum of how do we reconcile what Wyoming's law is in respect to federal contract provisions under the executive order. Now, you might ask, why does business care? What happens in 102 related to our public entities? Our public entities have always been our partners. These are, K-12 education, community colleges, hospitals, which I know if we are able to get that sorted out on the definition, or the intent is to exempt them out, air service, all of those things that makes business work in Wyoming is the public entity piece. We do our best work together, and by passing legislation like this certainly feels, to me at least on its face, like it's tearing us apart, pitting employers versus employees. And ultimately, at the end of the day, it was kind of telling. I walked up this morning and saw our beautiful bronze with some snow on it, and in the cold air this morning. And I thought, passing these legislations, all we're really going to be doing is having a chilling effect on job creation. If these measures move forward, why would anybody want to hire an employee in the state of Wyoming when we would be fraught with question after question? And not just question that we're not smart people and can figure it out, but I respectfully disagree with Mr. Wolf that if an employer finds himself in a discriminatory challenge, that is just going to be quite as cut and dry as the testimony was this morning, that the legislation will be our guide. That's not a situation that anyone that's in business in Wyoming wants to find themselves. And I really feel that this language just is continuing to create this confusion and lack of clarity and certainty that businesses need under the circumstance. This body has spent millions of dollars promoting economic diversification, and having these open questions really could lend itself to why somebody would want to come do business in Wyoming without the lack of clarity and procedure that we need and have come to rely upon for many, many years. So with that, Mr. Chairman, I think I've covered everything, and do appreciate your consideration as far as maybe taking a pass on what's before you today and looking for alternative solutions. Thank you.
Mr. Chairman. Yeah, Mr. Chairman, I'm really concerned with the obfuscation of the terminology that's been thrown out here, and it's very loose terminology. And so my first question to Ms. Delancey who is a background in law, has practice in the state of Wyoming, is I'm really concerned based on some of your testimony that you have now equated an executive order to have the full force and law under the Constitution of the United States. And so I did a little research on this subject this morning. So I'd like to see where you weigh in on this, but I pulled up the Yale Law School review of executive orders on there. And I just want to read a little bit from the abstract on this. It says this study reveals that although the executive order is a powerful tool of the presidency, courts have not tended to acknowledge the executive order as a form of lawmaking. So if we take the natural extension of that, and the fact that the Supreme Court's on numerous occasions have struck down executive orders for the very reason that they were unconstitutional, and the fact that they weren't laws, the supremacy clause then doesn't come into play. Because as you indicate, under the Constitution, the delegated authority to Congress under the supremacy clause is to write laws. And so when we conflate the issue of an executive order that's not clearly, and it may have the weight of law, but is not a law. Am I missing something here? Or are we now misconstruing what the legal terminology between a law is and what an executive order is? Because they've been used synonymously over and over and over this morning. And I'm quite frankly, given your legal background, I'm curious as to why that distinction that they're the same.
Thank you, Mr. Chairman. Perhaps I was unclear with you, but I was referring to the OSHA regulations being exercised under the authority that Congress has been given. The question, as you know, related to the 10th Amendment discussion that we had earlier this morning, Mr. Chairman and Senator Hicks. So if there was some misunderstanding or misstatement, I correct that by saying that what I'm referring to is the regulations passed by OSHA, even though they are regulatory in nature, are given because they are not acting outside of the congressional authority of which the agency was delegated to by Congress, that even though it's a regulatory scheme, falls within that protected purview of law. The question as to whether or not executive orders fall within the rise to the level that you indicate, that again is a question for the courts. I know that the executive branch is aggressively pursuing those questions right now. The business community stands in full support of those attempts to find clarity and answers through the courts on that topic. But I just wanted to clarify that I was referring to the OSHA standards that are being promulgated through the agency. And I have the citation of the cases that I'd be happy to give that to you as well.
All right, thank you for that clarification, Mr. Chairman.
So while we're on that subject, Mr. Lancy, so when the other side of this coin has been the imposition of I think it's Executive Order 10149 or whatever that is with respect to the federal acquisition regulations and procurement statutes I think it's in the document provided, which I found earlier, is the White House guidance, and they claim that they have the authority under Title 40, 102, 104. I can't remember the exact citation. That the president apparently has delegated that authority. But I'm just curious if you have any comment or idea with respect to that's the OSHA's one thing. MSHA will do whatever MSHA is going to do, but there's obviously a blanket order coming down through the federal acquisition regulations and procurement statutes for anybody who's involved, and that's if you lease a public contract, you're providing goods or services, anything that can be deemed as a subcontract to an ultimately prime contractor to the federal government. So I mean, you're a concessionaire in park, and you're providing water from a spring near Worland, Wyoming. And if you want your water to be offered in that concessionaire, or you're providing maintenance services or whatever, those by implication, those are going to be extended to those private employers. So anyway, as we get back to all that's coming down to the procurement statute. So I was just wondering which seems to be the president is claiming he has executive authority delegated to him under that statute. I don't, and I just wondered if you had a comment.
Thank you, Mr. Chairman. I do, and again, these, as I said to Senator Hicks, Mr. Chairman, these are open questions that are subject to debate. But when you look on page 1 of the executive order, the first paragraph states the authority for enactment, including the Federal Property Administrative Services Act, 40 U.S.C. 101 et sec, and Section 301 of Title III of United States Code. And in order to promote economy, efficiency, and procurement by contracting with sources that provide adequate COVID-19 safeguards for the workplace. And then we go into the order. Section 5, subpart A specifically states that the order shall apply to any new contract like instrument, new solicitation for a contract or contract like instrument, extension, renewal, existing contract like instrument, or exercise of an option on an existing contract or contract like instrument, if the procurement contract or contract like instrument for services, construction, a leasehold interest in real property. So those that have federal leases are subject to all this. If contract or contract like instrument for services covered by the Service Contract Act, 41 U.S.C. 6701. It's the contract like instrument concessions, including concessions contracted by Department of Labor Regulations, 29 CFR 4.133B, is a contract or contract like instrument entered into with the federal government in connection with federal property or lands and related to offering services for federal employees, their dependent. And this is really the one that's the kicker for me. or the general public. That's what makes this extremely broad-based in its application. And I've heard some testimony over the past week, Mr. Chairman, that this really isn't here yet. It's not affecting us yet. This is. And when you hear to some of our federal contractors that are having to submit certification that they have mandates in place to be able to bid or engage in discussions about contract procurement, this is very real and upon us. And that's why, you know, it's so crucial that we kind of get some resolution on this for the business community, because all those livelihoods down to the person cleaning the restroom in federal, you know, impacted facilities such as an airport are impacted by how they move forward as far as being able to comply with the order. So there's a whole bundle of citations there, Mr. Chairman, that I'm happy to share again with Senator Hicks. But you know, as far as whether or not, you know, where the courts come down on the executive authority on order for today and impacting those people that are trying to secure contracts so they can make payroll for their employees is really what gives me great concern with the ways that 101, House Bill 1001 and House Bill 1002 are drafted.
Thank
you. Mr. Chairman.
Go ahead, Senator Hicks.
So we get back to the OSHA regulations promulgated under congressional act. And so I'm reading from New York versus the United States, 1992 Supreme Court. Sandra Day O'Connor wrote the majority opinion. It says, in initial manner, Congress may not commandeer the legislative process of states by directly compelling them to enact and enforce a federal regulatory program, AKA OSHA, MSHA, and all that stuff. So it gets to one of your other comments earlier. It says the Wyoming legislature stepping in to tell business what is best. But it seems to me like the directive, that is part of our job in the context of some of the Supreme Court rulings. So you're right. I would completely concur that there's this tension. And our form of government was directly set up to provide that form of tension. But specifically to this, where we have Supreme Court rulings saying that you can't come in and compel our state agencies to enforce federal regulatory requirements. Are we not within our powers of the state of Wyoming to push back just a little bit? Or what is the proper role? If it's not for this, what is it? So I'm assuming based on your testimony, second question, Mr. Chairman, that you're opposed to House Bill 1002. So I'm assuming that's the entire House bill that includes the appropriations to the Attorney General's office to litigate the federal government, whether it's the supremacy clause, the legality of executive orders, or the legality under Supreme Court rules that says they can't come in and commandeer the legislative process or dictate or mandate how we can write the rules of the state of Wyoming. So are you opposed to House Bill 002 as you previously stated? And does that include the appropriations for the Attorney General's office?
Those two questions.
That's
for now.
Yeah, for now.
Okay, go ahead.
Thank you, Mr. Chairman. I kind of forget the question number one there, Mr. Chairman and Senator Hicks, but there has been a long line of cases, most recently the citation of Merck Sharp and Dome Corp v. Albrecht 139 Supreme Court 1668 as recently decided as 2019. So I'd be happy to share with you my research memo on this, Senator Hicks and Mr. Chairman, and share with the committee as far as going to exactly what you're saying. What I am suggesting to you is that the business community will never ask for additional regulation from government at any level. We feel as a business community that we are best situated to make the operational decisions on behalf of what's best for running our businesses and our employees. We operate in a free market system where choices really are the check on the process here. And any additional overlay from government at any level is certainly not welcomed. And that's really the basis of my testimony. As opposed to being in opposition to 1002, we do stand in opposition to 1002 for the reasons stated in my testimony. The fact that this body makes a policy choice whether to put in appropriation for the executive branch to pursue litigation is purely a policy choice. And I think that, you know, people want that clarity. And if going to, you know, the courts are the remedy in this situation. as opposed to trying to legislate a way around the supremacy clause. So absolutely, that component, maybe we should amend it to a different sum. But the business community also, as we discussed earlier, is the right party to have standing to sue as these conversations move forward. And I anticipate, if there is harm and damage to businesses, that they will exercise their remedy to the courts too. So for those reasons, yes, we are opposed to House Bill 1002, not purely, because of the appropriations piece, but there's ways to also engage in litigation to give the governor's office, or I'm sorry, the executive branch resources to have access to the courts in other vehicles besides this piece of legislation.
Mr. Chairman, thank you. So just two follow-up questions based on that response so if we're going to try to legislate around the supremacy clause, I'm assuming your opposition to that not only is at the state level, but at the federal level also, which would lead me to my real question is what exactly is your organization, if in fact you're opposed to legislating around the supremacy clause, or in this case, the federal government using executive orders to skirt around the supremacy clause, what exactly is the Business Council doing at the federal level to prevent this activity?
Go ahead.
Mr. Chairman, thank you. I believe Senator Hicks means Business Alliance as opposed to the Business Council, which is your agency.
Mr. Chairman, stand corrected.
I just want to make sure that I'm not speaking on behalf of anybody with that agency, Mr. Chairman and Senator Hicks, but we're constantly working on overreach at every level of government all the time. We have a wonderful delegation that is very pro-business, fighting back daily too on regulations that impact the business community, to have a climate that, we continue to be the envy of all states, and not all states, but there's many states. And by taking steps like this, our position seeks to kind of unwind some of that appeal that Wyoming has for people that like to come in an environment where the free market really, is promoted as opposed to being very prescriptive through legislation. So we're constantly working, chiming in, filing comments, being part of proceedings at every level to make sure that the business environment in Wyoming is the best it can be.
Any other questions for Mr. Lancey? All right, thank you, Ms. Lancey. Appreciate your time today.
Thank you, Mr. Chairman, and thank you, members of the committee. There's not many states where, we're able to have this kind of discussion with our elected officials, and I truly, truly appreciate that opportunity.
Okay, let's, if we can have him come down in front, let's hear, I see Mr. Boley. Are you going to testify, Mr. Boley, if you'll come down? I think we took care of Ms. Legursky, I think Dr. Paulus and Mr. Passano, if you guys want to come down, and Sheila Bush, if you want to come up. I think Erin told me that she was deferred time to Mr. Lancey, and then as soon as do these, then we'll do. In fact, why don't we let's take two out of the virtual one right now.
Mr. Chairman, we have Holly Rohrbach online.
Okay.
And I believe she's ready to testify.
Okay, Ms. Rohrbach, are you there?
Hi, Mr. Chairman. Can you hear me okay?
Yes, we can. Please proceed.
Well, my name is Holly Rohrbach, and I am speaking on behalf of the Wyoming Medical Freedom Advocates Group. We are a group of over 850 individuals here in the state of Wyoming, many of whom are healthcare workers. And so I just wanted to come before you guys and provide a little bit of information in our position on this going forward. So first off, I'd like to say we are in favor of both House Bill 1001 and House Bill 1002. I would like to start by arguing that today's testimonies have biasly represented the state's executives and not the people of the state of Wyoming. I think we're getting a little bit carried away on the dollar and cents and political moves and businesses trying to look out for themselves and prevent any inconvenience or accountability rather than focusing on the science and the freedom of the people. And so just due to that, I would like to start by clarifying a couple of just concepts to just bring a little bit of refresh to the conversation. So the first would be defining emergency use. With emergency use agents, citizens are legally granted the option to accept or refuse those. The FDA version, there is one version that is FDA approved, yet it is not available to the public. So I'm a little bit confused how we're mandating something that legally is to be provided an option to accept or refuse. And then additionally, how these businesses are able to say, for example, one in the center of the state that November 1st, this is going into effect, when yet there is indeed not an FDA approved version available to the people. And so with that, I believe it should be a choice of the person going forward. With that, I at the very beginning, Mr. Chairman, you said you'd like to spare the science and data, so I will spare us of that and just go off a couple of just concepts then. But we do know that whatever percentages we want to argue and throw around, we do know that it does not stop the spread. We know there are plenty of vaccinated individuals who have contracted COVID, spread COVID, and we do know that they are shedding it at a higher rate. And so with that, it is clear that it doesn't. Therefore, many of these proceedings against the unvaccinated are discriminatory. So I know that that's a word that many of our business owners are cowering at the accountability of that, but it is discrimination. If you're able to spread and contract the virus vaccinated, then, and you're able to spread and contract the virus unvaccinated, then what makes it not discriminatory? And so with that, I'd like to go into the concept of choice. Many of the businesses, I've heard a lot of thrown around about free market system where choices are that of our legislative process. What makes the free market flourish is the freedom of choice, all of these things in regard to businesses, but we're not carrying that over to the freedoms of the people. And so if we're going to give businesses these choices and say they have this choice, free market choice, this is what makes businesses, this is what makes people who comprise those businesses as well. And so with that, I'd like to share a couple personal testimonies. So I represent a large group of women aged 25 to 35. And in this group, I have a couple of my dear friends who are experiencing high levels of abnormal bleeding. I also have two friends with infants who are in vegetative states and unable to move their arms and legs, one of whom their infant was flown to Lansing, which is the center that takes care of these. And they say within the last month, they've had 16 cases of this. So when we have people like Mr. Glass throwing around that he has had his third dose and has been seen to be perfectly safe, I'm not sure how we're claiming that this is perfectly safe when there are a number of people having extremely adverse reactions to it, including my own friends and our infants in vegetative states. I also have a private funded study from a scientist friend in my group they are finding an 82% pregnancy loss amongst vaccinated women in my age demographic. I am not sure how this is being said as it is safe when we hardly even have a year that we've been able to study this, which is not nearly the length of gestation for a human. Furthermore, I would like to touch a little bit on exemptions. I do not understand, and excuse me, this may be my error, but I do not understand how there's so much confusion among such a highly educated group of individuals. So I'd like to clear that up. A religious exemption is an exemption granted to somebody who holds a sincerely held belief against this. This is the United States of America. We have the right to religious freedoms. And I do not understand how we are getting so carried away on making people define and prove and this and that and this and that. I mean, we have very conservative cities with mosques being built in the centers because we stand for religious freedom in this country. So how is it that they're having to prove on the cross their religious convictions and sincerely held beliefs? A religious exemption is a religious exemption. Some of our members are federal employees. They check a box that says they're exempt. We now all of a sudden have pages that our healthcare employer in the middle of the state is requiring to prove that we're religiously exempt. Secondly, a medical exemption. This is also not confusing. What defines a medical exemption is a licensed physician has granted a medical exemption. They're the ones with the personal history, the testimony, all of the things to do with that patient, their background, their medications, all of these things. Why is one physician with X amount of experience versus another licensed physician with X amount of experience? How is one more qualified than the other to grant a medical exemption on a patient whom they are seeing just because they're vaccinated? So one physician.
Ms. Forbrock, you've got about 30, 45 seconds to wrap this up.
Right.
Just giving you a
Thank
warning.
you, Mr. Chairman. My bottom line is I don't believe there should be any mandate allowed. Neither does my group of 1,000 healthcare workers that I represent, especially for a vaccine that's not proven safe and is not proven effective, and there is a medicinal cure. But if you must, I do believe employers shall absolutely grant exceptions, both for medical and sincerely held beliefs. Thank you.
Okay, thank you. Are there questions for Ms. Rohrbach? Thank you for your time today, Ms. Rohrbach. Is there anyone else? Anyone other questions? Thank you, Ms. Rohrbach. Go ahead and admit our next person.
Mr. Chairman, I'm going to probably mispronounce this last name. It's Iris Timersma.
If you say, I don't know what you just said, but go ahead and admit her. Hopefully her name will show up here on the screen. Hello, are you there?
Sorry, Mr. Chairman.
It's Iris, is it Tiersma?
It's Timersma.
Tiersma, all right. Hello, welcome, Ms.
I
Tiersma.
am. Can you see me and hear me okay?
I think you have a little feedback going in the background, I think, but go ahead and we'll see how it goes.
I'm sorry, I have an echo happening on my end. I'm not sure why. Okay, so I am here, I'm a nurse. Can you close
If you have YouTube on, I think you need to mute.
If you do, are you on the YouTube feed or are you admitted into do you have the YouTube feed on? A lot of times that causes feedback.
Hang on, I'm trying to figure out. Yeah, let me see if I can close the YouTube feedback. I don't know. How do you? Let me see if I can close the YouTube feedback. Do you have it open somewhere else?
Okay, you work on that. We'll come back.
I'm sorry, Mr. Chairman, if I could get my technical problem figured out and then maybe.
Okay, you'll take a minute and see if you can, and we'll see if we'll come back to you in just a minute. Let's go to the next person.
I have Zachary Miller.
Okay, Mr. Miller, Zachary Miller, are you there? Mr. Miller, are you there? Mr. Miller, are you there?
I am. Thank you.
Thank you, Mr. Miller. Welcome.
Thank you so much for the opportunity to speak to you today. My name is Zachary Miller. I represent Banner Health and our Torrington Community Hospital in Torrington, Wyoming. Related to this bill today, I will be very brief. Most of my comments have been shared by others today. However, as a first generation Wyoming resident myself, however, having family roots here, I think it's important to speak on this bill today. Related to House Bill 1001, the concern that I would have as also a small business owner in the community, a family who owns a small business, is really the concern of the over broad definition of the exemptions that are present within the bill. It makes it very difficult for an employer, whether here in my role as a Banner Health CEO or in my role as a private employer, to determine which of the exemptions, how to grant those, because they become overly broad. So that is a large concern that I would have. Further, the bill goes on to start to determine then how we test, and that I believe it would be a concern as well as we move forward with this. And then further in the bill, it defines, in that statement later in the bill, there is language around which type of test we need to offer versus nasopharyngeal versus other testing mechanisms. I believe that places an undue burden on the business to determine which test that they should be offering in their place of business. So overall, just have multiple concerns about the bill itself, but also would like to just note as we move forward throughout this that I believe as we, Banner, have started our vaccine policies within the state, that as we had a lot of guidance from our system partners. We relied on a current guidance from federal agencies as we went throughout that process, as well as consulted state law as that process for our vaccine program was implemented. Further, throughout the pandemic, I believe it's also important just to note that although there has been comments, I believe, made throughout the legislative session regarding banner health in general, or the opportunity for systems to take part in the state, I believe that our system has done a fantastic job of ensuring that we're adequately supplied, both with medications, supplies, et cetera, to help and protocol to navigate care of our patients throughout the pandemic. And so with that, I would stand for question.
Thank you, Mr. Miller. Appreciate your time today. Any questions for Mr. Miller? Any questions for Mr. Miller? There being none, thank you, Mr. Miller. Let's go back to Ms. Tiersma. I said it right. Ms. Tiersma, did you get your did you get your technical issue corrected?
I believe so, Mr. Chairman. Thank you
That's
for
much
giving
better.
me a
Thank you.
chance.
Thank you. Go ahead.
Okay, so Mr. Chairman and members of the board, I am a nurse. I have been a nurse for 6 years. I actually recently was forced out of my position where I loved my job, but there was a mandate. And so I was forced to find employment elsewhere or decide, whether I wanted to risk that with my health. I have natural immunity, and that's not something that the hospital is currently allowing as an exemption. I just want to kind of roll back a little bit and talk as a nurse about this specific topic and how important ethics are when you're discussing a medical injection. Mandating anything medical treatment is unethical. That is something that all physicians and all nurses go through training. And I know myself, as a bachelor's degree, I had an entire class on ethics. As a nurse, I find it's my own personal duty to advocate for patients and their rights. And there's a lot of discussion about, this is going to put businesses in a hard position. And I can sympathize with that. However, we don't want the federal government telling businesses what to do. We don't want the legislature telling businesses what to do. And yet here we have businesses mandating and telling individuals what they have to do with their own health care. With a inoculation that is very new, there is not enough data, there's not enough long-term research to really guarantee that it is safe and effective for the long term. We have already seen a lot of people having problems and side effects and permanent disability. And I can speak to a lot of my cohort and coworkers that were personally terrified to get this injection because of patients that they have cared for and personal experiences that they have seen, because we are on the forefront of this and we're seeing the reactions. I will say that the hospital in the center of the state does not have a current way to track those reactions or those side effects that are happening. And that is concerning as well, because we do not have accurate data as far as how harmful they are being. The other thing I want to just touch on, and I know a few other people have talked about it, but we have already discovered with many of my coworkers who chose by their own accord to get vaccinated, and they've had repeat infections with COVID. So we know now, after a year, that with the vaccine or without, you can still catch and you can still spread the disease. With that knowledge, I don't understand how any business can justify forcing employees to take a vaccine with unknown long-term consequences. There is no proof that it's going to save or protect our vulnerable population. If I get vaccinated and I still can catch it and have minimal symptoms, and I take care of somebody who's immunocompromised, I still run the risk, one way or the other, of putting that patient in a vulnerable position. And I think as healthcare workers, we're very conscientious of that. That's why, regardless of vaccination status right now, everybody is still wearing masks. But the rules and regulations are not lining up with what the current science is showing us. And so I have concerns about that. I do support House Bill 1001 and 1002, if only for the fact that I know a lot of friends and former coworkers that they today are, on that deadline. And unfortunately, I don't know what the long-term process is, if they're going to be suspended first and then they'll be let go. But there are still a good amount of people that are facing losing their job today. And so I just think that we need to be conscientious of that. And it's hard to have business rights when you don't have individual liberty. So I think that Thomas Jefferson said it best: there's no justification for taking away an individual's freedom in the guise of public safety. And that's what's happening here. We're harping on safety and trying to keep the public and the community and everybody safe. And we really might be doing more harm with this supposed cure than good. For that, I would stand for questions. Thank you.
Okay, thank you, Ms. Tiernan. Any questions for her? Okay, thank you very much. I appreciate your time. Let's come back in the room and we'll just go left to right. Go ahead, Mr. Bowley. My left to your right to my left.
I'm not good with directions anyway, Mr. Chairman. Mr. Chairman, Eric Bowley, President of the Wyoming Hospital Association and Leading Age Wyoming. I represent hospitals and about 2/3 of the nursing homes in the state. And I've asked Dr. Story to join me to maybe add some color to the comments. From our association's perspective, we want you to know that we are against the federal mandate. I was livid when in September, the announcement was made that nursing homes were going to have to be fully vaccinated. And that one segment of the healthcare industry was picked out. I'm just as bad now that we have a federal mandate for all of the healthcare providers, and our association is against the mandate. However, we are very pro-vaccine, and we think that the vaccine has changed the game. I remember not too long ago when we had a different president in DC, and we were excited about Operation Warp Speed and the vaccine that was going to come. And I think it was actually an answer to many prayers. And I wonder if we would be here today if there was a different president in the White House that had issued a similar executive order. Just a thought that I have, but we are where we are. I also want to support our private companies. They have the right to do whatever they want to. They also have the within the law, but they also have to respond and take the consequences of their actions. But I believe private companies are an individual choice in those companies is what needs to be thought about here. I also want you to know that healthcare entities, hospitals, nursing homes, our state hospitals, assisted living, all of those are going to be subject not only to the OSHA rules and requirements, we're also going to get caught in the CMS requirements. So we're under two different masters, both of them with really heavy hammers. And whether or not we like CMS or the CDC, and I question that a whole lot of times because that's my world. We are subject to their rules. And so visitation, all the different things that we've been facing now for almost 2 years have been guidance that has come through CDC and CMS for healthcare entities. I just want to share a couple of statistics with you because we talked a little bit about this and the financial impact. If we were ever to fall out of compliance with the federal law, our nursing homes are roughly 70% Medicaid. And then a portion of the 30% that's left over, a significant portion of that, 15% or so, is Medicare. So as you can see, 85% of the reimbursement for nursing homes is tied to federal funding. In hospitals, Medicare makes up for about 50% of our payer mix, with 10 to 12% being Medicaid. So 62% of that. Our hospitals and nursing homes would cease to exist without the federal funding. So if it comes down to making a decision between state law and federal law, we really have no choice. We're going to have to comply with the federal law. I'm all for you guys fighting this. And I believe that our executive in the state has the ability to do that and is already planning on that. Some testimony that was delivered on the other side, when this House Bill 102 came through, there was $1 million that was in the original bill to fight the federal mandate. It was stripped out at one point, and then as a placeholder, the 250,000 was put back in. The testimony that was received, I think, by the House Appropriations Committee is that our governor's office already has the ability to fight this and plans on doing it, so they didn't feel like the money was necessary. So the question you had, Senator Hicks, about whether or not we should support 102 because of the money that's in there, not sure it's necessary, is probably one of the things that it's put in there to make a statement, which I think 102 does. It makes a statement to the federal government. Not sure it's good policy, the bill itself, but we're supportive of you pushing back against the federal government on this, and we would be happy to see that. There's been some testimony also delivered about what breakthrough cases look like now, what we're seeing in hospitalizations. I think Dr. Story can probably address that better than I can, but it's pretty telling. I will tell you though, that vaccine has changed the game for us. In our nursing homes, about 90% of our residents, maybe 95% have received vaccines. Our healthcare workers, not nearly as high, but we are seeing decreases in the numbers of sicknesses and also deaths in our long-term care facilities. One thing that should be realized though, even under CDC guidance right now, if we have one breakthrough case, and a breakthrough case or an outbreak is one case in a nursing home, whether it's a resident or an employee, we're required now to test every single employee every day for a week. So we have to call them back. It's onerous. So as I look at some of the guidance that's been placed in here about testing employees, I don't know what that's going to look like, but the figures that Director Johansson shared about how many tests that could potentially be is staggering. If we decide to move forward with this, I just have a couple of things that might be quick fixes to a couple of problems that keep coming up. In 1001, on page 4, we've talked a lot about the exemptions. And I think that Joanna Vilos from the CRMC had some good guidance that we could provide for the religious exemptions. In section B though, as we talk about the medical exemptions, I think the best thing we could do here is we could just end it and put a period after physician's assistants on page 22 and remove the rest of that. I think that's where we're creating some ambiguity and some problems.
You said page 22. I think you meant line 22 on page 4.
Page 4, line 22, yes.
Okay,
Mr. Chairman. I also sent all of you a newspaper article. The timing was interesting. It was on Friday. There was an article that came out, and the CDC, if we think that we can start talking about natural immunity and COVID recovery being an exemption, as I've said, we're going to be subject to CDC and CMS. And so I think it's pretty easy for us to see the tea leaves. The article that I sent you basically says that the CDC is saying that immunity from prior infections is not going to be accepted as an exemption. So if we go ahead and put this into law, we're already creating a situation where we're going to be in direct conflict with federal law. And again, we're trying to figure out what a federal law is that hasn't even, or federal rule, however we want to terminology that we want to use. We're all going to be in conflict with that. And so I think that on this particular one, on page 5, I think that on page 6, after COVID-19 vaccine, I think that's a good place to put a period and delete the second 2 sentences.
Yeah, we're pretty much out of time for Mr. Boley. Go ahead and ask your question.
Well, and I appreciate Mr. Chairman sending that article, but I'm always reminded of what Mark Twain said when he said, "Don't read the flesh, you're uninformed. If you do read the flesh, excuse me, I missed it." Mark Twain said, if you read the press, you read the press. So the point being that I'm trying to get, it'd be nice to see the actual CDC instead of somebody's article saying what the CDC said. Is that possible to get that?
Mr. Chairman, Senator Hicks, it is a CDC that, if you look at it, came from the CDC. It was just reported. There's also a Wall Street Journal article that reported the same press conference that was held with the CDC.
Yeah, Mr. Chairman, and that's what I'm looking for is the actual CDC. I think email us an article.
Mr. Chairman, I can get that.
Okay,
You're welcome.
thank you. Any other questions for Mr. Boley? Thank you, Mr. Boley. Dr. I lost my sheet. Dr. Story. What's that?
May I defer my time?
Okay, do you have something else you'd like to say, Mr. Boley?
Well, I didn't think I was going to get there, Mr. Chairman, but
okay,
just a couple other things. And I appreciate that. Thanks, Sheila. When we on page 6, when we talk about the COVID tests in line 16 through 20, this section was amended on the House side, and it was because there was testimony that was delivered about the pain that's inflicted by getting the Q-tip all the way to the back of your neck. And so I don't think that there's any place in here limiting what the test should be that employers or healthcare workers should be using. And so again, I think that on page 6, line 18, a period after health guidelines would be good so that we would leave it wide open to, because as we know, technology is changing. We might have more efficient tests that come up, but right now we kind of have to use what's readily available to us. And those tests that are so intrusive are actually changing already, and it's not nearly as intrusive. So I would just suggest that for an amendment that might fix it. And then I think we've addressed it pretty well, but again, I believe there's ambiguity and concern for all of the private and also in 102, all the public entities as to when the switch is flipped on and off, when we're responsible to follow federal versus following the state guidance. So I would just like some better clarification. There was a lot of debate and conversation in the House on this and what was the best remedy, but I understand there are going to be challenges in court. Obviously, they're coming. Whether or not there are stays or not, we don't know. But to flip back and forth between the two, it's going to be very, very difficult. What I would really like to see is once a federal law is in place, then we're subject to the federal law because they're the 1,000-pound gorilla. And let's fight this thing out in court. I fully support that. But I think if we could remove that ambiguity, it would be a much more palatable on both 101 and 102. With that, I'll stop my comments and let Dr. Story share sometime now. Is there any questions?
Okay, thank you. Are there any questions for Mr. Boley now? All right, Mr. Boley, Mr. Boley, and go ahead, Dr. Story. Welcome.
Thank you, Mr. Chairman. If I may, just wanted to address a couple of things. I am currently the Assistant CMO of Cheyenne Regional. I also am an OBGYN who's practiced here in Cheyenne for 25 years and have a couple of comments to make in reference to the nasopharyngeal swabs. Mandating a specific or avoidance of a specific type of test right now is very, very difficult for us in the hospitals. Based on supply chain. And we often will be using those tests which we can actually access and be able to move forward in order to ensure both patient and staff safety. And so putting a handcuffs on what we can and can't use, both based on monetary cost and supply chain of actual being able to get them, makes it very, very difficult for us. And I would encourage you to not limit that within the bill set before you. A couple of other things, there was comments on the current hospitalized patients in Cheyenne, being privy to the patient counts in Cheyenne every day. What we have found right now is that over 90% of our hospitalized patients have not been vaccinated. We currently have 38 COVID patients, 6 of whom are vaccinated. and none of our ventilated patients are vaccinated right now. What this represents is well over a 90% unvaccinated rate for those admitted for the COVID-19 complications and disease. And we've found that running through. Our 6 vaccinated patients are the much higher risk patients, all of whom are 75 years old or older in those vaccinated patients. And it does improve their chances and help them clear the disease in a faster manner. For the vaccinations, the American Congress of OBGYN, our governing body as an OBGYN, recommends the vaccine at any stage through pregnancy, before pregnancy, and after pregnancy. The Reproductive Endocrinology and Infertility Society came out 2 weeks ago recommending vaccination of infertile and patients undergoing evaluation for pregnancy. And to this point, there has not been demonstrated evidence against the vaccine as it relates to fertility. And that's our governing bodies that oversee all of the OBGYN. There is a reporting system for all vaccinated individuals called VAERS, which is a federal vaccine side effect reporting. There have been 17,000 side effects reported in over 750 million vaccines given. So very low rate of side effects as reported up through the VAERS system. And again, with the mandate, against a mandate, it's making it very difficult as a business to figure out where we sit, especially since as a private business, as an OB in town, it makes it very difficult to know which side you have to comply with. And I don't have a cadre of lawyers, nor do I speak lawyer speak regularly. And it makes it very difficult for us to know how to comply, to be not askew of the law. I will say that should we lose federal funding, that removes a number of our contracts that we provide our patients and would make it very difficult in order to move forward and maintain a business successfully, should we have the threat of losing not only Medicare, but Medicaid dollars to our practice. And so would encourage this fight to go on within the federal courts as a state as a whole against the mandate that's coming out. But I'm not sure making a mandate against mandates supports the cause in the best way possible. And with that, I'm happy to answer any questions that I can. Thank you.
Thank you, Dr. Story. Questions for Dr. Story? Any questions for Dr. Story? Thank you for taking time out of your busy day, Dr. Story. Appreciate it. Dr. Janis. Excuse me, Dr. Paulus.
Yes.
There we go.
Mr. Chairman and the committee, I'm a board certified internist, American Board of Internal Medicine. I've been practicing for over 40 years. I've never treated an illness with the advice of self-isolate at home.
Did you pull
Self-isolate at home until you can't breathe, and then come into the hospital. You see, there's 4 legs to treating this illness. Okay, we have a vaccine, but we need a effective vaccine. We have early treatment, which could have saved 85% of people that died. And that early treatment is with hydroxychloroquine and with ivermectin. Hydroxychloroquine is very safe. In fact, I've got a statement directly from the CDC stating that hydroxychloroquine is safe and effective. Actually, they were referring to treatment of malaria, but both drugs, ivermectin and hydroxychloroquine, are effective for viral infections and for parasites. Now, I've been in the trenches, and for the last 2 years, I've seen and treated sick COVID patients. I know you've heard from a psychiatrist, and from a surgeon, and from a hospital administrator, but I've seen it firsthand. I've seen many vaccine injuries. We've got a note from the Cheyenne Radiology Group that we're not to order a mammogram on a woman for 6 weeks after she has a COVID shot because of the large lymph nodes. They look like tumors in the breast. Now, that's a lot of inflammation, and that can't be good. The problem I have with the vaccine is it's a messenger RNA vaccine. This is an artificial way for our body to make the spike protein. And then our body makes antibodies against that spike protein for COVID-19. But what happens next year when there's COVID-21 or COVID-22? Our immunological hands could be tied. You know, I heard about social and political and business and religious reasons that, you know, we have to worry about this pandemic. I'm worried about a tsunami of illness since the vaccine is now failing. It's not effective against some of the new variants. So we've neglected the other legs. There's 4 legs of treatment. As I said, the vaccine, the early treatment, the personal protective gear, and we shelter the elderly and frail. Now, I just want to emphasize that Pfizer does have Comirnaty. It's a version not available in the United States. I also want to say that Pfizer advertises a 95.1% risk reduction, but that is relative risk. The definition, when you study vaccines in previous illnesses, is called an absolute risk. The absolute risk of the Pfizer vaccine is not 95.1%, it's 0.7%. And another way of saying that is you need to vaccinate 142 patients in order to prevent 1 case. But we're talking about cases, not illnesses. A case is just a positive PCR. Back in the 80s, I took care of HIV patients. And Kerry Mullis, who invented the PCR test, stated before he died that—
Chairman.
Yeah.
How is this germane to these 2 bills? I mean, we hear a lot of people,
well,
their medical evidence back and forth. We know that, but I think we need to get back on the bills.
Okay, I've got, well, I have to talk about the, okay, we'll talk about the safety in pregnancy. That's a big problem because it's been barely 9 months since the vaccine is out. And the study that Dr. Story referred to, there were 827 pregnant women that were vaccinated, and but only 127 were vaccinated the first trimester. And of the ones in first trimester, 80 women lost their baby. So that's a 80% pregnancy loss. Okay, now I'll tell you what's important about these bills is the fact that the patients that I see, the people on the street, they're frightened, and they're frightened about what is happening, and they don't trust. We haven't done the job. They don't trust the medical establishment. We have to be open with them, and we have to tell them that we're going to do everything we can to help them. And I know people here are more concerned about finances and about, which is important, but we have a situation that there's breakthrough infections. And finally, I just want to tell you that I have over 30 references that support natural immunity. So if you've had it before and you have antibodies, you don't need the risk. So we have an illness that has a death rate of less than 1%. What happened to the flu last year? The flu can kill people and elderly, but with an illness that's so mild, to mandate a vaccination with so many documented side effects. I've had a patient that came in and 2 family members died after receiving the vaccine. And I won't go into any more medical. I'll just, if I have any more time, if anyone has any clinical questions, I'm happy to answer them now. Thank you.
Thank you very much, Dr. Janis. Questions for Dr. Janis? Any questions for Dr. Janis? No, I don't think so. So thank you, sir. Thank you for coming today and taking some of your valuable time to share with us. Thank you. Let's let's go ahead and let's get I think we've got still to come up. Let's go ahead, and I think we've got Mr. Porter Miss Witt. So Lance Porter, Sarah Witt, Marilyn Schickish, I think if you'll come up. And then we'll follow up. I think I still have, and after that, we've got we'll go on. I think I'm down to about Marguerite Herman, Gail Simmons, Joanne True, and Bobby Rolston, plus who's still in our. Okay, thank you, Marguerite. Appreciate that. Nor you, Gail. All right, thank you. What's that? And Joanne left? Was it something I said? Okay.
She'll be back.
Oh, she'll be back. All right, we'll see. Joanne True is fully capable of speaking for herself. I know that. So why don't we go ahead and do that? And then after we have these folks, we'll go back to our virtual room. So let's go ahead. Mr. Porter, I think you're sitting on my left. So let's start with you.
Good morning, Mr. Chairman and members of the committee. My name is Lance Porter. I'm the CEO of Banner Wyoming Medical Center in Casper, Wyoming. And I appreciate the opportunity to talk to you today about this. I don't want to add, I don't want to repeat what's already been said today. So I hope to add some information that just provides context as you make these important decisions. In July, when Banner Health issued their mandate, we were one of 19 healthcare systems in the country that issued a mandate. Today, there are 219 healthcare systems across the country which have a mandate. That includes prestigious organizations like the Mayo Clinic, Tufts, Yale, and our neighbors to the south, the major healthcare systems in Colorado and Utah. I bring that up because oftentimes throughout these hearings, it's made to seem like we are unique in this stance, and we really are not. There are a lot of healthcare systems that feel that the vaccine is our best tool in the fight against COVID. And so as the Banner Health System in Wyoming, we have followed in line with that because we really feel that that is the best way to keep our employees safe, to keep our patients safe, and to get ahead of this pandemic. I appreciate in these bills that it recognizes our right as a private business owner to have a vaccine mandate. Where my issue is afterwards, where it makes that very, very difficult and puts barriers in front of us. The exemptions are a big issue with me. Right now, we would have to accept an exemption from any physician, PA or NP. It's interesting, in a hospital on a day-to-day basis, as physicians care for patients, if they run up against something that they don't understand, they make a call for a consult. They call a specialist, somebody who is an expert in that area. And by doing this, we are ignoring experts. We're ignoring the infectious disease experts that can give proper guidance when we're dealing with truly a unique and highly contagious disease that we're dealing with now. It's unprecedented. And yet by accepting a physician exemption from just anybody, we're ignoring those specialists. And we may be opening ourselves up to risk for physicians or mid-level providers who make these decisions based on political or personal reasons rather than medical. We are not trying to put people out of their jobs. As a hospital operator, I have the obligation to keep my hospital open 24/7, to be there when your family members or your friends need our care. But right now, this is so stressed because of the COVID-19 that it's making it difficult to do that. As of today, we have 61 COVID positive patients in the hospital. Last week, it was 82. Today, only 7 of those are vaccinated. We continually, as an operator, I can tell you that it's harder to staff our hospital. Again, we're 24/7. We can't afford to close our doors and take a pause. It is harder to staff a hospital due to unvaccinated staff members who are more likely to get COVID or who may be exposed outside of work and then have to be quarantined for 2 weeks. That's hard to staff. That's then hard to care for those people that try to come to the hospital. Much more difficult than the handful of people who have decided to leave because of the vaccine mandate. That's the challenge we face. The final issue that I'd like to share with you is please don't put us in a position where we have to choose between state and federal law. That's been said before. The context I'll provide for you there is that at Wyoming Medical Center, 50% of our revenue comes from Medicare, 50. 10% is Medicaid. I would make an educated guess that most hospitals and most nursing homes in the state of Wyoming have something similar. So you can imagine facing a situation where you would lose 60% of your revenue. We've been criticized for talking a lot about finance and instead of on people, but it's the business, the hospitals that provide the jobs. And if we lose 60% of our revenue, it'll put us in jeopardy of not being able to provide those jobs. And we won't be able to care for the people of Wyoming. So those numbers are important and we cannot ignore them. So, you know, please, I am very much against both of these bills, but have some suggestions for some changes that might make this more palatable. And I appreciate your time and welcome any questions.
Okay, thank you. Any questions for Mr. Porter? So just help me, you're differentiating, or it seemed to me that you did differentiate, unless I misunderstood testimony, differentiated between the religious or strongly held personal belief exemption and then the medical exemption. I mean, it seemed to me that you distinguished those two, and if you could just elaborate on that, I'll appreciate it, because ultimately, I mean, if someone has a medical exemption, is there a practical difference between a strongly held personal belief that this is a bad healthcare choice for them, as opposed to a medical exemption where you have a doctor who's saying it's a bad health, or the medical providers a bad health choice care for them? So I don't know if you meant to differentiate between that, but at least that's how I interpreted your remarks.
So within the Banner Health system, the medical exemption is tied to certain comorbidities. Right now, it is not just a piece of paper that's signed by any doctor for any reason. It is tied to poor reactions to previous vaccinations or other comorbidities. And so there is a distinction between that and the religious exemption. You know, we want to respect people's strongly held beliefs. It's been said that our religious exemption is several pages. That's very onerous to fill out. That's not true. It's 2 pages. And the idea is give the people an opportunity to express where the gap is between their sincerely held beliefs and the vaccine. Again, that goes back to the basis for why we have the vaccine mandate, is that is the best tool for fighting COVID. And so we want to make sure that as many people as possible do that, so that so the burden of care is not placed on the vaccinated nurses and doctors, when the unvaccinated then are exposed and they're out of work, they're out of the fight.
Okay, thank you. Anybody else have any questions for Mr. Porter? Thank you. And then, so I guess we'll go to Mary Lynn, since she's sitting next to you, unless there's a reason.
I'll yield my time to Mary Lynn. This is Sarah Whittam, the interim CEO at Platte County Memorial Hospital with Banner, but I'll yield my time to her, but available for any questions regarding my facility.
Okay, Ms. Schickish.
Thank you, Mr. Chairman. Mary Lynn Schickish, representing Banner Health, and understand this difficulty that we're in. Is just wanted to say, as others have had, I'm a 3rd generation Wyoming native. I'm born and raised in Casper. Our whole family was born at that particular hospital, and deep roots in private business in Wyoming. I want to add to the conversation that's had before and let you know that we would be glad to share all the detailed information with regard to the exemptions, the forms, and everything of that nature. And let you know that here in Wyoming, we're above a 90% rate in terms of meeting the qualifications to be in compliance with the Banner Health vaccine requirements. So as we get to this point, we're talking about, lose my voice, less than about 150 to 100 people. I wanted to, specific to the bill, draw your attention to page 5, if I may, line 17, 18, 19, and 20, and read it.
We're on 1001.
1001. Thank you, Mr. Chairman.
Thank you.
The employer provides reasonable alternative measures to employees who have not received the vaccine or who will not disclose the employee's vaccine status. Although that particular section is not in the exemption section, essentially how we are reading it is that any employee who chooses not to disclose their vaccine status is eligible for an exemption. So I think that's really important to the whole context of this bill. In addition to all those other exemptions, all an employee would be required to do was just be unwilling to disclose their current vaccine status. So essentially, anyone would be eligible for an exemption as the bill is written currently. Thank you, Mr. Chairman. That's all I have to say.
Okay, thank you. Any questions for Ms. Schickish? Any questions for Ms. Schickish? Thank you. No, appreciate it. Thank you. All right, so I've got, the only other person I have on the list that I believe that I haven't, is Bobby Ralston. I don't know, Bobby, are you here? Okay, Bobby's not here, so we've got a few people left in the, is there anybody in here that I've missed that wanted to speak today? Anybody in here that I've missed? We wanted to speak today. We've got a couple people left in the waiting room. Let's go ahead and admit the rest. Let's go ahead and admit them.
Okay, Mr. Chairman. I have a Brenda Manina Mongold, but she's going to be, I believe, audio only.
Okay. And her name again is?
Brenda Manina Mongold.
Hello, can you hear me okay?
Yes, is this Brenda?
Yes, it is. Thank you.
Okay,
Mr.
Brenda,
Chairman.
I'm not going to try and pronounce your last name because I'll just murder it. So please go ahead. We're welcome.
That's okay. I'll get it. Thank you, Mr. Chairman. Mr. Chairman, members of the Senate Appropriations Committee, my name is Brenda Manina Mongold. I'm a citizen of Casper, and I thank you for this opportunity to testify this morning and by phone, which is quite helpful. I do hope to be afforded a similar amount of time given to some of the businesses represented in the room this morning.
Well, you have 6 minutes, Brenda.
Okay, thank you. My comments are primarily directed towards HB 1002. I do fear that listening to so many business representatives over and over might have a numbing effect after a while, and that individual Wyoming citizens are not being heard as loudly. The special session is supposed to be for vaccine mandates, and as House Representative Fortner wisely said the other day, the vaccine mandate is already here. There has been nothing written or passed that protects Wyoming children from mandatory experimental drugs, the COVID-19 vaccinations. Everyone knows that the CDC has just approved one of those vaccines for children, and the mandate will follow. But this has not been addressed, which is shocking to me. I would hope that you would amend HB 1002 with provisions to protect our children. There's so much more going on in this state than just the businesses. Secondly, the only options for citizens who test positive for COVID are to stay home or to go to the emergency room. Never in my lifetime have these been the only options when one comes down with an infection. There has been nothing written or passed that allows any Wyomingite to access alternative therapeutic off-label drugs from their Wyoming doctors or a Wyoming pharmacy for any of us to use at home if we come down with COVID. Please amend HB 1002 with provisions that help us get the therapeutics we need and we want. You need to know that most Wyomingites are aware what happened to a Wyoming citizen last year before he passed away. He refused being intubated at a Wyoming hospital. His arms were tied to his hospital bed so he could not fight what he had just refused. He made his own healthcare decision and the medical professionals ignored him. They restrained him, they intubated him. His wife was not allowed to be with him, and he died restrained and alone. This didn't just happen in America. This happened in Wyoming. How can that be? How can that be? For the love of God, how does a gaming commission bill become the only legislation that has come from the Senate on these issues? If there is a crossover deadline, I have not seen it on any schedule, except for the original schedule under special session rules that no longer apply. Why didn't you debate SF 1003 more until you got it right? Killing that bill had a devastating effect across the state. I don't know if you know that, but as a citizen talking with neighbors and friends, we're devastated. The bills you have before you now from the House specifically address employers and employees, which is also extremely necessary. But these bills seem to have been amended so many times they are a chaotic mess. Please fix them with appropriate amendments to protect individual citizens' rights, individual employees. These House bills you're hearing today fall quite low below the bar that citizens have personally put forth on this issue. Few citizens in the state feel anything appropriate and rational has been done so far. please amend HB 1002 with provisions that help all of us, not just some of us. There are so many people in that room in suits. Will Wyoming citizens be a priority? My husband and I have an agreement. If either of us comes down with COVID-19, neither of us will go to the hospital. No way, not a chance. And every Wyomingite that I have spoken to has said the same thing. This is a reality in our state. It has nothing to do with businesses. My husband and I have an agreement that if he is mandated to take this experimental vaccine, he will not, and we will prepare for him to be terminated. My son and I have an agreement that if his children are mandated with this vaccine, he will pull them out of school and I will educate them. This is not business as usual. There's a threat of COVID. There's the threat of hospitals ignoring and overriding citizens who make their own healthcare decisions. There's the absence of physicians and pharmacists because their hands are apparently tied for early treatment of their patients and prescribing off-label therapeutic drugs. There's the threat of the federal government, and there's the threat of people losing their jobs and potentially losing their homes. Please amend these bills to help all of us. It appears that all legislators are focused on and dancing around the federal government. Look at us. Look at your constituents. Prove to us we can depend on you. We need you to stand strong for us. We've lost trust in hospitals. We've lost trust in the federal government. We're in the 11th hour and we're watching with bated breath to see if we can trust our Wyoming legislature. Prove to us you will protect us in our individual rights as you promised you would when you swore your oath. Be our heroes. Wyoming needs heroes, not politicians. This is a defining moment for our elected representatives and for all of the state of Wyoming. Thank you, Mr. Chairman and members of the Appropriations Committee.
Thank you very much, Brenda. Any questions for Brenda? Any questions for Brenda? Brenda, thank you for your testimony. Who's next?
I don't have anyone else online, Mr. Chairman.
That's it?
Not that have indicated they want to testify. I think
We
we have
will,
run the gauntlet.
Okay, so with that, we'll go back. I know we have our Director of Health and Director of Department of Workforce Services. Anything else that you've been sitting here? Is that? Oh, I'm sorry. I thought we still had the mask on. I couldn't tell. I thought Stefan was still here. Anything, any director have anything for us? Okay, thank you. We'll go ahead and close off public testimony. Committee, why don't we take a 5-minute break and then we'll take up the bill. Okay. Go ahead and bring the Senate Appropriations Committee back to order. And we're going to take up these bills in reverse order. We're going to take up 1002 first. I think maybe we're wrong, but maybe we think it'll be a little bit shorter work over of that. Then we can get that one on its way if it passes out. So members of the committee, what's your pleasure on House Bill 1002? Got a motion and a second. Are there amendments? Let's work the bill. So anything on page 1, that'll flow out of what we do later.
Chairman.
Go ahead. Senator.
I've got an amendment the bulk of which is on page 8, but it does require an amendment on page 1, line 6. After the word citizens, inserting the words "and the state of Wyoming."
So I'll say that one more time on page 2.
On page 1, line 6. After citizens, it would insert "and the state of Wyoming."
Okay.
The balance of the amendment is on page 8.
Why don't you hold that one in
Yeah.
advance and we'll pick it up when we get to page 8.
Yeah.
Okay. That one. So anything else on page 2? Anything else? Go ahead, Mr. Vice President. Yes. Okay.
Mr. Chairman.
United States.
Mr.
I
Chairman,
believe.
I don't believe the audience can hear Senator Hicks with his amendment.
Is your mic on, Senator Hicks?
It's on. You want to do this one? Mr. Chairman, page 2, line 9, it says 45th President of the United States. I believe that's the 46th President of the United States. Technical correction. And maybe it is the 45th and the 46th. They were actually developed, I think, under the 45th president and authorized and approved under the 46th. As a technical correction, it might read the 45th and 46th presidents of the United States, the way the sentence is currently constructed.
Any discussion? Is that your way? We got a second? Second? All right. All those in discussion, all those in favor say aye.
Aye.
All those opposed say no. Motion carries. Amendment is adopted. Anything else on page 2? Anything else on page 2? Anything on page 3?
Mr. President or Mr. Chairman?
Let's go ahead, Mr. Vice President.
Page 3, line 10. After that, in the comma, would like to strike "in the coming days or weeks" down onto line 11. So it just strikes those words. I think that's a prognostication. We don't know when, in fact, that may or may not happen.
So what you're doing we're just going to read "is expected that the federal occupational safety and health." That's
correct.
What you want to read? Okay. Okay, any discussion? Any discussion? All those in favor say aye.
Aye.
Those opposed, no. Motion carries. Amendments adopted. Any other amendments to page 3? Any other amendments to page 3? Any amendments to page 4? Any amendments to page 4? I would propose that we amend on page 4, line 10, change it from private entities to private employers. Obviously, we have not everybody who's an employer is an entity. Some people are just people and they just have employees. Is there any further discussion? So if you got that, Karen, are you up with us so far? All right, thank you. All right, all those in favor say aye. Those opposed, no. Motion carries. Is there any other amendments on page 4? Any other amendments on page 4? Any amendments to page 5?
Mr. Chairman,
Mr. Vice President?
page 5, line 9. After the word granted, we need to insert under this section. It was omitted in the drafting, but by including those language, that's consistent with what Article 1, Section 38 says.
I think you're trailing off, and I doubt that anybody heard you say that, including me. I didn't hear the end of your sentence.
So, Mr. Chairman, page 5, line 9, after granted, insert the words under this section. Those were accidentally omitted in the drafting of Article 1, Section 30.
Okay. Are there any other?
Mr. Chairman,
Go ahead.
I believe our staff attorney would like to comment on that.
Heather, go ahead.
Mr. Chairman, often as we when we say something along the lines of under this section, it might mean the entire section of the law. So I wonder, we had somewhat or possibility, we had drafted as a possibility under that subsection C to refer it back to the subsection C of the Constitution that it is referring to, so that it doesn't, under this subsection could tend to refer to pardon me, it could tend to refer to the whole entire section of this section 1 that begins on page 1 of the bill.
So you're just going to clarify. So it's, if I understand what you're saying is, it's just that I think it's a friendly amendment. You're saying that what would do is under this, after the words granted, we would insert words to the effect that under this subsection, under this subsection C of the Wyoming of Article 1, Section 38.
Mr. Chairman, yes, it's to clarify that that is what they're pointing at, but
And
I'm
not referring to Section 2 of the bill.
Right.
Or Section 1 of the bill. Right. Okay. Is that what you had in mind, Mr. Vice President?
Well, I just wanted to bring in the actual, when we talk about Article 1, Section 38, this does modify it with subsection C of the Wyoming Constitution. There's some confusion out there that we didn't include the actual language in the Constitution. We did right up to that omission. And so if you go back, if I can borrow it, Senator Steinmetz, if I may, Article 1, Section 38 reads, the legislature may determine reasonable and necessary restriction on the rights granted under this section. That is actually in the constitutional language under Article 1, Section 38, subsection C. So my point is the verbiage in the bill doesn't comport with the actual language in subsection C.
Mr. Chairman, Senator Hicks, would you like it to be quoted then, as far as the actual quoted language from the Constitution?
Well, I think if we're going to reference section C, we ought to use the actual language in the Constitution and not interpolation of that.
So you would like, so, and that's fine. I would just to clarify, what you're doing is you would like us to quote this. You want to quote subsection C of Article Section 38.
As it is constructed in the Constitution.
Would you like, do you want to, just so it's conforming, so we're not doing it differently, do you want to do the same thing above that in line 2 so that in both those we're quoting subsections A and C of Section 38 of Article 1?
Mr. Chairman, I think that would be prudent to do that in subsection A, to bring in the actual language in the Constitution, because I do think it has generated some confusion out there.
That
Mr. Chairman, Senator Hicks, yes, that's understood.
you got that?
Is-
Okay. Now, if we quote both of them and it's clear they're both quotations, then I think it solves the problem.
Do I have a second?
Okay. All right, further discussion. All those in favor say aye.
Aye.
Those opposed, no. Motion carries, amendments adopted. Anything else on page 5? Anything else on page 5? Anything on page 6? Anything?
Chairman.
On page 6, Senator Kinsky.
Just, it's a note for Heather. If my amendment on page 8 is adopted, we'd want a couple of findings here that tie back to that about defending Wyoming businesses, and Wyoming receives grants itself and so forth. We'd want some findings that tie out to the amendment on 8. It's just a conceptual. Thank you, Mr. Chairman.
That's a staff note for later. Okay. Anything else on page 6? Anything on page 7?
Mr. Chairman,
Mr. Vice President.
page 7, lines 3. After Romanet 8, strike the balance of that line, all of line 4, all of line 5, and all of line 6.
Okay.
Second.
Okay, and all right, it's been motioned and seconded. Go ahead, and I'd like some explanation on this one because you just brought everybody back.
So, Mr. Chairman, members of the committee, by including this in there, for all practical purposes, there's no purpose for the bill. We've now said we're exempting out any public entity, and maybe we need to go back and clarify that as public employer, but no public entity does not include any receiving federal funds that comply with subsection B of this section would lose that federal funding. Mr. Chairman, I think we all recognize that within the state of Wyoming, that federal funding reaches almost every level of public entity within the state. My concerns is by including that we could potentially negate the legal position of the state of Wyoming. And as a result of, if we put that in there, it becomes state law. Under that state law, we would lose our ability to contest the legality of the executive orders, and particularly allied and looking at the Supreme Court history on the anti-commandeering doctrine, which says you cannot come into the states and use their employees to enforce federal mandates or unconstitutional acts by Congress, or an extension here may be an unconstitutional executive order. I clearly understand the implications of doing so, but at this point in time, for my own personal reasons, and I think the reason we need to do this is this could be a potential legal challenge associated with this. And by incorporating that language, we take that ability of the state of Wyoming to contest that in federal court. I'm very cognizant of the case of National Federation of Independent Businesses against Sebelius. I think speaks to that issue. The other side of it is that at some point in time, I honestly think that the state of Wyoming, this doesn't deal with employers. These are only state government, subdivision of state government employees. I think we need to step up and do what we are right as a sovereign entity and contest this in a federal court of law. So for that reason, on and for the amendment.
Mr. Chairman.
Go ahead, Senator Kinsky.
I wonder if Senator Hicks wouldn't provide a bit more context by explaining touching upon the subsequent amendment that's going to clarify that this whole thing is stayed pending federal litigation over those issues. Which is my second is predicated on that.
Thank you. And I was hoping that he would take the opportunity to explain that before everybody who has 85% or 50% of revenues now washed away, there was a, but first.
Well, Mr. Chairman, I was working the bill in order, but I'd
Okay.
love to jump forward.
All
And
right.
so there is subsequent amendments that says this bill this only stays in effect till there's a final disposition by the federal court system. At that point in time, either the bill fails, the law is struck down by the federal court. It doesn't have any implications to any public entity that receives federal funds. Well, that's what the subsequent amendments would do, is say, look, until we have this final disposition, till we've resolved all legal remedies within the state of Wyoming. At that point in time, if it's found that the executive order and the rules promulgated associated with that meet the litmus test of federal law, the state of Wyoming loses a legal challenge, then this would go away. It does not have, it was unenforceable within the state of Wyoming.
Okay, thank you. Is there further discussion? Senator Kinski, did you have anything further? All right, we understand the question. All those in favor say aye.
Aye.
Those opposed, no. Motion has passed. So we're back on the bill on page 7.
Thought you had it, it was under your name. Mr. Chairman, could we stand at recess for a moment till we find with the clutter on our desk where we've
Sure, we'll take
placed that?
we'll take a JAC stretch.
Oh,
Okay, I guess we won't take a JAC stretch.
No. Nope. It's not that. Yep. What's that?
I think she's ahead of you. Thank you. All right, so which of you fine senators is going to take this on? Senator Hicks, soft spoken. Okay. Mr. Vice President with Senator Kinski in tow.
Well, my name is on it for 1001.
All right, Mr. President, I will do the Kinski Amendment, number 5. This just brings in the previous discussion that we had. It would say, subject to the provisions of this section, the provision of section 2 of this act shall not be enforced until the date, final disposition, or resolution of all federal litigation concerning federal COVID-19 vaccine mandates that conflict with the provision of section 2 of this act. Subsection B. Subject to subsection C of this section, the provisions of subsection 2 of this act are repealed if a conflicting federal law, regulation, rule, standard, or order concerning a COVID-19 vaccine requirement or mandate is upheld in a federal court of competent jurisdiction, or a federal law, regulation, rule, standard, or order is otherwise found by a federal court to be lawful and enforceable. So it goes in and on pages 9, it deletes 16 through 23 entirely. Pages 10, lines 1 through 9, delete an entire renumbers, and then brings in this language.
It's been moved and seconded. We've already had the discussion. So I think this is an improvement on the language that's in the bill. So my question, particularly with respect to subsection A, is when we talk about COVID-19 vaccine mandates, do we and so we don't have do we need? Now on your, so if you go to page 7, line 20. And so at line 19 and 20, so just a minute, please. Oh, no, I got that. That's not- So, everything okay? Everything okay? Kinda. Okay, so just referring you, and this is, so with respect, you've got a federal COVID-19 vaccine mandates that conflict with the provisions of Article 2 in this act. Okay, you're there. If you go to 719, which is the provisions of this act and how they apply, it says that except otherwise provided in this section, to the extent that this section conflicts with federal law, regulation, rule, standard, or order, subsection B shall not be enforced after the federal law, regulation, rule, standard, or order takes legal effect, requires Wyoming employers to comply with a federal COVID vaccine mandate requirement or mandate. So so anyway, there's a difference. I'm just pointing out there's a difference between, here you've talked to vaccine mandates. In the bill itself, it talks about COVID requirements, COVID vaccine requirement or mandate. I'm just worried that when you look at that, is there a difference between a mandate and a requirement? And do we need to modify the language in A to make it clear that it's a vaccine requirement or mandate concerning any federal COVID vaccine requirement or mandate? What do you think there, legal?
Mr. Chairman, I think that the amendment that was passed out to you was for House Bill 1001, but the actual amendment that is for this bill draft for House Bill 1002 is has the the last 4 numbers as 1101, if any of you have that. And it takes into account, we made them be the same as far as between the 2 bills, but they were so slightly different structure between the 2 bills. So the way that they're described is the same in the bills, but since House Bill 1002 on page 7 already had a subsection D, then the entirety of what's added in the one that you read for that 2205 is not applicable to this bill. So the House Bill 1002 goes into to accomplish those same words. It goes into subsection C.
What's that?
And then it deletes the 2 and then replaces the rest of the language in subsection C with some language that I can tell you as soon as I get the copy back.
All right, let's start over again. Your Hicks?
In the beginning. Mr. Chairman, so we'll go into line 7 or page 7, line 14. And delete the word "to." Then page 7, lines 15 through 20. Yep, correct. All of that goes away and then we insert. So 15 through 20 is deleted entirely. And then we insert subsection B of this section shall not be enforced until the date of final disposition or resolution of all federal litigation concerning federal COVID-19 vaccine mandates, that conflict with subsection B of this section. And then on to page 7, line 23, delete during, last word in the sentence. Flip over to page 8, Mr. Chairman. We delete any period in which and we insert the word when a conflicting, so that will now read, when a conflicting federal law, regulation, rule, standard, or order is repealed, withdrawn, superseded, or declared by a federal court of competent jurisdiction to be unlawful or unenforceable. Mr. Chairman, that would be the amendment on page 7 and on over to page 8. It basically says that the state law would stand until it was struck down by a federal court in the final disposition. So in effect, what it does, Mr. Chairman, the discussion that we'd had earlier is which federal court. We could very well end up with competing decisions from federal court. So what the amendment says is until there is a final disposition. In other words, if there's a stay, whether there's an appeal, until that has exhausted itself through the federal court system, subsection B stands. Once there is a final disposition, whether the disposition is that the law is enforceable within Wyoming or it is not enforceable. So if it's not enforceable, it strikes down this law.
And what you said, what this does, it creates a toggle.
Repeat that, I did not.
If I understand what you said, it creates a toggle so that the bill says what it says and it goes into force. And then as soon as there's a federal statute, a federal regulation, or a federal order that puts a vaccine mandate into place that affects one of the public entities, at that point, then this bill is no longer, as far as the state prohibitions, are no longer enforced. Is that correct so far?
No.
Okay. So then if that's not correct, then what happens is, you have to, so they would be enforceable until there was an appeal filed, there was a lawsuit filed to determine the applicability or the constitutionality or whatever the challenge was, the order, that if that goes into play, then it depends what the court does. And so if it goes first to a district court and they say, yeah, we think we're gonna stay this pending, we're gonna stay the order pending the outcome of this litigation, then under those circumstances, then it still remains in effect. This bill would still remain in effect, correct so far?
Correct.
And then if that court, so let's take the inverse. So if that court said, no, I'm not going to issue a stay, then under those circumstances, then for public entities that there would be no stay, then it would be stayed and they would not have to comply with the provisions of this bill. Is that correct?
Correct.
Okay. So then it goes to the district court, and then it goes to the circuit court. It goes to the whatever court of appeals. And then they ask for a stay there. And then we would get the same thing. If they didn't stay it, then the provisions of this bill, if passed in law, would be unenforceable. If they did stay it, then the provisions of this law would be enforced.
Correct.
And then when it finishes there, if it goes to the Supreme Court until the Supreme Court hears it or issues or refuses to hear it or whatever it is, until that's resolved, then so there's actually, as I look at that, then the same thing happens there, correct? Whether it's stayed, the Supreme Court will stay it or not stay it, or they won't hear it, or whatever they're going to do. And then this will either toggle on or off according to whatever the status is and whatever that court decides. Is that right?
Mr. Chairman, I like the way you think, and that's correct.
So, but what that does is that it potentially toggles 3 times. So,
Mr. Chairman.
Correct? That's my concern. Okay.
All right.
We're not addressing a stay. It's as long as there's any federal court challenge rolling along anywhere, stay or no stay. This is not enforceable.
Is that way you understand it, Mr. Vice President? Because I don't think that's what we just talked about.
Well, my question is, what's enforceable? To Senator Kinski.
Yeah, so when you say it's not enforceable, we're talking about the provisions of this bill.
Notwithstanding subsections, subsection B shall be enforceable when a conflicting federal law, regulation, rule, standard, or order is repealed, withdrawn, superseded, or declared by a federal court of competent jurisdiction to be unlawful or unenforceable. It does not say that it's unenforceable during the pendency of any action. No, that's page 7, lines 15 through 20. Subsection B of this section shall not be enforced until the date of final disposition or resolution of all federal litigation concerning federal COVID-19 vaccine mandates that conflict with subsection B. In the amendment page lines 15 through 22. As amended.
Okay, so you're gonna have to turn your mic off. Thanks. So granted, I understand that. So the federal court issues this decision and you got 30 days to appeal. So it has been, you don't know if there's a pendency of an appeal until the 30 days lapse or the appeal is filed, whichever one comes first. So there's a 30-day there's potentially a 30-day toggle in between each appellate decision. See what
And yeah, absolutely, Mr. Chairman. And under that scenario, until that 30 days, we have a conflict. And the conflict is you have federal law and you have a state law. And the way the bill reads is the state law. And then let's assume the scenario that you just described, that the state decided not to appeal. Within 30 days, the state law then is not enforceable and the federal law is. If they did choose to appeal, then the state law stays and until that decision on that appeal is final.
Okay, I understand.
So on the amendment, lines 15 through 22, should we clarify that it includes during any period for which an appeal may be filed or the pendency of any appeals?
If you don't want it to toggle, you do. If you don't want this to toggle back and forth, you need to do something like that.
Mr. Chairman, my intent was the only toggle is when we finally get it resolved one way or the other, probably with the U.S. Supreme Court, or they deny cert and it's all over. That's the only toggle. The way this is intended is the day we pass this, it's unenforceable because there's already a pending lawsuit, 10 different states challenging these mandates. There'll be more lawsuits right behind them.
Okay, Mr. Vice
So,
President.
Mr. Chairman, I don't think it creates that codule where it bounces back and forth. Right now, the way I would interpret the amendment is no, state law rules in that particular case within that 30-day window. And at that point in time, if the state chose not to appeal, so it doesn't create one or the other, at least in our statutory construct here is this subsection B would stand until you've exhausted all remedies. That exhaustion is that 30-day appeals timeframe. At that point in time, if the states haven't availed themselves to appeal the decision from any level of the courts, district, circuit, or the Supreme Court, at that 30-day window, the state law controls. And at that point in time, if they fail to appeal, then the federal law becomes completely enforceable. I don't see where there's a discrepancy there. Now, maybe we want to address that in that 30-day window, but the way it's currently constructed, I don't think there's an off-on switch.
Okay. What do you think, Heather? Am I seeing things go bump in the night?
Mr. Chairman, I am hesitant to describe what you're seeing, but I do think that Senator Kinski and Senator Hicks had explained it well, but in subsection C, it's just that this bill is shall not be enforced until, and the keywords are the final disposition or resolution of all federal litigation. And then the subsection D moves on to say that notwithstanding that enforceability that's described in subsection C, that this section shall be enforced when a conflicting law, federal law is repealed, withdrawn, or superseded. So it encompasses the two scenarios of final disposition or resolution of litigation, or repeal or withdrawal of, or declaring unconstitutional of the law. So it covers the two instances, I believe, that Senator Kinski had described as far as the one or the other.
Mr. Chairman. Bill, I'll tell you, it's potentially susceptible of a reading as you described it. I'd rather we have additional verbiage in there so there's no question on anybody's part. The whole concept here is saying we as a state refuse to enforce it. Any entity, public entity shall not enforce it, but that is, we are putting all that on hold until we've got all the litigation resolved. So if we need to say, including during the pendency of any appeals or appeal periods, I think we ought to put it in there.
Okay, you can hold that thought. The other question I have is as a public entity, we have a state hospital, we've got the Wyoming Life Resource Center. We have a number of public entities. We have several county. We talked a little bit about this last night, but we have a number of county hospitals that are still owned and operated by counties. We've got a number of those issues out there. And so in those instances, as we heard this morning, you've got CMS issues as well as OSHA issues. And so those state entities issue there's a mandate there's this mandate's been imposed, but at the end of the day, OSHA is a federal program that the state applies for and receives approval of a state plan, at least in Wyoming and about 22 other states, 21 other states. And so that gives us the primacy, or at least the ability to enforce and modify that. And we've done that as a state because we have a compliance through cooperation and education first, and then the hammer comes later, and that's not necessarily the case with federal enforcement. And so as I understand the Federal OSHA Act, I think that when you have a mandate there, I don't know that the state has standing, even with this law. What you've done now is I don't know how the employers that are subject to OSHA get out of the crossfire on this, even if this passes. And then you throw into that the CMS issues. We've got the Pioneer Home State Hospital, Wyoming Elite Resource Center, and what's the one in Basin? we've got those, and they're all received that. And so that's a federal, I mean, that's a mandate that's tied to the application of federal money on that. And I don't know how, I'm not sure about the standing on that one. So I'm just looking at that, and it'd be nice if it was all homogeneous, but I look at this and it's not. So I don't know. And those are our public entities. Private employers are in a different bill, but those are public entities. And I don't know how we do that. If we don't do that, then our choices are we're going to have to appropriate money to pay the bill, which we certainly can do. We can pay the bills and we can pay 100% of the costs associated with those things if they don't. But I mean, in some respects, the state acts very much like a private employer in a few of its enterprises. Go ahead.
I'm having a hard time following because we say this was effective Friday. And say Monday, the Biden administration says, or the administration says, everybody getting any Medicare, line them up in the parking lot and vaccinate them immediately. They have to do it or their funds are cut off. This would not be enforceable during the pendency of any federal litigation. There's already federal litigation pending. So I'm uncertain where you're uncertain.
I'm uncertain because I don't think the federal litigation has anything to do with CMS or OSHA right now. So if the federal litigation has anything to do with OSHA or CMS right now, then as I understand this, it's not state. It's still enforceable against those entities. And ultimately, I mean, it will be I don't know what that means. So what happens is then I guess we play brinksmanship with the state of Wyoming, just paying the bill, whatever it is, for whatever it is that they do up there. And there is no ability to recover Medicare or Medicaid from CMS. And to the extent, I don't think like I say, there's no regulation on OSHA, so I don't know that to the extent that any of those workplaces are covered by OSHA, that there's any relief there either. So we go back, that's the problem when you pull out the thing and just make it all public entities. We've lumped them all in this homogeneous basket, and yet the effect of this is it'll be anything but homogeneous. It's going to be quite diverse, at least, and I'm sure that I haven't thought of all of them, but those are the kind of the obvious areas I've thought about just our conversation last night and then our discussions this morning.
Well, Mr. Chairman, if I may, and it gets back to the OSHA and the CMS. So this deals specifically if those agencies or those entities, federal entities, promulgated COVID-19 vaccine requirements or mandates. It only is specific to that. And so it may be in the case that the federal government would try to hold Medicaid payments for whatever purposes or any other, let's say highway funds, because we've adopted this legislation and highway constructions under the purview of OSHA as far as safety aspects of construction. In that case, I think that the federal government may very well try to say, yes, we're going to withdraw your funds. I think that's a likelihood that they would try that. They've tried it once before, not too long ago, with the Affordable Care Act. And there's a pretty interesting ruling that came out of the Supreme Court on that paraphrased what Justice Roberts wrote the majority opinion on this. It says, according to Roberts, the potential loss of federal funding for states was so severe that it precluded any real choice. As Roberts put, the Medicaid expansion was a gun to the head. And basically they struck down the ability of the federal government to withhold funds for those purposes. And so I actually think that this strengthens the state of Wyoming's position in the case that the federal government would try to do that we can rely back on that Supreme Court ruling if they come in and try to withhold school funding, funding through Medicaid, which this was specific to Medicaid in the decision referencing the Affordable Care Act. So at this point in time, Mr. Chairman, I think there's a real possibility that they may try to do that, but I think what we're trying to do here rests on Supreme Court precedent and try to get ahead of the feds in this particular sense. And Mr. Chairman, there's a subsequent amendment that will be presented that tries to address this issue of what we know and what we don't know as we go through the bill. And so,
I appreciate that. I think the distinction is that particularly in CMS matters, and it's a different deal, but procurement matters and acquisition matters. The difference is you're applying for those funds. There's no requirement. You're not entitled to those under statute. You're applying for those funds. You don't have to apply for those funds. You don't have to seek reimbursement on those things. And so there's the difference. Is it's not that there's an allocation of funds here. It's that you're applying for those funds. As a provider, you go out and you apply and you achieve that status and you seek those funds. And there's no requirement that you seek reimbursement.
Mr. Chairman, it may be well within an additional amendment to this to clarify that the difference between, voluntary application for federal funding, mandatory federal funding for federal programs.
Okay.
Distinguish between those.
We beat this one. We beat this one a little bit. Is there anything back on the amendment? So we still are on the amendment, but is there any further discussion on the amendment? Go ahead, Senator Steinmetz.
Thank you, Mr. Chairman. And now I'm thoroughly confused. So if we could start over a little bit. So in B, we're saying no public entity shall enforce. And then when we're adding into subsection C, that we're deleting that entirely, line 7 through 15, right? And we're inserting subsection B of this section shall not be enforced until the date of final disposition or resolution of all federal litigation concerning the federal COVID-19 vaccine mandates to conflict with subsection B of this section. So we're saying that a public entity can enforce the mandate until final litigation. Is that correct, or do I have that wrong? Thank you, Mr. Chairman.
I believe that and I'll speak to so I think that goes back to the substance of the amendment is, I think that they cannot, so long as there's a federal, as long as there's until there's a final disposition resolution of all federal litigation concerning federal COVID vaccine mandates conflict with subsection B of this section. And that so it's a fine point, but the application, I mean, what's happening is the federal government is not, we can call it a mandate, but ultimately it's a requirement to comply with the application to comply with and thereby qualify to receive the money as a part of your application. Think of it as a loan application at a bank or a grant application. You're going to apply, and until you check all the boxes of the requirements for the application, then you're not going to qualify. And if one of those requirements is that your workforce is vaccinated in accordance with this executive order or that regulation, you're not going to qualify. So, and lawsuits aren't going to change that unless they come back and find unless somebody sues about that particular issue, and there is something out there that says anyway, that's the problem as I see it. And particularly, just we all know on appropriations, our knowledge is a mile wide and an inch deep. But anyway, that's the problem I foresee. Go ahead, Senator Kinski.
So the three situations, what I hear you saying is, as opposed to the feds coming in and saying, here, state should go out and enforce this, or whatever, they just say, you're not getting your grant money. You're not getting your CMS money. And we'll just enforce OSHA directly. We don't need your complicity. The concern is getting clarification that they can still proceed to apply for grants. We're not prohibiting them from applying for grants. We're not prohibiting them from applying for reimbursement. We don't intend to do that. Because the feds will say, either get everybody vaccinated or you don't get any money. So and you're saying, well, you know, so now are they gonna be riven with doubt about whether they should even submit claims to Medicare or they should apply for the next grant? So if we need to clarify that, let's clarify.
Mr. Chairman, I'd like to amend the amendment on the amendment line 15. Well, it would actually be 17 where it says shall not. I want to take the word not out of the amendment. It's on the amendment, page 1. And then it would be line, let me see how it goes across there. Line 17, after shall, take out the word not. Mr. Chairman, the reason for that, if I could get a second.
Second.
The reason for that is I think it negates the entire bill to say that the meat of the bill shall not be enforced. And so I don't know if that was a typo or if I'm misunderstanding what we're doing here in this bill, but my intention in supporting this bill was so that this requirement is not enforced until we have final disposition. So that's the reason for that amendment to the amendment.
And you've seconded. Okay. So the question. So if you go to the bill, page 7, line 8, that's subsection B. And I don't think we've changed subsection B, which is just says, all right, no public entity, which would include the entities we just talked about, state hospital, et cetera. No public entity shall enforce any mandate or standard of the federal government, whether emergency, temporary, or permanent, that requires an employer to ensure or mandate that an employee shall receive COVID-19 vaccination. So then C comes back and says, we said that, but if that section B shall not be enforced until the date of final disposition and resolution of all federal litigation. Certainly if you put shall, then it truly is. You're forcing, I mean, if that's the intent, that's the intent. But the intent of it actually turns the amendment on its head and does the opposite of what the original amendment did. But that's your amendment. That's the way I understand it.
Mr. Chairman, the way I understand it, this amendment kind of turns Bill on his head for what it was seeking to do. So that's just my amendment. We might have a disagreement on that, but I'm standing by it. Thank you,
Okay.
Mr. Chairman.
Fair enough. Any other discussion on the amendment to the amendment? All those in favor say aye. Those opposed, no. Okay, motion fails. We're back on the amendment. Any further discussion? Are we ready for the question? He's ready for the question.
I want to amend the amendment. And it's conceptual because I'm not sure that I can state it properly, but Heather, in the amendment on lines 15 through 22, I'd like language added that clarifies addresses the concern the chairman raised about pendency of any appeals or any appeal periods or any period where you have a time frame in which you have to decide whether to appeal or not.
Mr. Chairman, Senator Kinski, so it would be inserting something along the lines of including during the pendency of all appeals or all appeal periods or something close to that?
Mr. Chairman. I think, I'm not quite sure where to put it, Heather, but I want something to clarify that enforcement, that this does not stop people from applying for grants, nor applying for reimbursements from federal funds. You know, if Robin Cooley's department is entitled to seek reimbursement for unemployment insurance, she can go ahead and do that. I don't want to have any confusion about that. We want this to be absolutely unambiguous. And I'm not quite sure where to put it or how to state it, but the chairman's point is a good one.
I don't think it, people are going to apply. It's just, they may be denied. I don't think it stops people from applying. You're not going to be able to certify that you've complied with the COVID vaccine requirements if there's a box in your application, or at some point that they say comply, certify that you've complied with whatever the applicable order, rule, or regulation is, and they're going to say that or not, or they're not, and then it's going to be processed, and it's just going to be flagged, and it's not going to be granted.
Yeah, now I understand. I better understand it. I had the same conversation with somebody in education. He said, state's got nothing to do with it. He said, at some point, I'll just have to check a box that the college is in compliance. If I don't check that box, everybody's Pew grants gets cut off. So I guess we'd have to have something to clarify that, while we're in this period where it won't be enforced, they can, I think the intent is during this appeal period, if you don't have a stay or an injunction from the federal court and this mandate comes down, people have to follow it. I don't think they have any choice. I think they have to do it. So unless there's an injunction stops the whole thing, the intent is that if the order comes down, you need to comply or we're going to cut off your funds. They've got to be able to check on the CMS box that they're in compliance. So whatever verbiage we need to make that clear, it's not going to be an easy lift to write that and clarify it.
Mr. Chairman, Senator Kinsky, these enforceability clauses of when it would go into effect would mean that they were in compliance with federal law until and unless it was finally disposed of or repealed, withdrawn, superseded, or declared unlawful or unenforceable. So they would be complying with the law clear up until that time that one of those takes place, in which case then subsection B would be in effect only once the final disposition has taken place.
Well, that's implicit. I think we have to make it explicit that if we're in the pendency, if the federal action is being challenged and it hasn't been finally struck down and they get an order to comply, they're free to comply, this act notwithstanding. If they have to check the box that says they're in compliance and they have to implement a policy, they have to implement a policy. It's blackmail. I don't like it. We're just trying to find a way to bootstrap ourselves into some standing in federal court. That was a conceptual amendment.
Conceptual amendment on this amendment? Is that to amend this amendment or is that a separate amendment?
That's to amend this amendment. So move a conceptual.
All right, this further discussion on that? All those in favor say aye.
Aye.
Those opposed, no. Motion carries. Amendment is adopted. We're back on the amendment as amended. Any further amendments on the amendment? We're ready for the question on the amendment. All those in favor of the amendment as amended, say aye.
Aye.
Those opposed, no. Motion carries and the amendment is adopted. We're back on the bill. So we are still on page 7. Is there any other amendments on page 7? Amendments on page 8?
Mr. Chairman, you should have a copy of this amendment. It ends in 2201. It's HB 1002 S 2201. So page 1, line 6, after citizens, insert and the state of Wyoming. Page 8, line 13, before with, insert a little a. Let me see, before, with the, insert a little a. Section 3A, okay. And then page 8 after line 18, which is after this general discussion about litigation. We have B, litigation of the section may include 1, initiating an action in the name of the state of Wyoming as the party aggrieved by a violation of 10th Amendment involving federal overreach into rights reserved, asserting standing on additional grounds, including the state accepts federal funding, federal contracts, therefore injured directly by the federal threats and coercion. 2, initiating a class action lawsuit on behalf of the state of Wyoming as the lead plaintiff that may allow Wyoming citizens to join the lawsuit as members of the affected class of those personally injured whose livelihood is negatively affected by the federal mandates. That would be my motion. Mr. Chairman, the rationale here is exactly per our prior discussion. So the intent of Senator Hicks's bill originally was an anti-commandeering bill, that they can't commandeer our people to enforce their law. They're not going to do that. They're just going to cut us off. So the injury is directly to those political subdivisions, to the state. That injury is directly to those businesses. The businesses don't have, I don't believe we'd have standing to sue under the OSHA mandate, but an affected business would. Problem is, they don't necessarily have the resources to do so. So we'd be able to provide those resources. So I think little I gives us standing directly, us and all political subdivisions, to challenge it under the same rationale as Justice Roberts articulated in the ACA case. And then 2, helps those who do have standing that are out in the business community bring action in their own right.
The only thing I would, I think this is a friendly amendment, Senator Kinski, but agreed by violation of the 10th, and I think that the thing I think is if there may be we may be agreed by other provisions other than the 10th Amendment, and so I think if we just expand that, so it was just the 10th Amendment or other provisions or other protection, other powers reserved to states under the United States Constitution. Something like that. Yeah. Yeah, or other protections reserved to the states. Other powers and protections reserved to the states. Something like that.
I regard that as a friendly amendment, but if you make that, I'll second it.
Just if you're gonna go get them with whatever provision you can load up. Okay. Discussion. All those in favor say aye. Oh, well, that's a friendly amendment. Never mind. We're back on the amendment. Any other discussion? Any other discussion? All those in favor say aye.
Aye.
Those opposed, no. Motion carries. Amendments adopted. Is there any other amendments on page 8?
Excuse me, Mr. Chairman, can I ask a clarifying question on that last amendment?
Oh, yes.
Mr. Chairman, earlier when we were on page 6, Senator Kinski indicated that he wanted a finding that matched up with this amendment that included some of the Roberts language about including any real choice. And is that a separate amendment or is that still a part of it as he had suggested when we were on page 6?
If you just, that is a committee of the whole amendment, just to add some additional findings in there in support of this Romanet 1 and 2.
Okay, thank you, Mr. Chairman.
Have we done that? We've adopted that.
Yep.
Okay. So are there any other amendments on page 8? Go ahead, Mr. Vice President.
Subsection E. Line 8. Page 8, line 7 through 11, which is all of subsection E, would be deleted.
Second.
Okay, discussion?
Mr. Chairman, it brings a whole different concept. Now we're bringing in vaccine passports and public entities shall require proof of a COVID vaccine. And I think it conflates and confuses the bill with a subject completely opposite of what we're trying to address. So I'd just like to eliminate that section from the bill.
Okay, thank you. You got a second? Further discussion? Further discussion. All those in favor say aye.
Aye.
All those opposed, no. Motion passes. Any other amendments on page 8?
Mr. Chairman.
Mr. Vice President?
Page 8, line 1, or line 20 and 21. Change the appropriations from $250,000 to $10 million.
Got a motion and a second. Discussion?
Mr. Chairman, with the adoption of Senator Kinski's amendment, there very well they may need additional appropriations to the Attorney General's office.
You'll be hiring special assistant attorney generals. No question. There you go. Okay, discussion. We've had that. Any other discussion? All those in favor say aye.
Aye.
Those opposed, no. Motion carries. Amendments adopted. Any other amendments on page 8? Page 9? Page 9. All right. Any other amendments on the bill? There's a question on House Bill 1002. Let's call the roll.
House Bill 1002 as amended. Senator Guru.
Aye.
Senator Hicks.
Aye.
Senator Kinski.
Aye.
Senator Steinmetz. Chairman Perkins.
Aye.
5 ayes.
Okay. Now we're on the easy one. Oh,
Yeah, that was the easy one.
House Bill 1001. Members, what's your pleasure? So it's been moved. Do I have a second? It's been moved and seconded. Amendments. So which one? Page 2. Any amendments on page 2?
Mr. Chairman, let me see if I've gotten some updated amendments from the staff. Hang on a second.
Okay, is there any, we can come back if there's some back on page 2. Any amendments on page 3? Any amendments on
Mr.
page?
Chairman?
Go
Before we
ahead.
go any further, are they available? We have staff that's available on video if we need them, and I don't know if you wanted to bring them.
Brian?
Yeah, Brian.
Brian?
Yeah.
Okay.
So I don't know if you wanted to bring.
Sure,
them
let
before-
Brian in so that he can help us if we need him. Brian, your head is small, but we can still see you.
Yeah, Mr. Chairman, just happy to answer questions as they come up.
Okay. All right, thank you. So we're on page 3. Amendments on page 3. Amendments on page 3. I would make the following amendment on line 13. What we would do is after, on line 13, at least one employee and after that, we would, it would strike has any other federal contract. And insert is subject to federal acquisition or procurement regulations or CMS requirements for payment in the course of the, and then the rest of it is in the course of the employer's business. Sure. So what we're doing is we'd get rid, has any other federal contract, and just get rid of that and just say is subject to federal acquisition or procurement regulations or CMS, which is Center for, I think we'll have to call it Center for Medicaid Service Payment Requirements.
Second.
So obviously, we're trying to do the same thing. It's just broader. I think it's just broader than federal contracts. And so we're just trying to get it broad enough. And if we may end up adding a few more, but anyway, that's the intent of that. So any other discussion? Any other discussion? Those in favor say aye.
Aye.
Those opposed, no. Motion carries. So the next thing is I'm having, so what A does, the top of page 3 to the top of page 4 is we create two classes of vaccine. And the first one is just a complete prohibition. So notwithstanding any Wyoming law to the contrary, no employer in the state of Wyoming shall require or mandate an employee to receive any emergency use authorized COVID-19 vaccine as a condition of employment. That's just an out and out prohibition. No exemptions, no nothing for that. And the way the bill's written right now, then the next sentence is notwithstanding that if you have an approved vaccine, as I way I understand it, of which there is one, but apparently it may or may not be available, that only then can you provide, or can you go through this exemption process? And I think that does two things. One is, assuming some of the testimony is true, there's no approved COVID vaccine that's available. So that means there are no exemptions. There's just an out and out prohibition, end of story, end of game. You don't get to do anything. It does two things. One is it makes it virtually impossible for anybody to comply. But the other thing it does is it limits choice. It limits a lot of choice because now you're saying you can, for this to apply and for this to be compliant under this program, you have to have the approved vaccine, which is apparently not available. So what we've done is in the intent to say, these are experiments and we're, by golly, we're not going to require to do. You're saying you can't do that. If you do that, it doesn't qualify. And therefore, it's only when you have that, then you don't even have to offer the exemptions to somebody who got one of the experimental vaccines. And you don't have to offer them exemptions. You only have to offer exemptions to those that have received approved vaccine. It does the exact opposite of, I think, what the intent originally was. Unless the intent was to simply put a general prohibition on any kind of vaccine mandate on an employee in your own workplace for private employers. So what my proposal, and so I'm concerned about that. So with that, are there any amendments on page 3? And I'll offer this one. I would strike on line 18 after A, I would strike line 18, except for the designation of subsection A. Strike line 19, line 20, and line 21. And then the other part of the amendment would you'd go back on page 2. And at the end of line 17, you would strike the semicolon. And then you would strike all of line 19. You would strike line 20 to the word vaccine. Actually, I'm sorry. You would simply strike, all of lines 19 through 22, and you would strike lines 1 and 2 on page 3. So ultimately, all we're dealing with is a COVID vaccine means any vaccine that is marketed to prevent COVID, or any vaccine that is marketed to diminish or decrease symptoms of COVID vaccine. So we're not having to distinguish between whether it's FDA approved or not FDA approved. It's just a COVID vaccine, which I think is the common understanding for most people with COVID vaccines. Second. So Senator Steinmetz.
Mr. Chairman, I would just have a concern with that and the fact that it seems like it's still under testing if it's not, it doesn't have full FDA approval, because I was trying to look this up as we had discussed it before, and we were looking into this earlier, but it says full approval represents FDA's highest level of confidence under a drug's safety and effectiveness. And full FDA approval takes longer than emergency use authorization. More data needs to be processed and reviewed over a longer period of time. When the FDA fully approves a product, patients can be sure the approval is based on large amounts of scientific data. And I think that represents the concern some of my constituents have, is that so much of this is still kind of in the testing phases, and that's where the concern in some of my constituency lies. Others are perfectly fine with how things are going and what, taking the vaccination. But I think when you start talking about mandating and what we're going to allow to be mandated, then mandating an emergency use authorization, it's just a little more questionable to me. So for that reason, I'd be on and against the amendment.
Okay, well, just keep in mind, we've got 40% of Wyoming's population have already been vaccinated with a vaccine that we're calling out, and and those people aren't going to be extended accommodations, or people who don't want to get those aren't going to be extended accommodations. So it actually ends up being incredibly restrictive for an employer who's trying to provide accommodations for someone who doesn't want to get an experimental vaccine. And so it's actually, in my mind, you're limiting the ability of employers to work with their employees and try and find a way to let them work without necessarily violating state law. But anyway, that's my moment. We've discussed it. So anyway, any other discussion on the amendment? All those in favor of the amendment say aye.
Aye.
Those opposed say no. The amendment carries. Any amendments on page 3? Any amendments on page 4? Page 4. Any amendments?
Page 4, line 6. Strike critical and insert important.
Okay, is there a second? My motion is seconded. Any discussion?
So what was the basis between important and critical?
I think critical is less important than important. Or critical is more important than important.
I think we're just trying to lower the threat. I had some concerns expressed to me that the threshold needed to be lowered, that the employer doesn't have to prove that it's critical to their business. It's important to their business. So it's sort of one of those draftsmanship things. It's kind of a Hicks type amendment.
Aye.
All right, any further discussion? All those in favor say aye.
Aye.
Opposed, no. Motion carries. We're on anything other amendments on page 4. Line 9, go ahead, Senator Kinski.
Strike evidence and put notice, and line 14, strike evidence and put notice.
Second.
Keep it up, Mr. Chairman. All right. We already talked about this, but we had a further discussion about notice. All those in favor say aye.
Aye.
Those opposed, no. Motion carries. Amendments adopted. Any other? Go ahead, Senator Kinski.
Just trying to avoid feedback. Somebody said something about being consistent with applicable guidelines, and I think we heard today that there are guidelines embedded in the Wyoming Fair Employment Practices Act for granting or withholding of religious exemptions. So be patient with me here. Employer shall grant exemptions on religious grounds upon submission of an exemption request by an employee, and the exemption shall be, considered in
Consistent with the accepted guidelines.
Considered and consistent with applicable guidelines pursuant to the Wyoming Fair Employment Practices Act.
Mr. Chairman, I'll second it for the sake of discussion, but I tried to do a search and I couldn't find those guidelines on the Wyoming Fair Employment statutes. Not to say they don't exist, but I could not find them.
Oh, we have the Director of Workforce Services here.
You have such guidelines?
So do we have, Mr. Chairman, do we have a specific EEOC statute?
There's a federal EEOC that are
Okay, so pursuant to EEOC standards and guidelines. So Karen, it'd be upon submission of exemption, which shall be granted or denied consistent with applicable EEOC guidelines.
Today.
Further discussion. All those in favor say aye.
Aye.
Those opposed? Other amendments on page.
Mr. Chairman, line 20.
Go ahead.
I would stop at exemption and add an exemption that will be the same language we used above, considered or approved or denied consistent with applicable EEOC guidelines, period. And I would strike the rest of it down to line 23 and lines 1 and 2 at the top. So again, that's responsive to the request that if we're going to pass this, let's keep it all within the context that all businesses are all used to working within. So it'd say an employer shall grant an exemption for medical grounds upon submission of exemption, and the exemption will be approved or denied consistent with EEOC, applicable EEOC guidelines, period.
Okay. Okay, so we've had the motion and a second. Is there any further discussion? Further discussion? All those in favor say aye. All those opposed say no. So were you and I? Okay, the motion passes. Any other amendments on page 4? Any other amendments on page 5? Any amendments on page 5? Yes.
I would strike lines 4 through 7 as we've incorporated with existing guidelines, which I think what we'll find out is the EEOC is going to look to some of those things that the good doctor had described, the CDC recommendations, Infectious Disease Society of America, NIH. We don't need to recite all those because I think the EEOC looks to those for guidance. And without debating whether a COVID test positive, I mean, we try and work with this thing, try and fix it up one way or the other, but when a positive COVID test is recognized by any applicable authority, they'll be able to get an exemption or waiver on that basis. Presumably, those criteria already consider contraindications, but what's really bad about this is we're having the employer in the middle of contraindication and looking at written evidence. Typically, what you try to do when an employee applies for an exemption, as an employer, you really don't want to know all that stuff. You want a letter from the doctor that may allude to some of those things, but we don't want to be getting into that level of detail on the employee's medical history. That goes against everything that we've ever passed legally in terms of HIPAA and confidentiality and everything else. It's getting too far into the employee's confidential business by the employer.
Okay, thank you. Further discussion?
Is there been a second?
There's a second.
Discussion, Mr. Chairman, I'm going to vote against this at this time because I have not had an opportunity to review those federal guidelines. And my concern is based on some of the earlier information that I've seen is they did not allow for the demonstration of antibodies. And so until I see that language at this point in time to see if that accommodation is made in those guidelines or rules, I'm going to be a no vote on this.
Thank you, Mr. Chairman. May I?
Sure, go ahead.
I did not mean to represent that those standards recognized a previous COVID positive test as bestowing immunity. What I said is when such time as those are recognized by the medical community as bestowing the necessary immunity, it will be incorporated into those standards and guidelines. It's not now. I mean, it's not recognized by the medical community now. There's a lot of people that assert that it is or should be, but it's not as of yet, to my knowledge. I didn't mean to represent the contrary.
Mr. Vice President.
Mr. Chairman, I understood that. But my concern is that probably should be included. And if it's not in there now, then that would be the reason that I'm voting against this motion, is because I do think that needs to be made as a reasonable accommodation, that if somebody can provide an antibody test to an employer, that should be granted an exemption under medical.
Did you have something to add, Senator Drew?
No.
Okay.
No.
I just, I think what happens is once this relieves a religious exemption and goes into medical, then it starts to fall into the ADA. That's, you're talking about reasonable accommodations, and there is a whole area of law that deals with those types of things. So I think that anyway, it's neither here nor there, but it's treated differently because it's like it goes into the area of disability. So it really starts to be a protected class when it becomes a medical reason. It's covered under the ADA, Americans with Disabilities Act. So, but anyway, that all being said, any other discussion? Are ready for the question? All those in favor of the motion say aye. Aye. All those opposed say no. Motion fails. Okay, any other amendments to page 5? Any other amendments to page 5? Go ahead, Mr. Senator Hicks.
6, delete or, and insert a comma. and bring in additional language after COVID insert on page 5, line 7. Or upon evidence of a laboratory test detecting the presence of antibodies to COVID-19.
Say that one more time, if you would, Senator.
So, Mr. Chairman, if you go to on page 5, line 6, delete or and add a comma. So now it will be COVID-19 vaccines, and then it says or upon evidence of a laboratory test detecting the presence of antibodies to COVID-19.
Okay, any other discussion?
Question, Mr. Chair.
Oh, go ahead. Okay, you want a question on the amendment or?
Sorry, yeah, on the, to the maker of the amendment. You read comma, or upon evidence that, but you didn't say the word written. And my question is, and this is why I'm just baffled by this, but as an employer, is the state going to provide me with a lab equipment so I can do blood tests on my employees to count antibodies? I mean, that's kind of where I sound like we're going.
Mr. Chairman.
Go ahead.
The answer to the question is no. It would be upon evidence of a laboratory test.
Okay.
So that would be incumbent upon the employee to provide copies of those test results to their employer.
Okay. Just ask.
Mr. Chairman, it's not putting any additional mandates on an employer.
Okay,
I'd second.
ready for the question? All's in favor, say aye.
Aye.
All's opposed, say no. Motion fails. Back on page 5, are there any further amendments on page 5? Any further amendments? Go ahead, Senator Kinski.
Line 18, after the word have, insert qualified for a medical or religious exemption, period. Strike the balance. Let me see. Let me strike it down to an employee shall not be. So strike not received the on line 18, strike 19, 20, 21, 22, and 23 to the period. So it now reads the employer provides reasonable accommodation measures to employees have qualified for a medical or religious exemption, period. An employer shall not be required to provide an employee's preferred alternative and so forth.
Okay, there. For discussion purposes, I'll second that.
So Mr. Chairman, I think it was pointed out to us that the way this is written now, whether you have a medical exception or a religious exception, doesn't matter. You just come in under 3 and say, I just don't want to get a vaccination. I'm not going to tell you whether I have a vaccination. If that's the law, if that's what we intend to do, we don't need religious and medical exemptions. We can strike all that religious and consideration and everything else. They just say, I don't want it. And then it's a question of whether the employer can or cannot accommodate them reasonably. So I'm just trying to find out, what is it we're trying to do here? Are we really trying to say that what this law says is employee just comes in and says, I don't want to, in which case we can simplify a lot of language in this bill. And then our focus is on just whether the employer, but somebody who doesn't want to, whether the employer can or cannot reasonably accommodate their desire not to vaccinate or not to disclose vaccination. So for the medical and religious exemptions to have any meaning, I think we have to adopt this amendment. If we don't adopt this amendment, we just will strike out all the language about religious and medical exemptions. That makes sense?
Mr. Chairman, just a question for Senator Kinski. Where did you stop your strike? Was it on line 23 after subsection?
It was on line, oh, where did I stop my striking?
Yeah.
I stopped it on line 23 after subsection,
All right.
correct?
Thank you.
Further discussion? Further discussion? Those in favor say aye.
Aye.
Those opposed, no.
No.
Motion carries. I think we're to the bottom of page 5, unless there's something else on page 5. Is there anything on page 6? Is there anything on page 6?
Mr. Chairman. Go ahead. Let me back up. Let me back up just a little bit. This would be an amendment. I have not been able to identify every place where it occurs. But wherever we have the phrase undue burden, I would substitute undue hardship. I think that's what it is under the current statute, EEOC, isn't it? Undue hardship rather than undue burden. That's what I had, is that undue burden was the preferred terminology because that's consistent with current law. And then second, anywhere where it has RAM, reasonable alternative measures, we would substitute reasonable accommodations. Again, those are phrases that are very familiar to the state agencies and to employers in terms of dealing with these kinds of things. Instead of creating a whole new nomenclature, we'll just stay consistent with what we already know. That's my motion. I think those are the only two that people are concerned about.
Okay, further discussion? Further discussion? Question? Favor of the amendment, say aye.
Aye.
Opposed, no. Motion carries. Adopted. So we're still on page 6.
Mr. Chairman.
Go ahead, Senator Hicks.
Page 6, line 18. After testing, strike by means other, down on line 19. Continue the strike all the way through swab. So now we provide that testing shall also be offered to employees when available.
Second.
Okay. Further discussion? Further discussion? All those in favor say aye.
Aye.
Those opposed, no. Motion is adopted. Amendment is adopted. We are on page, anything else on page 6? Anything on page 7? Anything on page 7?
Mr. Chairman, I have something, I just don't know what I have. I thought what we heard from people is this was that B, lines 5 to 18 was throwing people in the realms of a discrimination complaint. Is this where we would fix that?
Yes. Mr. Chairman, just for the sake of discussion and maybe to refresh Senator Kinski's mind, I think this is where there was numerous people that testified that the unfair employment practice was extremely onerous, that we may want to consider moving this into the unemployment insurance benefits rather than the unfair employment practices.
And Mr. Chairman, I have an amendment that does move it into UI, except Director Cooley raised some concerns that the feds might not look kindly on that. They wouldn't pay us for the unemployment insurance, certainly. We could probably administer it under UI though, but they wouldn't pay the unemployment benefit. So we could just administer it under UI, but not pay UI. So UI would be the arbiter whether I'm not quite sure how to do that, Mr. Chairman.
Mr. Chairman, could we ask the director to weigh in on that? I don't recollect that discussion, but if that's true, I'd like to have the director weigh in.
It was a hallway discussion.
Use the microphone, please.
Mr. Chairman, members of the committee, Senator Kinski, I did send you an email that we did receive from our UI folks, but also from DOL. So one of the concerns with that is if you have our UI folks that are implementing or making these determinations, they are still paid by unemployment. They cannot be paid through those funds to make that determination. So that's one of the concerns. Another concern is, of course, that's not their expertise area, particularly from USDOL. Their concerns were the cost. Let's see, they say certainly a state law that an action is not misconduct connected with the work, or that a quit was for good cause connected with the work, resulting in eligibility or ineligibility for UI benefits under UI law may not have the same result when looking under the lens of another state or federal law. So in other words, when you look at it in terms of UI eligibility, you're not looking at it in terms of a discrimination case. So it's not their area. They can't be paid through UI funds for that. And it would be a difficult thing to administer, to be quite honest. We've got a lot of UI folks in Casper, and trying to get them to parse out their time that they're making those determinations versus they're making an unemployment determination would be very difficult.
So, Mr. Chairman, so Director, I guess I'd point you to line 20. Department of Workforce Services shall enforce the provisions of this section and promulgate rules and regulations. Do you feel the department is up to taking this statute and setting regulations so that they can examine these reasonable accommodations by employers vis-a-vis vaccine requirements and employees alleging that they weren't accommodated or that their religious exemption was unfairly denied?
Mr. Chairman, Senator Kinski, I do. That is the work that they essentially do now when they're looking at a discrimination case. They do a full investigation. Certainly it takes a lot longer, and that would be a benefit if you were to run it through the unemployment agency. It's a shorter time frame. It takes a lot longer with an investigation through our labor standards folks, but that is the work that they do that they've been trained to do. Another point I wanna just throw out there so you're aware of it. When we're doing work through the EEOC with these discrimination claims, we do get a reimbursement from them for those claims. Because this would be a state-only claim, that reimbursement level is not there. Just another consideration.
Well, Mr. Chairman, in light of that, I don't know that we can do anything except strike lines 5 through 18. I don't know how to fix it because everything here is predicated on 27-9-106 and the department investigating all this is an unfair employment practice. We just got to defer to the department to put the rules and regs together. Because what we heard is the consequences of an unfair employment practice go way, for a business, go way beyond just an employee. So I would strike lines 5 through 18. I don't know how else to clean this up.
Rulemaking authority for the department under that provision. I don't see anything else up there on a quick glance that would require rulemaking.
Mr. Chairman, Senator Hicks, I'm, if I understand you, line 20, et cetera, would be maintained. Oh, sorry. Okay. Well, I've been moving away because of the feedback. Okay. So Senator Hicks, if I'm understanding you correctly, we're still going to maintain lines 20 through 22 and on to the next page, the rulemaking. I'm just proposing striking 5 through 18, which is kicking it all into unfair employment practices and that whole realm.
Mr. Chairman. Yeah, I understand. My question is it necessarily then to give the Department of Workforce Services rulemaking for subsection A and B, if you go back to page 6? Because now this would be renumbered and come in as subsection. And maybe we do. It's a
I
question.
think what you do have is you still have remnants that you still gotta, if you go back, you've got to provide notice of the determination of workforce services. We'll have to figure out what that notice is, what should be the contents of that notice. I think the anticipation is there's some ability for review to see if, particularly now that they're tied to a specific standard, I think there's going to have to be some ability and some rules so that they can make sure that people know and with more definitive about the applications and the process they go through. I'm assuming ultimately that's the way I see it. Director DeCooley, do you see it a different way, or with respect to the notice on like either on the various exemptions, and they've got to provide information to you as under the bill, you still have to have some ability to decide what that looks like in that process.
All right. Thank you, Mr. Chairman. I'll second the motion.
Okay. But yeah, I don't want to give the department more power than they already have.
Repeat what the motion is now.
So I think, as I understand the motion really is now the lines 5 through 18 on page 7. That's the motion, as I understand it. For the discussion, ready for the question? Those in favor say aye. Aye. Those opposed, no. Motion passes. Go ahead, Senator.
I have a question. This is. Yeah. We've been, one of the proposed motions rolling around out there was thought to be inserted on page 10, line 22, after the word act. And I was wondering if maybe it might be better to place that on page 7 as a new key instead of the one we just struck. After line 3, add a new section B that says this act shall not apply to federal contractors designated in Executive Order 1404.
Actually, I think the best place for that is probably in section 5, which are the general applicability section of this.
So stay where
Well, actually,
suggested.
I think so, because that's section 5 is talking about the general applicability of this entire bill as it goes. And so if you want to apply the entire bill, then 22, then I think it's in the right place.
I just remember we had another discussion I had about that section and wanting to go up.
Okay, anything else on page 7, page 8?
Mr. Chairman, I thought we had a discussion about striking lines 4 through 7. I can't remember what the rationale was, though.
No, I think that what it was is I don't have any idea what it really does. Nothing in this section shall be construed to limit or preclude an employee who is unemployed from receiving any other benefit which the employee is entitled to receive under law.
Seems like a restatement of law.
So
I'd move we strike lines 4 through 7.
Okay, is there a second? Motion and second. Discussion? All those in favor say aye.
Aye.
Those opposed, no. Motion is adopted. Anything else on page 8? I think this is where we start in on page 8 is any other, no, page 9. So anything other on page 8? Anything else on page 8? Anything else on page 9? And I think on page 9, this is where this one proposed amendment that we were talking about before. So this is the one that we were looking at this one and trying to shoehorn it into 1002, but this is actually where it would go in 1001. Senator Hicks, I think you want to take us through this. We're on. So if you take the 1001, page 9.
It's 1001, excuse me, it's 1001 Amendment 5.
And also, while you were gone, we also amended and dropped subsection D, which is page 8, lines 4 through 7.
Mr. Chairman, this Amendment 5 on 1001 begins on page 9 and it strikes lines 16 through 23. This discussion will be familiar from the discussion we had about holding in abeyance the effective date in House Bill 1002. And then you go to page 10 and you strike lines 1 through 9. So all of the existing section 4. Then you substitute subject to the provisions of this section, the provisions of section 2 shall not be enforced until the date of final disposition and resolution of all federal litigation concerning federal COVID-19 vaccine mandates that conflict with section 2. And per our prior discussion, would be Heather or whoever the staffer is would insert that language about including pendency of any appeals or appeal period. And then B, subject to subsection C of this section, the provisions of section 2 are repealed if a conflicting federal law, rule, regulation, standard, or order concerning COVID-19 vaccine requirement is upheld in the federal court of competent jurisdiction or is otherwise found by a federal court to be lawful and enforceable.
Oh, is there a second? Motion seconded. Discussion on the amendment. Brian probably doesn't know about the expanding language. Brian, are you still there?
Yeah, Mr. Chairman, I am. Can you hear me?
Yes, can. So Brian, I think what we're talking about doing is on line of the amendment of that proposed amendment that Senator Kinski had you work up on line 8. And certainly have literary license to be more artful or put it in a more appropriate place inside section A. But so on line 8, after disposition or resolution, after those words, you insert words to the effect of including the pendency of any appeal or appeal period, something like that. We're just trying to make sure that there's not an inadvertent toggle that occurs during the pendency of an appeal or while or during. If there's no appeal filed, there could be a 30-day or more period that the appeal hasn't been filed yet. Make sense?
I think so, Mr. Chairman. We'll get that drafted. We'll get that added if the committee so desires.
And Mr. Chairman, Brian, I would add that Heather Jarvis is working on language as well. We'd like the language to be identical in both bills. So there's no confusion out on the floor or no more confusion than there already is.
You got it, Mr. Chairman, Senator Kinski, you got it.
Okay, so any other discussion on the amendment as proposed? All those in favor say aye. Aye. All those opposed say no. Motion passes. So any other amendments on page 9 or 10? Senator Drew.
Thank you, Mr. Chairman. On page 10, line 22, after the word act, add this act shall not apply to federal contractors designated in Executive Order 14042.
Okay, is there a second? I'll second it for discussion. I think we understand. That. So are you, there further discussion on the proposed amendment? This is one that was given to us about adding at the end of on page 10, adding a new sentence at the end of and after act on 22, says this act shall not apply to federal contractors as designated in Executive Order 14042. So further discussion.
Mr. Chairman, I mean, we just well say the act will not apply to anybody affected by Executive Order 14042. Because I think 14042 is the OSHA, the contractors, and I think CMS is a separate executive order. I'd be against the amendment.
Okay. Any further discussion? Those in favor say aye.
Aye.
Those opposed say no. Motion fails. Back on the bill. Are there any other amendments on 10 or 11? Go ahead.
If we go back to what we've already done to page 8. Well, maybe not page 8. Where is it? So we, on page 7, Mr. Chairman, we deleted all of subsection B. So line 5 through 18 is now deleted based on a previous action of this committee.
Correct.
So the appropriation of section 3 on page 8, 11 through page 9, line 12, was assuming that there was going to be a significant increase in workload associated with the provisions of subsection B. So for that purposes, it seems to me at this point in time that would be appropriate to delete subsection 3.
Mr. Chairman.
Go ahead.
Senator Hicks, I think what we heard is the department is going to have to stand up regulations and in those regulations and an apparatus that when somebody feels that the lawyer has not, that the employer has not accommodated them, that they can bring that to the department and the department can vet those plans. The department is going to have to give guidance to employers on what kind of notice they have to give an advance notice of the implementation of these rules. And then somebody that feels that they were wrongly denied their religious or medical exemption is going to be going to the department on that. So they still need that money to stand that up and to vet those complaints that they haven't accommodated me or they haven't allowed my exemption. I think is that what you had understood, Director Cooley?
So, Mr. Chairman, if I may, Director Cooley, how long does it take your agency from the time, let's say this is signed into law, and then to go in under the Administrative Procedures Act, do public notice, take comment, back to adopt final rules? What is the time frame for that process to happen within your agency?
Go ahead, Director.
Mr. Chairman, Senator Hicks, as is noted in here, we would try to do that by emergency rule initially. I think the time frame for getting rules out for public, it would take us, say, a month to draft the rules, hopefully less. I think the public comment period is 45 days. It's been a while since I've looked at those deadlines, but then we would come back. I mean, it's a process that goes back and forth. It has to be approved by the governor's office initially before we go out for public comment. So there's quite a timeline in there. I'm going to guesstimate that it would be around 90 days, 120 days around there.
Well, Mr. Chairman, thank you for that explanation. So given the fact that we'll be back here in 1 month doing budget hearings, I think at that time it would allow the department to do some additional analysis to determine exactly what they needed, instead of just putting appropriation and an authorization of employee in here and when we may be right back. So I think it's premature to go ahead and do the appropriation and analyze the position, given the fact that we're looking at a 90-day process right now. Not saying that they don't need it, Mr. Chairman. just like a little further analysis and discussion as we get into the full markup within the agency's budget and have them have an additional chance to look at what the potential workload now that we've eliminated part of that out. So, again, Mr. Chairman, I would make the motion to eliminate that section. Or from the bill.
Okay, is there a second?
Second.
Motion and second. Further discussion? For discussion. Go ahead, Senator Drew.
Thank you, Mr. Chairman. I understand the motion and would tend to agree with it, except for the fact that based on what we're doing and how we're doing it, this bill will go into effect on Friday. If passed. And so I'm voting no on this motion because I think they're going to need all the help they can get. If this were to pass in this form, employees are going to be making a lot of phone calls come Saturday morning. Probably not going to be getting many answers. I'll bet there'll be some people around, but I'm saying they're going to need all the help they can get. Thank you, Mr. Chairman.
I mean, it's just, I mean, you do have to go through the effort of if you're going to add, if you have to add or hire, even if you're going to contract out the work or whatever, you still have to go to the process of finding somebody and it's getting, you just don't hire somebody overnight anymore. You're lucky, in fact, you're lucky right now, you're lucky if you're going to hire somebody over, 30, 40, 90 days. If you're looking for something more than a pulse. So. Anyway, vote your conscience on this one. So not like you don't always. So, all right. Any further discussion?
Mr. Chairman.
Go ahead.
I just have a question because we're saying in the amendment we just passed, in the last Kinski amendment, that in A, subject to provisions of this section, provisions of section 2 of this act shall not be enforced until the date of final disposition. So if we're not enforcing section 2, then I don't think they have anything to do. And that's why I was going to be a yes and why I was a second on this striking this, because if this stands as it is, I don't think they'll be doing anything. But that's just, maybe I'm confused. If I am, please straighten me out.
I think they have to act when the law is passed. They have to be ready for whatever. Again, I would say I don't think for private employers, some of them are going to be affected and some more. I think. So, but anyway, we'll vote it up and we'll do what we do. So vote it up or vote it down. That's what we do.
Mr. Chairman.
Go ahead, Senator.
I just follow along Senator Steinmetz' line of thinking is we can pass this and tell them that they have to do it, but we've also told them that they can't enforce it. So we're going to give you a position. We're going to give you rulemaking authority to go out and promulgate all these rules and everything, but because we already have pending litigation, you can't enforce anything. So I just failed to see the need for additional expenditures at this point in time. The way we've currently amended this bill to say that, but you can't enforce it. So are we really going to hire a state employee, appropriate $400,000 and then tell them to go out and do nothing until we have final disposition of the court system? Because that's what I see we're doing here with that, with the amendments that we've adopted. So
I think it's kind of like renewable energy. You have to have, you got it when you need it, you got to have power from somewhere else. And so the ratepayers have to pay for that additional battery or whatever form that comes in, whether it's a pile of coal,
even when the wind's not
whatever it is,
blowing,
you got to, when the hammer drops, they got to enforce it. So whenever that does. So anyway, life goes on. All right, any further discussion? All those in favor, say of the motion, which is to strike the appropriation section. All those in favor say aye. Aye. All those opposed say no. Motion has failed. We're back on the bill. Any other amendments? Any other amendments? Ready for question on the bill? Call the roll on the bill.
Thank you, Mr. Chairman. On House Bill 1001 as amended, Senator Guru,
No.
Senator Hicks, Senator Kinsky, Senator Steinmetz, Chairman Perkins,
No.
3 ayes, 2 noes.
All right, the bill goes to the floor, so here we go. Thank you. Committee, thanks for your time. Not easy, takes a lot of time. It's not stress-free for any us or them, anybody out there.